Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota that is definitely, well, I am not currently licensed to practice. Do not call me. I will not help you. I will not. And that should fulfill my obligation to the state of Minnesota and the ethical rules that I either am or am not under, because I'm either an attorney or not. Who knows? Who knows? It's nebulous. Sorry for the delay, guys. So when you set up a stream in StreamYard and you pick do not schedule, I learned today that it actually schedules it. Katie, is this shit getting old? Good. Who cares? Fuck you. Nobody gives a shit. Don't watch. It's fine. No one's going to be mad. But yeah, you don't schedule a stream specifically. It schedules it for the minute you start it. So then I set it for 1:30 because I was thinking, oh, I'll just go quickly pan fry this steak and it'll be great. And then everybody asked me for help with a bunch of stuff. And I was like, guys, I have to go. I have to go right now. I'm busy. Very important things to do. And oh, are they important? Oh, are they important? We are going to have a special edition of Cooking with Kurt where he roasts a Rekieta. He roasts a Rekieta. We have to see if his technique is any good. Will I be flambéed? I don't know. I have no idea. I haven't watched it yet. I don't know if any of you have, but I have not. And so this will be a free stream in the sense that it's open to the public. This is not, most of the Cooking with Kurt is members only content. This is not. This is because it's a little bit special. It's a little bit dangerous. It's a lot of bit autistic. And I think that's something we need to all consider here as we go. And that's what makes all this so funny to me. I can't take it. I'm giddy with anticipation. I'm not afraid. I'm not afraid to express that. Here we go. I'm just setting up my chat windows. We are live on Rumble and YouTube, and you can also, if you are in locals, you can watch along in locals and enjoy the locals chat there. It's hard to schedule your live for on my show when I set the scheduled time of whenever I get there. Sorry, I can't help it. I can't help it. So anyway, this is the gauntlet. This is the crucible. This is everything, right? This is to determine if I should make fun of Kurt or not. That's what this stream is for. We have to know if I should make fun of Kurt or not, based on his legal analysis of my Bodycam case that is before the Minnesota Court of Appeals. All right. Very, very important to find out if the beating should commence or if they should be stopped. And we'll never really know, but we can form opinions about it. Speaking of forming opinions, Palmyra Media, welcome to Paralegal Status. Thank you for joining the channel. This stream is going to lick sniz, then it's okay in my book. It's okay in my book. We have a couple things going on. So as stated, this is an open to the public stream. Normally I do these streams for members only content, but since this will actually have a decent legal overlap about a case that I'm very interested in, which is my own, I figured we would go ahead and keep it open to the public. That said, if you enjoy Cooking with Kurt or Roasting Kurt or whatever, among other things, you can join my members only content by joining up on YouTube or by joining up on locals, as low as $2 on YouTube, $5 on locals. You can join at any level and enjoy all of the members only content that we've been making. Make at least one members only stream per week, and that is still planned for this evening. We will be doing that. So you can join that if you want. If you don't, that is perfectly fine. That is okay. I'm okay with it. I do the members only content as a thank you to the people who choose to support me on a regular basis and, you know, have stuck with me through some bad decisions that I've made and still said, hey, we got you. Hey, we got you. And I really appreciate that. Even though I don't deserve it, it was really awesome of people to do that. But that does not mean, just because it's free today, doesn't mean that there's no reason to join up. There are plenty of reasons to join up, including tonight's members only stream, as well as, you know, just being nice if you like the show. But it's not required for the majority of content. Let's see. What else do we have to say? Oh, yes. We do need to note that if one of the mods wants to put the link in the chat, I'll replace the pinned chats on both YouTube and on Rumble. But we have an alternative way to participate other than super chats and Rumble rants. If you want, you can use what's called a super tip. If you've never seen how a super tip works, you type your message in. You can pick from a bunch of different voices, and they use those voices to actually read off your message, like this one. Although no one is going to know who this is unless you're deep in the lore, so deep that the lore will be pregnant very soon. Oh, no. I screwed it up. Hold on. I can fix it. I forgot I changed a couple settings that need to be fixed real quick before we can go on. Hold on one moment. Oh, yeah. Here we go. Oh, yeah. Unmute that. And then, nope. We go back to this guy. All right, let's try that again. Sorry about the confusion and delay there. Thomas the Tank Engine up in this house. Let's see. Whoops.
The primary cuts of steak originate from 8 primal cuts of beef, chuck, brisket, rib, plate or short plate, loin, flank, round, and shank. From these, numerous retail cuts are derived, including filet mignon, T-bone, porterhouse, ribeye, New York strip, sirloin, flat iron, skirt, flank.
I will fix the volume.
Denver, picanha, and hanger. Good to see you, Rackets. Kurt has a small penis.
Okay, the volume's really low. Hold on. I went on another stream and had to fix that. Let me crank this bad boy up here. Just a second. And we'll get you spend a bunch of time getting your settings in order, and then you go on, someone else's show, and it completely ruins everything. MLS, come on. No, that's not true. What are you talking about? Let's see. Hopefully, the volume on my end is a little bit better. I hope that's up there for you guys. Let's try this super tip real quick. I won't play. Well, I guess we can play the same one.
The primary cuts of steak originate from 8 primal cuts of beef, chuck, brisket, rib, plate or short plate, loin, flank, round, and shank. From these, numerous retail cuts are derived, including filet mignon, T-bone, porterhouse, ribeye, New York strip, sirloin, flat iron, skirt, flank, chuck eye, Denver, picanha, and hanger. Good to see you, Rackets. Kurt has a small penis.
Okay, so I'm hearing super tip is louder, but that I need to be brought up a bit, which we'll get this set up. Don't worry about it. 1 second. I have one more thing to adjust here. I muted myself like an idiot. 1 second. Filters. Oh my God. Okay, here we go. Here we go. There, that should be better on my end, I hope. And we'll just see from there what we do. Okay. Any last minute things I need to get on? All right, so a little bit later, we're going to tell a little bit more of a story I've talked about before, and it was the last time I spoke with Kurt. So that's something to potentially look forward to. The last time I spoke with Kurt, my audio is near perfect. That's because, okay, I'm getting annoyed. Like trying to fix this is so irritating because the audio of StreamYard is just trash. And unless you let it fucking gain boost you into oblivion, it's a mess. All right. Hopefully that fader adjust will help with this. But yes, the last time I spoke to Kurt, which we'll go through a little bit more in detail later. But the context of it was I was at a tattoo convention with Lady Rackets in April. Many people saw us at that convention because first there was a news crew there. Well, I think all the pictures were from the news crew. And so, of course, we show up at the convention, trying to stay low-key at the time. It was July, shortly after the arrest. And there's a news camera right there on everyone walking in. There was no avoiding it. And someone found it and posted it, which wasn't that big of a deal. It was not a problem. It was just kind of funny because, like, trying to stay low-key, but, you get caught by a news camera, which was not as bad as that guy at the who got caught at the Coldplay concert, because that's awful. You never want to be seen at a Coldplay concert. It's the fate worse than death. Who cares that he was with someone else? It was more about, bro, you were at a Coldplay concert, and that's why he had to step down and resign. So it was something akin to that, but not of the same level, because didn't really care about being seen who I was with. It was just, in general, we were trying to stay low key. But that's okay. That night, I talked to Kurt on the phone very extensively. And a little bit later in the show, when it's appropriate, I'll give you the theme of how that conversation went, which I haven't talked about too much, but that's okay.
Kurt was fairly on with his analysis, but soon his jealousy and micropene became apparent when insulting you and others. Kurt is a sad man.
Well, that reminds me, I guess we should turn on the micropene counter, which is already at 2. Already at 2. The micropene counter, as always, is sponsored by Kurt's Dating Advice and Chicken Shop. If you need dating advice or chicken, you are able to get it at Kurt's Dating Advice and Chicken Shop, a proud sponsor of the Micropeens that are brought to the show today. Any micropeens will be counted and kept a running tally throughout the entire show. And that is brought to you with special request and full endorsement of Kurt's Dating Advice and Chicken Shop.
Given what we know about Kurt's cooking habits, do you think he has a Thanksgiving edition where he shoves his hairy arms smothered in butter all into the cavity and skin to massage the floppy meat?
Maybe. Oh, yes. The super tip link is, thank you, Peachy's Paradise. It is now pinned in the description. You can, or pinned to in the chat on YouTube. It's about to be on Rumble as well. Here we go. And you can also find it in the description of both YouTube and Rumble. It is the first line of both descriptions. So yes, there we go. Now I do apologize for the thumbnail. I know it was jarring for many of you. We need to go ahead and share this video and then we'll get started here. This is going to take a little bit, guys. Maybe. I don't know actually how long it'll take, but typically if I'm reviewing something, that's video oriented, it'll take a little while. Hearing Barnes say floppy meat wasn't on my bingo card. That's actually not an AI voice of Robert Barnes. Anytime you pick the AI voice of Robert Barnes, it actually sends a message to his phone. He very quickly records it and sends it back to me. So that's real. This video of Kurt's is 1 hour and 39 minutes. Now, if you are a regular viewer here, you will have maybe seen that I went through this argument on live stream the other day. And we've already gone through most of the legal arguments, but I may address some here or there, depending on what to do. Or not what to do. What Kurt says, and if it needs to be further elaborated or eliminated, whatever. What I think I should do here is I think we should take the headline down. So then I think I won't have to switch off screen to do super tips.
I don't understand why you don't get it. I'm just trying to find my forever minor. I mean, love.
Oh, no. Oh, no. Oh, man. Woo. Okay. Hey, what's up to my man Connor's in the chat, the Glarer's in the chat. Holy shit. The real Lady Rackets is even in the chat. So that's fun. How you doing, girl? Nice to see you. I mean, I just saw you like a second ago, but nice to see you again. Of course. And we have this.
Hello all, Nick Lowell looks like a 1970s drug dealer, greasy Italian with Jew in him. Hilarious.
Greasy Italian with Jew in him. It's like a bonus added in. Now with extra Jewy flavor. Holy shit. Oh my goodness. Wow. Thank you, Cookie, for that. Yes, and MLS is he's putting the pressure out there. He says, I'm excited for Nick and his wife to join us for Legos on December 6th. Now I guess she has to. Join us for Legos. But I will definitely be joining MLS and Valhalla Awaits for Legos on December 6th. And I will be putting pressure on Lady Raggets to join us as well. The subtlest of pressure in the best of places. X just revealed Nick's location as Israel. Does it count? Does it count on X if they reveal your location as Israel? If you've been abducted by Mossad and put into a basement and that looks just like your studio and forces you to stream and tweet all the time? Like, is that the same? Am I actually from Israel now? Have I been adopted? I don't know. All right, let's get started on this. This should be something.
Hello, everyone, and welcome to Uncivil Law. My name is Kurt Mueller, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story,
I am a licensed attorney whose license is suspended, but only in the state of Minnesota. Because I only go where the trouble is.
we are
Massive echo? Oh, no. Oh, no. Oh, no, 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 no. Not good. Not good, not good, not good. Let me see. Let me see how we fix this. There is a way. There is a way. I had this fixed the other day. I had this fixed. Wait a minute. I think I know. Hold on. I don't think this is going to fix it. Tell me if it's still echoing in just a second.
going to review an ongoing issue involving Nick Rekieta.
Was that still echoing? Still echoing. This is the most frustrating thing in the world to fix. This is all Super Tip's fault, by the way. This is all Super Tip's fault because Super Tip has to go through OBS and then into the mic input. Let me see about this. I think this might do it, actually.
Nick Rekieta, who used to be a lawyer.
How'd that go? How'd that go? Still echoes? Oh, that's weird. Okay, that shouldn't echo. That's very strange.
Cease and desist.
I can't cease and desist. Let's see.
I'm still trying to heal from the shrimp and block of grits.
Oh, okay. Tell me, are those Super Tips playing right now? Did those Super Tips play? Okay, the Super Tips played. Okay. All right. Okay. Just have to figure out where that's coming from. Okay, one more thing to check here. Tell me if you can hear this. Nope, I can't. So that's annoying. Okay, yep. So nothing there. That's fine. That's expected. Wait a minute. What happens if I do this? Can you guys hear me now? This is great. I love doing this. I love audio troubleshooting in the middle of the thing. Okay, you can still hear me now. Oh, that's weird. Okay. If you can hear that, we might be onto something.
I'm still trying to heal from the shrimp and block of grits.
Did that come through this time? Okay, that came through. All right, now for the final test. Final exam. Here we go.
Had his home searched for drugs. Drugs were found as you will recall, and he eventually pled guilty to felony.
Okay, last thing. Does that working? How is it echoing? What? How is there an echo there? That doesn't make any sense. That doesn't make any sense at all. Let's see. We're going to try this real quick.
Possession of those drugs, although the actual judgment.
How about that? Can you hear him there? That's it? All right. There we go. So much shit had to happen for that to work. Okay, here we go. Here we go.
Of guilt was deferred, suspended, pending probation. So he is not convicted at this time.
Correct.
Although he has pled guilty. He is also simultaneously fighting an issue where people would like to see the body cam footage and presumably other footage, such as dash cam footage that might exist from the incident at his house. The footage has not been made available.
Now do the super tips. Someone's going to have to send me one. I'm not going back. I'm not replaying those. They got their value. Especially Melton, who didn't pay anything for his super tip. He never pays for just the tip.
Although a couple people have seen it by actually going down to the courthouse and actually looking at it before it was sealed even from that. So a few people were able to see it in person by going to the courthouse, but it has not been made publicly available.
And the few people who saw it in person, though they did not attempt to do anything unlawful, it was unlawful for the court to do that. Because this was never offered and accepted. Now, it was unlawful due to presumably negligence from the court. Someone mislabeled them as accepted into evidence.
This is an employee perk. My Chargers.
Even though, you completely derailed me. You completely derailed me. But, no, it's no one was entitled to see them because the evidence was never offered or accepted by the court, or even presented to the court. So the idea here that they should be entitled because someone on the county end mislabeled the documents doesn't make much sense. So I can do nothing to fix the sound of Kurt's voice. I just want to say, look, I'm not being too critical here. My nose gets very red, as I get warm, as I get into talking.
Love the jacket, man. Call me about Clenny.
Hey, what's up, Andrew Bronca? That was the Andrew Bronca show. And yes, I will call you probably later today, brother. Good to see you. Thank you so much. This is a pretty good jacket. I'm going to say it is. I agree with him. Andrew Bronco with spot on analysis as always. So my face can get all different shades of various colors. But my man's face is a gradient. It's like a slider on the font color selection choice on the editing software. Look, it can go from transparent all the way to red. Oh my goodness. Whew. Whew. The worst part is, and this is why the glasses are a problem for Kurt. Why these glasses in particular. Now, I assume these look like some sort of blue light elimination glasses or red light, something else. Those are not, I don't think those are style shades. I'm not sure, but I don't think so. I think he wears them for a reason. Look, when you've been streaming a long time, it puts a huge strain on your eyes. You're looking at a lot of lights coming at you. You've got the light from the screens is a lot to deal with. It's a lot, okay? It's a lot. It's so hard to be a stream. But it gets a lot of eye strain. So that makes sense. But I think he should I don't know if they come in a different color or whatever, but I don't think the red is working out because it draws the distinction, and it actually pulls the red of his skin out more. This is style tips from Rekieta Law, which you can find on my style channel. Yes, I am a fig.com. That's not real. Don't go there. Don't go there. But yeah, this is not a good look for him because it draws out and draws attention to the reds in his face, when otherwise it would probably be a smoother gradient. So just some helpful advice for Kurt. He asked me for advice a long time ago on how to, how to be more presentable for various types of different audiences. I gave him my opinion, and none of them involved two small black framed pink tinted lens glasses. That was never part of my advice, and it's really hurting my brand.
These lawyers who are talking trash about Nick is sad. Stop it.
Thank you, Cookie. I agree. It's pure trash. Let's see. We've got 200 Watt Studio says, what culinary confection to trigger my acid reflux will we make today? This is roast turkey, in which Kurt roasts me. So there we go. Palmyra Media and Vice Baby gifting 5 memberships each. Thank you so much for bringing more people to the glory that is the members only content. We want everyone here to grab their members and be excited about it. 200 Watt Studio 8 also says Gillian Anderson is still hot. Wait, Scully? Is she? I always had kind of a crush on Scully back in the 90s. She was, she was something special. The X-Files. But David Duchovny is also, very beautiful person. Marlier, how French are you, has joined. Welcome to the channel. Absent Minded says, when will you be on Trashcast? Cope Files in your CGE faction misses you. It's more about, when I'm invited, I go places I'm invited to, especially now, rather than, I don't want to impose on anyone. Having me on stream is a little bit of a chore because some people like to make it painful for the people, or try to at least make it painful for the people who have me on, which is a little silly, but hey, that's how people do. That's how the internet works. So I don't try to impose myself on other people's shows, but I love to go on when invited, with my friends. The Bronca shows us Nick is aging more slowly than normal due to his proximity to that gravitational field. Time dilation is real. It's happening now. Hey, Bronca, we may have to, I might have to invite you on for a special segment. Because I watched a video today posted by Yellow Flash on Twitter. I retweeted it, but it was 3 large women seeing how many rides they could actually be passed for on at Epic Universal Studios. And one of the women, they didn't give their weight because I'd assume like they ran out of characters or bandwidth, but they gave all of their other measurements. One of the women was 5'10" and had 74-inch hips. 74-inch hips. I'm 6'2". I'm 74 inches tall. It is so, like, it's unfathomably big. It's unfathomably big. Consequently, she could not ride a single ride at Universal Studios. So if you have 74-inch hips, you will not fit on any of the rides at Universal. The seat restraints are not safe for you. But honestly, they should just let someone that big go on the ride anyway, because they're going to probably die before the ride will kill them. What was her waist, I wonder? It's on there. If you go to my Twitter and find the retweet, or go to Flash's Twitter, either one, you can you can find that that woman. You can find that video. Okay, but more importantly, we have another 74-inch hipped hippo to discuss, which is, of course, me. So here we go.
Under the relevant law, as I understand it, unless the information was offered as evidence, the information can be and generally is withheld unless it's deemed to be in the public interest to reveal it. And this has been the contention, that it's in the public interest to reveal it. And by Mr. Matthew Harden, who has sued to have the information revealed. So what we're going to do.
Oh my goodness, Angela, Australia, coming in hot with 20 gifted memberships. Thank you so much. And Kurt has so far succinctly summarized the legal issues and the procedural posturing of the case. And I have no complaints about it. 200 Watt Studio says 74 inches needs a boat oar and a wet towel to wipe. You know, it's the practical things that you don't think about. Everybody who gets a gifted membership today from Angel Australia, please remember to drop her a nice little thank you. It's very, very sweet. Very, very sweet of her to do so. Matthew Harden has, who is Joshua Moon's attorney, whom I referred to Joshua Moon many years ago, and has done a pretty stellar job of representing him in the Kiwi farm so far as I can see, is the one not actually representing in this case. In this case, Matthew Harden has presented himself as the plaintiff, which there are potential issues with that, but we're not going to discuss those here at this point. They may come up at a later date. We'll see. But so far, he has represented that it is his personal interest to acquire these videos. Now, his client, Joshua Moon, has stated otherwise and has pretty explicitly stated that Matthew Harden is working for hire for Joshua Moon on this specific issue, even though he is not working as the attorney. He is standing in as proxy for Joshua Moon. So, again, not relevant at this point, but may become relevant later. Shut Up, I Can Cook, and Fletcher Boy bringing 10 more members to the stream. And look, we are all about adding members to the stream and the channel in general. I say the more members, the better. Just like Bonnie Blue, who famously slept with 1,000 men in one 24-hour period, will be attempting to break that record and go straight for 2,000 men sometime early next year, I believe I read. And this is the world we live in. Look, girls got goals. We are trying to get more members than Bonnie Blue. That's our goal here. More members than Bonnie Blue. Member drive. Member drive usually results in good feelings for all involved. So, please consider that as well.
Nick, you need to be careful about saying the phrase "in April." Just saying.
That was a bit below the belt. That was a bit below the belt.
Like picking up girls in an...
Like picking up girls in an... What's in an? Oh my goodness.
To do today is review Mr. Harden's brief. Then we're going to also review the mistake.
Lady Raggeds, do you not have a... Oh, you don't have a membership to the channel. How can I hide stuff from you if you have one? You're getting called out right now because it is based algorithmically on how much you watch the show, particularly live streams. And so, catching you lacking, girl.
State of Minnesota's brief as well as Nick Rekieta's brief and try to analyze who has the better end of the legal issue in play.
I always analyze who has the better end. Eric PP has a wonderful end, gifting 5 memberships as well. Thank you, Eric, for that. And by the way, Eric, I saw you ask in chat earlier and meant to respond but forgot. Yes, I do have a P.O. box for gifts. If people want to send them, no, please, that's something that is so unnecessary. So unnecessary. but is always appreciated and welcomed. And it is P.O. Box 97, Spicer, Minnesota 56288. If you want to send something there, you are welcome to. But, I don't ask for anything. The ability to do this as a profession is about the greatest gift that one could get. Thank you for that. And Lady Rise, you're busy with our kids. Sure you are. Probably.
End of it is better legally. So we're going to read all three and try to offer a legal opinion because that's how we roll. We will start with...
Is it how we roll? We'll see.
The intervener, the person who would like to see the footage very much, and their brief and what they have to say about the operative legal issues that are in play. The legal issue. Whether Mr. Hardin or presumably anyone else for that matter is entitled to view records submitted by Nicholas Rekieta and referenced in his brief in district court pursuant to Constitution or
Angel's asking for a membership count. So far, we have 47 new members. 47 new members on the stream today. You know what? We'll actually put it on the membership counter or on the micropene counter. So now that will be a running tally of memberships that are added to the show today. I would really love if Locals would have a better notification system for when people join up as members on Locals. But we do have the micropene counter is at 2. The membership counter is at 47, sponsored again by Kurt's Dating Advice and Chicken Shop. Very, very happy to have them as pretty much the most faithful sponsor of the show. And Kurt's Dating Advice and Chicken Shop, where you can get all of your needs fulfilled and hopefully fulfill someone else's.
Common law right of access. So there was this issue because it had been filed by, I'm going to get this slightly wrong, and I'm sure the brief will clarify it, but I think it had been put on docket or filed by Mr. Rekieta's lawyer, but not actually referred to in any way, which means it doesn't really count.
Okay, let me help Kurt out here. This is a very new aspect of Minnesota law and Minnesota legal processes. Kurt not knowing how this works is not on Kurt. There's no reason for him to know specifically how this works. In fact, I didn't really know how this works because I haven't really practiced in years, and this is a new thing, a new requirement as of May 1st this year, though they started building it out a couple years back and implemented it in some select counties for testing. This is called the Mendez system. I don't remember what it stands for, but basically it's Minnesota's evidence presentation system. And so what you do, the process with Mendez is very simple and straightforward in practice. When you have a hearing or something coming up that is evidentiary, right? It's evidentiary hearing. You upload into Mendez your evidence that might be brought into court. Anything that you are potentially going to have. This includes you can upload rebuttal evidence. You can upload any sort of thing. Now, it doesn't have to be hyper specific. For example, if your evidence is a 20-second clip from a live stream, you can upload the entire live stream, and that may be relevant because you may need to provide additional context or something else. So you may be uploading a 5-hour video, even though you're only going to use 20 seconds of it. And to my knowledge, you don't have to provide like timestamps or anything at that point. Once uploaded into the system, it is stored there. Then when you get to your hearing, when you're at the actual evidentiary hearing, you would offer the evidence to the court as you would if you were standing in a courtroom with a piece of paper. This came about because of COVID and all of the problems with presenting evidence that having hearings by Zoom presented, right? So you can understand, normally you're standing there in a courtroom, you have print-offs of everything, you hand one to the witness, you ask them to authenticate the evidence, say, hey, do you recognize this? Do you understand this? Is it true and accurate representation of whatever? And they will say yes or no. If they say yes, you can say, I offer this to the court as evidence. The court will look at it, determine its admissibility. That's called presentation. You present it to the court. The court will determine its admissibility. And if they admit it, it is accepted by the court. And only then does it become evidence and part of the judicial record. So at that point, once it is both offered and accepted, according to the Minnesota Supreme Court, once it is offered and accepted, does it get labeled as evidence that is added to the court record. If it is not accepted by the court, it is not in the record. It kind of can't be, because the record then is relied upon for a matter of appeal, like this one. You have to file your appeal brief, and also the appeals court gets a copy of the complete record for the case, and they review it as necessary, depending on their standard of review for the issue that is there. So that's what the process is. And again, Kurt not being familiar with that is he's not a Minnesota lawyer. He doesn't practice in Minnesota, and he wouldn't need to know that. So that's one that definitely, I wanted to explain the full process of that as much as possible. What happened in our case is that this evidence was never presented to the court. It was never offered, and it was never accepted. It was uploaded into the system, and then after the hearing, someone at the county attorney, or not the county attorney's office, the court administration office, I believe, they do the classification, or maybe the court clerk. I'm not 100% sure which one, but they label the evidence in Mendez after the close of the evidentiary hearing as, whether or not it is evidence or whether it was excluded. And they picked the wrong choice. They chose evidence for this body cam footage. So that is what has happened. That is all in documents that were presented to the district court as what has happened. That's not my theory on it. That is what has actually occurred according to the court. That's the record before it. Tilly T gifted 5 memberships. Angel Australia drops another 20, and Talking Trash and Truths, hey, how you doing? Good to see you, has dropped another gifted membership. That brings us to 73 memberships on the membership counter, which I'm updating right now, brought to you by Kurt's Dating Advice and Chicken Shop. So thank you again to the Chicken Shop and Dating Advice and Chicken Shop for their sponsorship and their presentation.
Count. So it was, I think, entered onto the docket by Rekieta's lawyer. I'm pretty sure as part of the motion to suppress. So I think Rekieta's lawyer is the one who submitted it to the docket, and then, but he didn't actually refer to it in any way in any of his briefings, which just says how I think it got on the docket. 1999 from Nate the lawyer. Let's effing go. I'm glad to report that Nate the lawyer is back home, by the way, for those of you who are concerned by his health. So he is back home with his family, and I look forward to seeing him tomorrow to catch up with him some more. And we're going to have a stream pretty soon in which we are going to recount the story of what happened. And I'm going to be there because Nate isn't necessarily a reliable narrator for all this, but I am, because I was there. Nate was less there at the time, but we'll just.
Happy to hear that Nate is doing well, of course. This was yesterday. And Nate has been doing remarkably well, and that is fantastic. Jim tells you, wonderful friend of the show, has dropped 50 gifted subs. The sub count, or memberships, the membership counter is rising. We have so many members right now. I'm starting to get sore. Thank you. Jim Tells You. Make sure you guys check out Jim Tells You, who streams basically every night, talks politics and other cultural subjects. Good dude who's been a friend of the show for a very long time. Thank you, Jim. That is unreal. Here we go. What do we got?
I am just putting money in Nicholas's pocket. He has 5 kids and a wife, plus other incidentals. Also, Nick, I will be sending you a link to a short 3-day trial of a pastor who was shot. So was his wife.
Hell yeah, Cookie. I'm definitely interested in that. Thank you. Thank you so much for that. And very much appreciated. And I love money in my pocket. I love it, of course. Here we go.
discuss that later. But thank you, Nate, for the 1999. It's very kind. In any event, yeah, Nick Rekieta's lawyer put it on the docket, but then didn't refer to it. And so he's like, that didn't count. So that's sort of the issue.
And again, this is not picking on Kurt. That'll happen later. This is not picking on Kurt. He didn't put it on the docket. On the docket, refers to the court's actual docket of the case. It is not there on the docket. It is not part of the discovery file. It's not in there. It was uploaded to the Mendez system.
Fear the micropene.
Fear the micropene. That's the micropene counter is now up to 3, and everyone should fear it. It is small, but fierce. Fierce. I think the gifted memberships have finished tallying up. We are now at 123. I should have been able to do the math on that, but I have not eaten fried rice lately and am weak on my math powers.
Okay, apparently. Anyways, pursuant to the Constitution or common law right of access, presumably the Constitution of the state, but we'll see. Trial order held.
I wouldn't presume that, because the constitutional right of access he's speaking about is federal. But again, Kurt, I don't expect Kurt to have familiarized himself with the entire posture of the case. He's going off the appellate briefs, and that's fine. And that is a confusing line. But I believe he's referring to the federal constitutional right of access.
Whatever. Mr. Hardin preserved the issue written by motion. So the trial court already ruled on this, and they're like, not so much. Whether Mr. Hardin is entitled to be heard and present evidence before the trial court to make adverse factual findings, which if
not only have they been heard and the trial court turned them down, the trial court acknowledged that this was done as a mistake, very specifically, and ordered the mistake corrected. That's what they're challenging.
affect his substantial rights. Trial court held Mr. Hardin's written motion to intervene was granted in pertinent part, but trial court held that no further briefing is required, which, kind of makes sense because it's a pure limited issue of law, right? There's no particular reason to allow anything more because it's just pure legal issues.
Correct.
And so the court's like, well, I'm going to rule on it based on what I know. So I'm like, okay, fair enough. This effectively denied the relief he sought filed in the written motion. Yeah, so the court just basically denied him, granted him limited permission to intervene, but said there was no briefing or hearing required. So I grant your petition to appear and I deny your request, which gives him grounds to appeal. Fair enough. Here are a statement of the facts, at least as they're going to be presented by this brief. Nicholas Rekieta filed a motion to dismiss his criminal case on August the 18th. In that motion, he cited 2 body cameras he believes support his argument.
Actually, that's not technically accurate. I think it was styled as a motion to dismiss, but it was a motion for a Frank's hearing on the warrant. Although we may have had a general motion to dismiss in there, I don't remember. When I say it's not accurate, it's in the statement of facts. I'm not criticizing Kurt here.
One from Candio High Sheriff Deputy Barnes and one from Deputy Pomplin. Both these were filed with the court via the representative system contemporaneously with the motion. I'm not sure, strictly speaking, that he cited the videos is correct, but he did file them on the docket. That's true, which seems like
I believe they were referred to in the motion. I don't know that they were cited specifically in the motion. The motion, in relevant part, to summarize where the body cam footage came in, would have come in, were the issue addressed, involved the third issue in the motion. The first 2 issues were addressed in court. The third was mooted by a pre-hearing conference between the county attorney and my attorney, Mr. White. Okay. The third issue was a motion to suppress statements gathered in violation of the Sixth Amendment rights of April. April made statements to the police that, were improperly obtained, as the officer had just been told that she said she would not answer questions without a lawyer present. He was informed of this literally moments before he started to ask her questions in violation of her Sixth Amendment rights. So that was the issue there. people believe that these statements were somehow damaging to me. They were not damaging to me in any particular way. They were, again, they were a violation of her Sixth Amendment rights, but they would be improperly included, and they weren't particularly damaging to me. They could be used in a manner that would be damaging because that's what prosecution does, right? Like they use statements. The prosecutor informed the judge and my lawyer that she did not intend to use any of those statements in any of the proceedings, and that the issue was not relevant. So it was dropped. This was prior to, this was not addressed in the motion. This was right at the beginning of that hearing, that they would not be addressing that, and that none of it was necessary.
Cell phone, but whatever. The trial court held a hearing on the motion to dismiss and denied that motion. Motion to dismiss and denied the motion, right. On April the 12th of 2025, Mr. Hardin filed a Minnesota Judicial Branch copy request form, which we requested evidence submitted through the system by Nicholas Rekieta, including but not limited to the 2 files that Nicholas Rekieta's own lawyers put on the docket, which is just kind of hilarious, right? His own lawyers are the ones that filed it. So this entire situation.
Yes, because Minnesota law requires you to do so. And so Kurt's, this entire, let's see what he says.
Is being created by a cell phone. So if
it's not being created by a cell phone, Kurt, it's the literal legal requirement of the state to put proposed evidence into Mendez prior to the hearing. If you were to not put proposed evidence into Mendez prior to the hearing, it will not be able to be offered or accepted under the rules of practice established May 1st, 2025 in Minnesota. You must do this. This is a required process. I'll give you a little bit of leeway on not understanding the nuances of the process. But before you go ahead and call out a lawyer who actually practices for a self-own, you should maybe understand that you're procedurally fucking retarded and you don't understand that he has to do this. It's not an optional thing. It's not a thing he did by mistake. It is the requirement of being a lawyer practicing in Minnesota. I know it's hard to get through your head, although less hard because there's no insulating ablative hair plating protecting it, but you need to try a little bit. You get some leeway for not being a Minnesota attorney. You don't get a leeway for being autistically retarded and wrong, which you frequently are. And the fact that no one has called you out on it for years and years has much more to do with you being so obviously autistic that it would feel mean than anything else. But I digress.
If this gets released, it's because Nicholas Rekieta wanted it released because he's the one that filed it. So,
Want is a strong word. Being resigned to the possibility of it having to be released to preserve a legal issue is a different one. Thankfully, we were able to resolve it without that happening.
And just listening to the audio, it's difficult to tell if Kurt's nasally labored drawl is due to a stroke, laziness, or an actual physical fat obstruction preventing him from forming words. Though the simple answer is likely that he is lazy, fat, stroke. I may be the expert in vocal fry, but this motherfucker is the expert in vocal fat.
When Kurt hears the word vocal fry, he's like, where? I'm hungry. Plead the Fifth says, what was the legal issue you were attempting to preserve? Again, would have been preventing those statements from being used in court as they were improperly obtained. Those statements related to where she was staying, where she had lived, stuff like that. Not huge issues for my case, although they did matter somewhat. And now, at present, those statements aren't that big of an issue at all. I don't remember the exact questions she was asked and questions she was answered, the questions that were answered. at this point because I haven't reviewed the footage in a long time, but I would have no problem saying them publicly. That's like there's nothing specifically to protect in those statements. And again, the prosecutor said that those statements would not be utilized. So that was fine.
There's that. So the irony could be very thick, my friends.
It could be if you were correct, but you're not, which is the problem that we run into all the time. And again, no one wants to call you out on it because they're scared of hurting your feelings. Because when your feelings get hurt, you lash out at women because women are small. That's what you do.
Where's the Kurt voice?
It's not up to me to have a Kurt voice at present. If it were up to me, there would be probably 2 or 3 Kurt voices. Diceana says, isn't Kurt a patent attorney? Kurt is not a patent attorney. Kurt worked for the U.S. Patent Office for a while. He is no longer working there. He was not a patent attorney. In fact, up until recently, Kurt had never drafted nor filed a motion in court at all. He had never argued a motion in any case. He had never argued at a hearing. He had never presented himself in court unless it was to represent himself. And I'm not even sure he did that. That is something that Kurt never really told anybody, as far as I am aware. But that also happens to be true. Kurt was a licensed attorney, and all licensed attorneys are fully capable of doing that. He did not, however, do that until recently, in which he was hired by someone who appears to have stolen tools from someone else. Though they were not convicted of the theft itself, the tools were returned to the original and presumably correct owner of said tools. And Kurt's client, who at least attempted to convert or steal the tools, it appears, is suing the county for returning the tools to the actual owner rather than to the attempted non-owner. But that is the first case in which Kurt has written and filed anything with a court in any jurisdiction on behalf of a client. And that happened earlier this year. That case is still ongoing.
Oh my God, it's my unintended consequences again.
The unintended consequences of this is you're making an ass of yourself because you're actually incorrect. And you're carrying on about it, which is funnier.
The unintended results of my actions are coming back to plague me once again.
They're not.
What are the odds? Good times.
Listen,
on May
the unintended results of my actions, that waiting room is full. These are not that. That's the funny part here. You have infinite number of things to roast me on, and you chose that one? Okay. Good job.
The 1st of 2025, the Candy, Ohio District Court approved Mr. Hardin's request for access to the record. Specifically, the court noted it reviewed the evidence and was aware of the contents of the evidence, stating that 2 body cameras exhibits request to display unredacted displays of children who were present during the search warrant, along with viewing all rooms and spaces. We're perfectly comfortable having the children, blotted out if that's the issue. I'm pretty sure.
The children's privacy doesn't just extend to their faces, right? You're talking about wanting to look in their rooms. You're talking about wanting to look where they hang out, at their private things as well. The 4th Amendment doesn't cover your face, but it does cover the right to be secure from unreasonable searches and seizures of your person, places, effects, and property. My kids didn't do anything in this scenario. They don't deserve any of this. And you can't be like, oh, your dad's a total screw up, so your privacy's fucked. It doesn't work that way. And what is required on this is just a tiny bit of thought. into it. What requires you to think the way that Kurt thinks is density, anger, and a lack of maybe some things that would calm those down. I did make a mistake that I want to correct really quickly. Just so I said May 1st. It was actually January 1st. Here we go real quick with this. This is the Minnesota Digital Exhibit System, which is hard to find. I know this is hard to find. You type in Mendez into Google and you can find this info right on the Minnesota Judicial Branch entire subheading about this system. But as of January 1st, any documents, photos, or audio or video recordings you want to offer at an evidentiary hearing or trial, called exhibits or evidence, for a judicial officer to consider, must be submitted electronically before the hearing or trial through the Minnesota Digital Exhibit System, unless the court has ordered you to submit exhibits in some other way, or the exhibit contains sexual content or nudity, including internet address linking to those materials. So, that being said, that's it. I know it's fun to call it a cell phone, Kurt, and make fun of lawyers who actually practice or whatever, and make fun of me because I'm so dumb and I never get anything right. Funny, you were happy to suck my dick on stream all the time about my legal takes. We would get into all sorts of erudite legal discussions, and you would tell me how I had interesting perspectives, how I was correct on the law all the time. Suddenly, I'm never correct on anything, right? You're wrong on this, and I can prove it, you fat bitch. But again, keep talking about it.
I'm pretty sure Mr. Hardin would be also happy to have the children's images, blurred out or whatever. I don't think.
Maybe you could have stopped at having the children's images, because if you want the truth, it's not that Mr. Hardin wants this. It's that that's what people want. They want images of the children. They want images of the children on a really, really horrible day. That's what they want, because they think it'll be humiliating to me or something like that. That will somehow be great, is to do that to the children to get to me. There's plenty of ways to make fun of me and get to me. It's been done for a year and a half now. But that's what they actually want.
I think that's the issue. Okay. But again, even if it is the issue, it's Nicholas Rekieta who did it, right? Nicholas Rekieta.
No, actually, I didn't take the body cam footage, and I did not change Minnesota law to make someone else have the ability to access it.
It is the one who filed the body camera footage.
The body cam footage was not filed. It was uploaded, Kurt, to the system. Read the fucking thing. All you have to do is Google one thing, and it's the thing you're talking about, and you didn't do it, which is kind of like that Supreme Court brief that you got fired before you filed, where you missed the main issue. The main issue. And ChatGPT tried to tell you, and you couldn't handle it, so you chimped out. Wadita, welcome to Paralegal Status. We have another membership. That brings us to 124 memberships. Sponsored, of course. The membership counter is sponsored by Kurtz. 124. Kurtz Dating Advice and Chicken Shop. If you need dating advice or chicken, you can get it at Kurtz Dating Advice and Chicken Shop. The chicken, however, only comes in 4-pound quantities, so please prepare yourself.
Including his children as they appeared on the footage. So it's like, if his children are seen, it's because Mr. Rekieta put his children's images on the file.
Nope.
Yeah, that's okay. So that's the stupid continues to burn. Due to what the court deemed the sensitive nature of the contents of the footage, the court allowed Mr. Hardin to view the evidence in person rather than view the evidence remotely.
And Mr. Hardin chose not to do that and to instead send people as proxy, when Mr. Hardin could have easily traveled to the courthouse and done it himself. Instead, he chose to send other people, which I'm sure was Mr. Hardin's choice and not at the behest of his client or the frothing mob that just can't get over it. And that may come up at some point in the future as well. But interestingly, the person asserting their right in this case, who is saying that his rights have been trampled was allowed to see the footage. He just chose to send someone else instead, which is kind of curious.
As I believe other people did as well. Without any notice to Mr. Hardin or any opportunity to be heard, and apparently in an intentional effort to circumvent a Minnesota Government Data Protection Act requested by Mr. Hardin with the Candidato County Sheriff, the Candidato County
Data Practices Act, but who's counting?
Attorney filed a purported consent motion in which the county attorney and criminal defendant asserted for the first time the evidence submitted via the system and cited was not actually admitted into evidence, which I...
Well, because it wasn't admitted into evidence. The fact that it was added as evidence was not something that we had any reason to know, as it was done by someone else at the county after the hearing, in which it was not offered nor accepted as evidence, which I'm sure was completely a mistake.
I don't believe it was, to be fair. It wasn't actually admitted into evidence. That's actually a step you have to take. Other than just dumping it on the docket. Those aren't quite the same thing, right? To actually admit it into evidence, you have to go through a procedure in court to have it admitted into evidence. So, like, it was available. It was on the docket.
It's not on the docket. The docket is the wrong term.
Shared, but that's not quite the same thing as it being in evidence. So, I mean, I agree. It wasn't in evidence, at least as far as I understand the operative.
Correct. 100%. Nailed it on this one, Kurt. I'm proud of you.
Law in the state. That's true. Mere minutes have.
I mean, there's a judge who specifically, the presiding judge specifically said this was not offered nor accepted into evidence in his ruling. But, you know, there's that.
The courthouse opened. The trial court granted the consent motion without providing Mr. Hardin any opportunity to be heard, which I don't know how Mr. Hardin would have any information on this issue. It's, again, there's nothing Mr. Hardin could add to this equation, right? All the available information is known, and there's nothing Mr. Hardin can add to this, right? How it got to be on the docket, who did it, you know, how it was submitted, whether it was or was not evidence. There's nothing Mr. Hardin can add to this picture. He has no information to add. So, you know, fair enough.
Delicious.
Immediately upon being aware of the county's motion through checking on the public docket, not because he was served, which it wasn't about him. So, you know, okay. Mr. Hardin.
I love that this isn't about Kurt here. I love that Hardin is complaining that he wasn't served in an issue in which he was not a party, because one of their strategies here and the way they got access to this footage in general was to file an administrative procedure that specifically excluded serving any of the subjects of the video, which I actually believe to be a procedural error that should have terminated the case. I believe that notice should have been provided to the subjects of the video, even if the video were in evidence, so to speak. I believe that the subjects of the video should be notified because they could assert their rights and contest the nature of the video's public status, because the video is considered private under Minnesota law until some intervening act changes that classification. Private means that no one except the subject of the video has the right to see or authorize its release. And if there are multiple non-government subjects in the video, all of them must consent in writing to the release of said video. None of that was heard, none of that was followed, and no one who was a non-government employee, and there were more than just me, my kids, my wife, and April involved, who are non-government employees that were in that video as well. None of them have had any notification sent to them, no notice provided, and no opportunity to contest the validity of releasing that footage.
Sought leave to intervene in the criminal case for the purpose of preserving access he had been previously granted to the evidence at issue. So maybe he never got to see it. Maybe he didn't get down to the courthouse in time. But I understand other people did. Specifically, in Mr. Hardin's motion to intervene, he requested two forms of relief. First, that Mr. Hardin be permitted to intervene for the purpose of filing the motion to vacate the order they conclusively attained without notice. I'm not sure he's entitled to notice, to be honest. Second, that Mr. Hardin be permitted to file a brief in opposition to consent motion, which I don't think that makes sense either as an intervener, and present evidence and argument in opposition to the consent motion. On June the 16th of 2025, the trial court entered ocean which purported to grant the limited request for intervention. However, the trial court made 16 separate enumerated finding of facts without participation. Because again, I'm not really sure Mr. Hardin really has any information to offer on this issue. What facts could Mr. Hardin offer that would be relevant to this?
None. Kurt's spot on here in his analysis. He's got it down. There is no relevant fact that Hardin would have to offer this. All he has potentially are conflicting legal arguments, but no factual issues. Mr. Hardin was not present for the uploading. Mr. Hardin was not present at the hearing. Mr. Hardin was not present for any of this, and would have no factual basis to add to the court's record. Ben Ryder says, Nick, are you going to practice law ever again? Potentially. At present, I'm focused on stabilizing my YouTube streaming, making sure people know that I'm here. The hardest part is getting the notice out, and that's on me also. Like, I'm not blaming other entities like YouTube or whatever. I'm blaming myself. Consistency of streaming is really, really important. And until I am consistently streaming, it's hard for YouTube or anyone else to know where things are. I've been working on that quite a bit, trying to stabilize the schedule and stream consistently at routine times. And I'm not quite there. So that's my first goal. After that, we'll be doing the CLE requirement that will get me my license back, and then we'll proceed on.
He doesn't have anything to offer, right? I mean, everything he knows, he only knows from the court docket, he doesn't have any special information. He doesn't have access to any special information. He has nothing to offer. He has legal arguments potentially, but he doesn't have anything factually to offer this picture. So, I mean, it just is what it is.
That's what I said. Good job, Kurt. You're learning.
And the trial court stated would not allow further briefing because as far as the trial court's concerned, I don't need to hear from him because he has nothing to offer. In this case, a criminal defendant submitted certain body cam footage through the system in support of a motion to dismiss and cited extensively to the body camera footage in brief. Did he, though? I don't really remember that he did. I don't remember citation to the body cam footage. I don't remember that. After the motion to dismiss was denied, Mr. Hardin requested access to the footage. The trial court initially granted Mr. Hardin's request in pertinent part and issued a written opinion in which the district judge expressly noted the content of the body cam footage, confirming the court had indeed watched it. The trial court quickly reversed itself inexplicably when the criminal defendant...
It's explicable. I mean, it's very explicable. And I love how they're framing this. When they rush to the court without notifying Hardin, who again doesn't need it, seeking a correction of the records. Yes, the correction of the records, which due to their erroneous labeling, allowed people to have unauthorized access to that which is private.
In the underlying case, and county attorney rushed to court without notifying, seeking correction of the record in a way that would circumvent the request for access. Well, that's because, as I understand it, by this time, other people had seen the footage. So other people actually took the time to go down and see it and had been reporting on the footage.
Yes, those people went in as proxy for Mr. Hardin. So yeah, you're 100% right. That's why. And preventing further access is, of course, a critical part of all this. Hold on. What is this? One moment. Something is happening.
With fairly detailed notes in some cases. So they were aware that people could see it and people had seen it, and they essentially wanted to seal it so no one could see it. So it wasn't Mr. Hardin's...
Actually, we didn't request it to be sealed, to be precise here. And this is a critical distinction. I'm not just picking on Kurt here, because this is a big part of all of the cited authority that is brought by the representing attorney at the appeals case, Oliver Bromke. He has cited cases in which challenged the sealing of documents But all of those documents are part of the court record. This is not the sealing of a document. This is the correction of an erroneous labeling in an electronic filing system. Has nothing to do with the legal status of the document itself. A sealed document has a legal status that has been adjudicated by a judge. A judge has determined that a document needs to be sealed either for a partial amount of time or a permanent amount of time. This is a different thing. This is correcting what is essentially a quote-unquote technology or user error, akin to a scrivener's error in, a filing where, maybe some numbers get transposed or something, and that can be corrected by the court. The ability of the court to correct clerical errors, especially clerical errors that cause harm, is something that's been around forever in both the federal rules and in every state's rules. And the idea that a court could not correct a clerical error that is causing harm to one of the citizens under its jurisdiction is insane. But that is Hardin's and Bromke's position, that a clerical error cannot be corrected, and they have likened it to the sealing of a document. We're not asking for the legal status of the document to be changed. That's actually what Bromke and Hardin are trying to do, even though they are too retarded to actually say that. And they also know that they will not win on that subject. But what we're asking for is the legal status of the document to be preserved under the existing law, the correct way. That's a huge difference. And they have completely misrepresented their posture to the court at every stage of this.
Motion that really tipped them off. It was the other people reporting on it on kiwi farms, among other places. So, all that.
Correct.
Without notifying Carr and seeking correction of record in a way that would circumvent the request for access and related Government Data Protection Act request. Yes, in response to a motion presented by Kandiyohi County with apparent consent of the criminal defendant, the court suddenly revoked Mr. Hardin's access that had previously viewed and issued written findings explaining. Fair enough. Because the court changed the legal posture based on new evidence. Let's see. Remarkably, the court now held it had not reviewed the records at all. Mr. Hardin laterally formally moved to intervene in the criminal case for limited purposes seeking access to court records, specifically noted that he sought leave to file a brief in opposition to consent and set a hearing at which Mr. Hardin, can present.
Mick D87 says, reading $2 chats immediately now used to be 20. Yeah, it did. There was a time when reading chats immediately was so disruptive to the show that it was impossible to keep up. And that's why I created the $20 plus would be read immediately rule, which made shows have a considerably better flow. Lots of people adopted that. At present, that's not necessary. If it's necessary again, we'll do it. But right now, I like reading the chats as they come in. I'm happy to have them, and I'm happy that people choose to contribute.
We need video of him at the gym at Improv and dancing. Please, someone find him dancing.
That motion is denied.
There is video of Kurt at the gym. And believe it or not, it will present without my doing in this video.
Evidence and argument regarding his rights to access. The trial court purported to grant Mr. Hardin's motion to intervene in the criminal case in a limited extent, but the trial court did not allow him to file a brief in order to set a hearing. Instead, the trial court made 16 separated facts, all of which afforded Mr. Hardin any opportunity to participate or challenge. I don't know that he could. The trial court then denied Mr. Hardin access to the records, which is a pure legal conclusion. This is error for two reasons. First, the records are plainly judicial records, and the court's own May the 1st, 2025 order demonstrates the court.
That must be where I saw the May 1st number that had me make the mistake on the Mendez system, which was actually implemented January 1st. However, Mendez actually came into function in 2023. And I believe Kandiyohi County was one of the counties that required the electronic filing. So again, a couple years behind on the requirement. The test counties required the filings to Mendez, although they allowed, as it was a testing time for a period of 18 months to 24 months. They did allow for, if there was some sort of error, they got a lot of leeway on not having things filed at the right time.
have viewed such records and made findings as to the content of such records. Okay. Second, the trial court was not permitted to make factual findings adverse to Mr. Hardin without permitting Mr. Hardin an opportunity to be heard. Why not?
Yes, of
course. It
course
was a limited
can.
motion to intervene. He has no rights in the first instance.
Correct.
And the court basically is granting a limited intervention. And so the nature of the intervention is kind of what the court wants at that point. Because he's not a party to this. He's not a party to it. He's trying to get at it a different way. So, okay. Especially when the trial court purported to have granted Mr. Hardin limited status as an intervening party. Yes, but the nature of the limited status is kind of the issue. The standard of review, whether a record is a judicial document, which is open to the public inspection under constitutional common law right of access, is a pure question of law subject to de novo review.
Incorrect. It's abuse of discretion. And in fact, it's so clearly abuse of discretion. It's actually abuse of discretion in the briefs that are cited by Oliver Bromke, including the one he referenced, Arif. And there is a Minnesota case on the right of intervention as well, which he would later cite because he was too lazy or incompetent to find it earlier. Even though this is the key issue of his case. I'm talking about Oliver Bromke, North Dakota and Minnesota attorney, not Kurt in this instance. Oliver Bromke, though this is the key issue to his case, failed to provide any relevant Minnesota authority on this. And when he eventually supplemented recently his Minnesota authority, the case clearly states that this is reviewed as abuse of discretion and not de novo. So not only does he not have his authority here on the main issue of his case in the jurisdiction where he's arguing, the cases cited both in federal jurisdictions and the one case that he supplements with clearly go against his legal position that he has laid out here. So this is rather embarrassing for Bromke. Big mistakes. Lynn Britton says, I like Kurt. I like you too. I have no problem with people liking Kurt. I don't like him. And it's not about what he said about me. That I really don't care. He and Nate were involved in a discussion that really, really pissed me off at a time when I was really easy to piss off and really hurt by some things that people said. They got some things wrong. I was able to squash that beef with Nate immediately. No problem. Talked it out. I apologized for the things that I said. I've long forgiven that discussion. It doesn't matter. It's something that gets brought up all the time. And I think there's something else. I don't really care that they laughed when they thought I was going to jail. I did at the time. I was angry. I was angry at a lot of stuff. I was angry at me, mostly. But I was angry at other people. I was angry at people who called me friends that, I would have been happy to provide information to so that they could get the story accurate. And they chose not to take it. And that's fine. But it did make me mad, of course, right? Like that, I think that's understandable. But that anger has been let go. Now I don't like Kurt because of myriad other reasons that I overlooked for a really long time, particularly how he treats my friends, particularly how he treats women, and particularly who he offers his pizza casserole and wine to. These are things that I find objectionable and have no desire to associate with. And it's the type of thing that I would never have associated with. I wasn't really aware of the pizza casserole thing until more recently this year. But here we go. Reading the rest of that chat. Sorry. Honestly, I like Kurt. I like you too. Happy to see you working on life balance, continuing to keep y'all in my thoughts. Hey, I really appreciate that. I really do. Snarky old lady, welcome to Paralegal Status. Very happy to have you on board. That makes us at 125 memberships, which is phenomenal. Thank you so much. And big shout out to our sponsor, Kurt's Dating Advice in Chicken Shop, where you can get all of your needs. Do you want to have a stuffed chicken or stuff a chicken? Kurt's Dating Advice in Chicken Shop will help you with both of those needs. Thank you very much to our sponsor. Medieval Syphilis. So many developments made me miss the Rekieta drama, but glad I'm into your stuff again. You were the first father figure type I got after joining the military 6 years ago today, and happy to say you still run my night schedule. Oh, that's great, man. Hey, I hope the military treated or is still treating you well. You know, I know people have different experiences. What I can say is this, as your fatherly figure, take out of the military more than what they take out of you. Make profit on yourself and on your future based on the investment you've made in giving them part of your past. You deserve it. Take it. It's yours. Godspeed, God bless, and may his hand protect you. Let's see. We got this from Cookie.
The Godfather is one of my favorite movies. I watch Michael clips often. Also, I'm getting my driver's license and plan to move from NYC. Too expensive, crowded, crime-ridden, and dirty. Suggestions.
Move somewhere without an income tax and with a good culture around you. Those options are Tennessee, Florida, Texas, Nevada, as far as I'm concerned, and I'm aware. I'm not aware of any other places that don't have a state income tax. Where you go in those places will dictate the cultures that's around you. So careful. Also, Florida is always sus on the list because people throw alligators like javelins there, and that's always a risk.
Um,
South Dakota as well. South Dakota doesn't count because South Dakota is still cold and also smells like North Dakota.
Well, for the most part, yes. I mean, yeah, it is pretty much a pure question of law at this point because the factual predicate is understood. So there are no facts disputes. There are no factual disputes. So at this
correct. And what Kurt isn't saying, and he may say this, I don't know. This is again not a criticism, but to word that more appropriately, the entirety of the factual, the relevant factual scenario here is contained in judicial records. There is no internal or external fact that is missing from the judicial records within this case and the accompanying administrative law case that was brought on May 1st or whatever. Nothing else exists which would clarify or supplement the factual record that is not present in the judicial record itself. So there's really no need for, not only is there no need for Mr. Hardin to present an alternative factual scenario, there's no real need for anyone involved to supplement the factual scenario. It's all part of the judicial record. And all of it can be done by the judge taking judicial notice of what has happened strictly within the bounds of the court.
At this point, yes, it's a pure question of law. What else would it be? Unless you could somehow say you could challenge the trial court's findings of fact, but how could you do that? And how would that even make sense? And what finding of fact do you think they got wrong or left out? Like, what is the material aspect of this? He hasn't said yet, by the way. He's just said, you deny me the chance to participate. But why did that matter?
And again, I actually think this is probably doesn't matter because it wasn't raised by my attorney, or the county attorney. But actually, let's be very clear. He was granted the relief he sought. Hardin was granted the relief he sought. And honestly, this should have been argued as this case is moot, because even though the filings were mislabeled, even though that allowed particular public access, and even though that was error that may need to be addressed in some other way on behalf of the county, even though all of that happened, Mr. Hardin was still granted access to that which he sought. He received the relief he requested from the judge. He chose not to go and to instead send by proxy 3 other people, I believe, although only 2 made it in time to actually see the footage. But he chose not to participate in the relief that he received. And this should have been brought probably by both the county and by my attorney. I only realized this, 2 days ago or something. I think only when the motion was argued or when the appeal was argued, did I realize, hey, wait a minute, he actually got the relief he received. Or no, it was even after that hearing when I was thinking back on it. So I'm not criticizing my attorney or the county attorney here in not bringing that up. I just thought of it later. And it's one of those issues where where what I believe happens is you get deep into an argument and you miss like the surface level opportunities here. And that happens frequently. People get locked into minutia. Well, what about all these facts and getting through all these facts? When the simple answer was, hey, he actually got it. He got the relief. And that's it. Now, of course, their counter argument would be that a further right of public access would be necessary. However, the counter to that is really simple. No, it isn't, because the people who witnessed the footage put up what they purport to be a factual and accurate recounting of what happened, and none of them found anything that disagreed with the record that was put before the court or the public, and therefore they have gotten the right of public access. Public is now satisfied as to the status of these body cams, and everything is good. What was requested of the court was granted. That's somehow being ignored here, and it's probably too late to bring it up. But that's, again, what happens when you get into the woods on arguments rather than looking at the forest from the outside first. And it's a problem not only in law, it's a problem in just daily discussion. I'm sure you've all been in arguments where you get trapped up in minutia, defending yourself against something that like is little, maybe doesn't even matter, and you miss the big issue. That's what happens. That's what makes the job actually difficult, is proper issue spotting. Arian the Vegetarian says, you're my replacement high school best friend. He's gay. Look, I'm the best gay friend. I really am. You're the older bro my loser brothers could never be. Well, send him to the Nick Rekieta brother camp, and the Nick Rekieta brother camp will whip them into shape. I'm a fantastic brother. I'm not a good brother. I try to be. I'm just not the greatest. But my sister's really awesome. That said, my gay best friend camp is also very, very prominent program that's been accessed by all of the best gay best friends that exist.
Why did his ability to participate matter? What would have changed? What is the error? What is the materiality of the error? It's unclear yet. Okay. What difference would it have made? Whether the trial court has denied a party opportunity to develop its evidence, what evidence? The court cannot uphold the trial court's judgment and should demand for further review of what? What possible other evidence could you offer? If he doesn't at some point in this brief tell me what evidence he wants to have offered, if he doesn't tell me what it is and why it's mattered, I'm going to be really, really grumpy.
Are you going to be grumpy, Kurt? Why? Are you going to be grumpy because you were hoping that the legal posture of the Kiwi Farms would be better than the legal posture of the Nick Rekieta? Look, I've said from the start that you never know what can happen in any of these things. Something is always possible to happen. But from my understanding, my read of the law, which I know, not an attorney or whatever, and so stupid, worst lawyer ever. Okay, cool. Yeah. Right. I got it. But my read of the law, it's really, really clear. It's not even a question that we should win this case. This shouldn't even be before the court at this point. This should be really straightforward. The question that no one is saying is, does a clerical error by the court, not by an attorney, not by a party to the case, not by anybody, by the court itself, does a clerical error then condemn a document to change status forever? And the answer to that is obviously no. I think it's Rule 60 of the Federal Rules of Civil Procedure. Let me see. Federal Rule Civil Procedure 60, or it might be 66. So let's see. Here we go. No, it's Rule 60. Here we are. Let me make sure this is showing up. Yep. Okay. Relief from a judgment or order. Corrections based on clerical mistakes, oversights, and omissions. The court may correct a clerical mistake or mistake arising from oversight or omission whenever one is found in a judgment, order, or other part of the record. The court may do so on motion or on its own, as in sua sponte, with or without notice. But after an appeal has been docketed in the appellate court, and while it's pending, such a mistake may be corrected only with the appellate court's leave. All of this was done prior to the appellate court. This is Federal Rule 60, and the Minnesota rules are modeled largely after the federal rules, include that rule as well. I don't remember which Minnesota rule it is. I didn't have to deal with it in Minnesota law during my practice, I don't believe. However, I remember in law school learning about the federal rule, which is why it's up there. It's one of the big ones. Correction of clerical errors is critical in this. The court's right and ability and power to correct its own error is essential to the right of the court to do anything. And you can't condemn a private individual's rights because the court screwed up or some person associated with the court screwed up, maliciously or innocently. It doesn't matter. The court must be able to correct those errors to preserve the rights of the people under its jurisdiction, or else its authority is meaningless. Why don't we understand this? Why is this a foreign concept? Why is anyone struggling with this? I don't know. I don't know.
Kurt is so gay, he makes Richard Simmons look like Gene Simmons.
Might be that micropene, white bread as lawyer.
Oh my goodness, that's 4 micropenes. Oh my goodness.
Okay, Nicholas, how about North or South Carolina? My family seemed to be migrating back to the South. I like the idea of Tennessee, but as far from Memphis as possible. Out of the 3, which is best?
I have spent very little time in North or South Carolina. I think only driving through them. I spent a little time in South Carolina, I think. Is Charleston, South Carolina? I think so. Was it Charleston? Oh, I was near the... Yeah, Charleston, South Carolina. Where else? There's another town down there. I can't remember. This is years and years ago. It was major South Carolina cities. There's Charleston's the only. Wasn't Columbia, wasn't Charleston. Okay, it wasn't any of these places. Where was I? I guess I just drove through there. It doesn't matter. There's a military base somewhere close by. I was really charmed by the feel of that area. I liked the... I liked the vibe I got, for lack of a better word. Savannah. I think I was in Savannah, Georgia. I think that's maybe where I was. I think it was in Savannah, Georgia that we ended up in. But like that whole like area has a cool kind of the architecture is really neat. I mean, I know it's like slave era architecture, which is super offensive to the people today or whatever, but it was that Southern Plantation look is like really, it's like an interesting era of US history, and it looks really clean and white. But the pillars out front and all that stuff, it's almost like a new Victorian. And I like that also. Lady Rackets is messaging me some pretty good stuff. Stop it. I like that look and feel, and the people down there, is a really nice area to be in. Now, obviously you don't want to go to Atlanta. No one wants to. They always end up in Atlanta. But yeah. So I mean that could be really good. The tax situation is different, but I don't know your situation, Cookie, so who knows? But I think, the Southeast is a really beautiful part of the country. It's got a pretty decent climate. You're close to the good ocean. And because the Pacific can eat balls for all I care. So fucking warm. And yeah, it's got a lot going for it. Good food too, of course.
Whip up some brother butter at Nick Rekieta's brother camp in Wisconsin.
Special guest Taisha Business Sushi Bar.
You know that bitch had a bite.
Wait. What happened with Borowski's voice there? Guys, what happened with Borowski's accent? Oh my goodness. All right. We're going to play this again. Just because, in case you missed it, Borowski is the second voice that comes out. I think I have an explanation, and it's so good.
Whip up some brother butter at Nick Rekieta's brother camp in Wisconsin.
Special guest Tay Taysha Business Sushi Bar.
You know that bitch had a bite.
Special guest, Taysha Business Sushi Bar. Please open cloth. Show vagine. All right. So one of the features that hasn't been explored on this stream, people are welcome to mess with it. If you send a chat that is in a foreign language, the AI will actually have the chat voice perform with the foreign language accent and inflection as best as it can. So I think what happened there is somehow it triggered the AI to be like, yeah, South Asian, the Indian variety. I think that's what happened. What just happened with that? I'm sorry, I'm stuck on it.
Whip up some brother butter at Nick Rekieta's brother camp in Wisconsin.
Special guest Tay Taysha Business Sushi Bar.
You know that bitch had a bite.
Special guest Taysha Business Sushi Bar. Ryan, if you're around, can you clip out just that segment of it for me? I need the sound drop for that, please. Oh my God. Yeah. Treasure Island says, I'm sorry, but did Uncivil give a 20-minute workout talk yesterday? He may have. I don't know. He may have. I think he might have.
And so will the Court of Appeals. You should have given me a chance to present evidence. Why? What would it have been? What would it have mattered? Why do we care? Hopefully at some point he'll tell me.
He won't. Spoiler alert.
Okay.
We've been streaming for almost 2 hours, and we are a whopping 16 minutes and 45 seconds into this 1 hour and 40-minute video. I will try and interrupt less.
And then we cite some case remanding to a trial court so a state could develop a factual record when it was not previously required to develop. I mean, there are certainly times when that's true. I don't know why it's true here. Another case holding that although appellate courts do not ordinarily consider arguments not presented at trial, exceptions can be made. That's true. It can be done. But why here? Alternatively, this court might view the trial court's denial of an opportunity to be heard, including but not limited to the opportunity to present proffered evidence, like what, as a violation of procedural due process. How do you have procedural due process as a limited intervener? In which case, the denial will be subject to de novo review.
Kurt is nailing this right now. He is spot on the issues and the problems with it. The opportunity to present proffered evidence. No evidence has been proffered in this case at the time of this filing. So it's very weird for them to suggest that they didn't have the opportunity to present proffered evidence. They did not offer a proffer to the court at all. Sully SDS says, oh wait, was it you or Real Hard Truths? Are they the same? Oh my goodness. Says, I live in upstate South Carolina. Although we do have state taxes, they are pretty low. And housing costs are pretty reasonable. There you go.
Okay. That's your argument? That seems like a strange argument.
By strange, you mean not any good?
Because you're kind of trying to do on factual issues. That seems like the wrong line of argument. Right? That feels like the wrong line of argument for this appeal. If I were going to find...
Resist the temptation.
Fight this. If I were going to fight this appeal, I'd just be going on the pure legal issue. Right? I'll just take all the facts as given and just say, well, given all those facts, I should be entitled to view the thing. Because that's the legal argument. Now, I don't know whether or not I can win on that ground, but I don't see how I'm going to win on the factual issue, because I don't have any facts to offer. What facts do I have to offer? What do I know? What testimony could I give? What evidence could I give?
Brother, your face looks like a Monet painting at the moment. What is happening? There are clinics that, Kurt should go to. I'm really refraining from being mean on this. He needs to go to a cosmetic clinic and get a skincare routine that is specifically designed by a specialist to take care, evening out some of the redness and whiteness that's going on his face. I don't think it's sunburn related. I think he has some underlying issues, which are not his fault, but they are treatable, I believe, at least in some way or another. And I think it would really do him well. Again, going back to the time when Kurt didn't think everything I said was crap, when he didn't think that everything I said was a load of garbage, and when he was asking me about this type of stuff, I think this would really help him not only in delivering his content, but also in his extracurricular pursuits. And I don't think Kurt will ever be a chiseled Greek god. And I don't think that's in his future. Like, it's not in mine, either. Like, that's not a whatever. Like, some people have the genetics, the time and the drive for it. Other people have other interests and not as favorable genetics. Perfectly fine. But that said, clean up what you got, man. Because I feel like you're wearing a mask that could peel off at any moment and there'd be another one under it. And there are all sorts of creams and even laser treatments and shit that can help out with that. So.
Right? I mean, there's nothing to do. Right? The evidence is what it is, right? I mean, that it was submitted to the filing system on a certain date with these file names at this time. It was submitted by Nicholas Rekieta's lawyer. The court wrote in its opinion what it wrote, either did or did not cite it. Either that did or did not happen. Either it did or it said it considered or it didn't, right? I'd just be quoting straight from the record. That's what I'd be doing. I'd be like, look, here's clearly where the court cited it. Let me cite you the places the court cited it. Let me show you all the places they cited it. Let me show you the place the court said it considered it. Let me show you these things.
The problem with that, of course, is the court expressly said that it was not considered. That's actually in the judge's ruling. I did not consider the videos or their contents in any of the rulings that are made for this. And the judge, it's almost like the judge has done this for a little bit.
And that's why I win. If I have the cards.
But you don't.
If I don't have the cards, then I'm just making shit up. Right? So I hope he has the cards because he says he does, but he hasn't shown me yet. So and even then, it's not based on any facts he has to offer. It's not like he has some unique testimony. His entire argument would just be, go read the fucking page. Just go read the goddamn page. Go read the court order. That's how I did it. I read it. You can too. Go read it. Go read page 5, line 6, where it says da 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 da. Don't take my word for it. Go read it. It's in a book. Take a look. Reading Rainbow.
Lesko says, in the video we are pretending doesn't exist. He nearly cleared 2/5. To do that, you probably dabbled a little bit previously. Wait, what video are you referring to? And who? Is this a Kurt video or a me video? I'm just curious what you're talking about here.
This is going to be a long ass stream.
Look, there's a big ass to cover on screen right now. You get to decide which one of us is two cheeks. Which one? Maybe we're both a cheek.
But he has no. Okay. Argument. Mr. Harn was entitled to view the records he requested, in which the court previously ordered he could review. You do understand that courts generally have the power to change their own orders, right? It's not like you have property right in it. It's like, the court said I could view it, and now I have a property right they can't take back. And that's not how that works. The records Mr. Harn requested reviewed were submitted to the court via the criminal defendant and cited by that defendant repeatedly in the motion to dismiss. Was it cited? I don't remember the citations. See, you don't have to just tell me, just show me. Show, don't tell. Show, don't tell. Don't tell me he cited it. Show me. Say, on page X of motion Y, it said in line Z, dot, 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 dot. Just show me. Show me the Carfax. The motion to dismiss was denied, and Mr. Rekieta ultimately entered a plea of guilty. He sure did.
Yeah, when your procedural options are out, you've exercised your rights, and though I may disagree with the trial court's ruling and the appellate court ruling, there are maybe reasons they made those rulings, but on the broad issue, I may disagree with what ultimately happened at those stages. When your rights have been exercised and your procedural options are out, the question comes down to, are you guilty or not? And I was. very, very simple. I didn't put up a fuss about it or anything. I just pled guilty. Yeah, this was my stuff in my safe that I had the combination to. It was mine, my responsibility. I love that. Like, I stood up in front of the court. Well, they had me sit down because the mic is close to where you're sitting. They didn't have me stand up, but I came before the court, during the court, and after the court. I came to the court and I said, I did this. It was me, my choices. I may have reasons for those choices, but they're not excuses. They don't excuse my conduct. I made them. They turned out bad. Really sucks. But it happened. But I did it. No one held a gun to my head, made me do them. No one held anything to my head and made me do it. Again, I have my reasons, and that's fine. But those are my reasons for me to explain my poor choices. Those poor choices were made consciously, and I admitted to them straight up because they were mine. And a bunch of people say I refuse to take accountability or responsibility. I don't know how else to do it.
Court unquestionably viewed the video footage submitted by the defendant because the court's initial order granting the motion access to records explained the substantive content of the video. Well, just quote it. Just quote the words of the court. Just quote it. I'm getting frustrated. The records are therefore inarguably judicial records, and there's a presumption of public access to those records stemming from at least three sources: the United States and Minnesota Constitution and common law. Please note, by the way, he doesn't actually cite anything.
Right. The citation would be to the First Amendment, freedom of the press, would be the idea that the right of judicial access is derived from the First Amendment right of the freedom of the press. The press has a right inherently to review documents and to effectively challenge the government. All of the cases cited that he cites go to this issue. Interestingly, in all of the cases, the petitioner versus respondent positions are not the same as mine. Usually, the petitioner is both the intervener requesting access on behalf of the public and the defendant who has not been able to review the document. And that's what's being left out of all this. All the citations that support this right of intervention in a criminal proceeding have the criminal, the purported criminal, the defendant, unable to access a piece of quote unquote evidence or a document from the record that they believe will be effective in assisting their defense. That didn't happen here. I have had access to the body cam footage the entire time. The body cam footage was not at any point used against me by the state. So none of that was an issue. So there is no, I don't have access to records, and there in the right of the citizenry or the right of the press to intervene for that limited public access is often combined with the defendant. And by often, I mean literally almost always combined with the defendant having a lack of access to the same thing. The government has sealed from even the defendant the document in question. That's not happening here. In fact, neither the state nor I have any issue with the evidence, the status of the evidence in the case, and no documents in the case have been sealed. They're all fully public. These documents, I say documents, they're videos, but documents for the legal purposes, are not part of the record. Therefore, there is no need to seal or unseal them. The judge unsealing the document, for example, would have no legal effect on its status because it's not sealed presently. It is just in private status because that's where it belongs. As it's not part of the judicial record, it is then governed by the Minnesota Data Practices Act. And once it's in the Data Practices Act, that law controls, and it says it is private, which is defined in the Practices Act specifically as subject to the privacy interests of all non-government employees who are in the footage. We don't need to rehash this.
It's in the U.S. Constitution. Where? Where in the where in the Constitution is it? Would you like to cite an article, a section, a clause, an amendment? No. Where in the Minnesota Constitution is it?
And Kurt's right to make by the way, Kurt's doing a wise thing right here. He's like, where is it? Where is this constitutional right? Would you like to cite it? And that's it's a bit of a trap challenge because you can't find it in the plain text of the Constitution. It's in derivative decisions made at the federal and state level. And he doesn't cite those well either.
That's it. Would you like to cite any particular portion of the Minnesota Constitution? Oh, it's just in the Constitution somewhere, floating around in the ether. Great. That's great.
And it's actually not in the Minnesota Constitution, and the Minnesota cases derive the right from the federal right, remembering that the federal Constitution is the minimum bar that everyone is entitled to. State constitutions can go further. This is only in the Minnesota State Constitution and as derived from federal constitutional law.
That's fantastic. It's in the common law. Would you like to narrow that down at all? Would you like to narrow that down from like the 800 years of common law? Would you like to tell me where? No, you wouldn't like to tell me? Oh, okay.
The case that he cited at the hearing, US v. Arif, involved two Arabic men who were involved in a sting operation where they were attempting to buy a missile launcher to shoot down an airplane, an airliner in New York, right? Like they were trying to buy, like from the 90s movies, the Stinger missiles, right? Like those things. That's what they were attempting to buy. It was a sting operation that was a setup, and they were convicted of that crime. They clearly intended and attempted to do so. They attempted to make the purchase, and that is, that is enough in furtherance of the scheme to make it an attempt. So they were convicted on all of those. Well, one was convicted on all counts. The other was convicted on 10 counts, and the rest were dismissed. I don't know the details of the dismissed counts. In that case, the government, the court issued some orders, and those orders contained classified information. Those orders were then sealed because of the classified nature of the order under the court's rules on sealing documents. They sealed the entirety of the documents, and in US v. Arif, the appeals court came to the conclusion that the sealing should typically not be of an entire document, but that in that case, the sealing was proper, that the defendant also has a right of access to any piece of discovery evidence that would aid or assist them in the defense of their case. However, since what was sealed were orders of the court, those orders were not assistive in the defense of their case ultimately, and therefore contained nothing that the defendant was entitled to. And if that were the case, the orders would have been made available to the defendant with limited redactions. And in fact, the defendant's attorney in that case was allowed to review those documents to attempt to find and educate the court in camera, ex parte. So the defendant's counsel alone was in a room with the judge, and they were reviewing the documents to determine if there was anything that would be assistive in the defense of the client. And the judge determined at the end of that in-camera hearing, no, there was not. So that's the case that they cited at the hearing. They have since supplemented with a couple extra cases that all come to the same conclusion.
Just in there somewhere. Take my word for it, bro. Sure. Lord. The presumption of access has not been rebutted, and the trial court only claimed the records were never judicial records to begin with. That was error. First, the court must determine whether the records Mr. Hardin requested are judicial records. According to the trial court, the answer is no. This was error. Sure. There's a common law access to judicial records. I'm getting really pissed. I'm actually getting pissed at this point in this brief. I'm getting mad.
You shouldn't be emotional about this, Kurt. The reason you're emotional is because you want me to lose. You've wanted me to lose for a long time. I said earlier that I would offer a little bit more about my last conversation with Kurt, which was a 90-minute phone call in a hotel hallway. That conversation effectively boiled down to jealousy over Kurt's perception of my relationship situation. Finding it unfair that my relationship status at the time existed and his did not. Ever since that phone call, in which I did not in any way insult Kurt or demean him, or nor was I rude to him, other than to say some things, man, I can't talk to you about right now. Some things I can't say to you. I can't tell you everything. But other than that, I attempted to answer the questions that he had as best I could. Some of those questions involved the privacy of other people, which I was not going to disclose to Kurt. And when Kurt doesn't get what he wants, he gets angry. And Kurt was on my side up until that conversation, which was around July of last year. It was not around. It was in July of last year. I have been trying for years now to help Kurt be presentable to the opposite gender, whatever that may be. I don't know what the opposite gender of a refrigerator is, but I know that he's cold and stuffs a bunch of food on the inside. So I think that's what it is. But I don't know what the opposite is. But I've been trying to help him out. He never followed any of my advice or tips, and that's fine. But then he was mad at me for what he lacked, which I had nothing to do with at all. Only ever tried to help him. If you want to know the secret, there it is. If you want to know why Kurt's incel rage suddenly manifested in late July and continued on, slowly declining from that point to where he was laughing at the prospect of me going to jail, even though we had expressly negotiated that out with the county attorney. If you want to know why, that's it. Why do you get 2 and I only have 0? Okay, Kurt.
Jim te dit boc boc dans ton wagon de queue canard canard oie.
Don't make him French. It's very rude. Very rude.
Legal hypothetical question. You said the other day your oldest just turned 18, right? Congratulations, BTW. Always a proud day seeing your tiny human grow up into an adult. 1-3. Question, since you can't have access to firearms, if the now adult had a safe you didn't have access to, would that be a court-compliant legal transfer?
Court-compliant legal transfer would imply that I would be involved in that transfer in some way, which would be a problem because I don't have any guns to transfer. Under a hypothetical scenario where I had guns up to the point of being placed on a probationary order where I was temporarily restrained from owning or possessing them, like now, could a legal transfer be made at that point in time? It's a hard one. I don't know because my guns were seized and forfeited right away, in which I do believe the process by which Minnesota does this is a violation of your Fifth Amendment rights, because they compel you to sign a document acknowledging the seizure and forfeiture of your property, including firearms. And to contest the seizure and forfeiture of your property, you must make a filing within either 60 or 90 days of the signing of that document, which you are, while in jail, compelled to sign. you have to make a motion for the opposing or contesting the forfeiture of the property while the criminal case is still ongoing, which requires you to make a claim of ownership at that point. It requires you to make a claim of ownership to property that may have been circumstantially illegal to own. For example, as a user of a controlled substance, owning a firearm and claiming ownership of that firearm could be a violation of the law, which I was charged with. So were I to contest the seizure and forfeiture of my firearms within the time window, which again was 60 to 90 days of the arrest, and I was convicted 11 months after my arrest, so you can do the math there on why that won't work, I would be compelled to make a statement that would be used against me in a criminal proceeding that I was under at the time. To me, that is a violation of the Fifth Amendment. That came up considerably later. And so at that point, I had to let go of the firearms that were seized from my property. Importantly, though, signing the forfeiture acknowledgement is not an acknowledgement of your particular ownership, merely that property was seized from yours. So that in and of itself, signing that forfeiture document is not violative of your Fifth Amendment rights, but the requirement to pursue your property within 60 days, which may be the subject of criminal litigation, requires you to violate your own Fifth Amendment rights by claiming said ownership. In which case, I was not at the time able to do, because I would have been then potentially convicted of a further criminal act. It would have complicated matters, and that is a violation of your Fifth Amendment. I don't know how else to say it. So I think that is impossible as a standard. Hold on, let me read this. So there, that's to answer the question. But in a hypothetical situation where maybe firearm ownership was missed or something like that, could it be transferred to the person? Yes. In theory, to simplify the question, could my son, who is 18 and living in my house, own a gun safe that I do not have access to and keep a firearm in it? Purportedly, yes. Possession is not mere proximity. It has to do with who has the right to grant and deny access. If I didn't have access to the safe, it would be hard to claim that I owned or possessed the gun. So in theory, yes. In practice, do you want to be the guy who fights for that in court with the risk of 2 years of prison hanging over your head? Practicality often trumps the legal posture. But in theory, legally, yes, it could be done. Practical, I wouldn't want to risk that personally.
If you want another short, wild WTF case, you should look up the airman who was indicted in a plot to take over a Haitian island and enslave its population.
I just saw this.
Also, Curticus Micropenicus is looking rather gradient today. I can't wait to hear how a goat gets dubbed with such a glorious name later this year. 4-4.
Now we're at 5 micropenes on the micropene counter. And what he is referencing, of course, is my friend Valhalla Arise's fundraiser to deal with a probate case. I was on Valhalla's stream yesterday helping raise money for his probate case. And I have created the Nick Rekieta goat naming cartel. I have bought a 1/10 share of it with a donation of $50. If you want to donate to Valhalla Arises, if one of the mods can, or Valhalla Awaits, sorry, not Arises. He only arises when I show up. Valhalla Awaits. If you want to donate to the Nick Rekieta goat naming cartel in favor of Valhalla Awaits, you can do so at his Give, Send, Go. Just make sure you comment Rekieta cartel or something like that in the donation description so he knows how to tally those up. If we get to 500 aggregated dollars in the Nick Rekieta goat naming cartel, then we get to submit a name for one of the goats, which currently the leading contestant is Curticus Micropenicus, the famous Greek historian and arena combatant and legendary chariot rider, Curticus Micropenicus. And if you would like to honor said Greek hero, Grecian hero, of the meme wars, you can do so by donating to Valhalla Awaits. And thank you to the mods. If you would go ahead and share the link to that Give, Send, Go. I don't think I have it pulled up right now, but if you guys could pull that up, I would really appreciate it, and share it in the chats. Okay, back to this. Oh wait, we got a couple more of these, and then we'll get back to Kurt.
Kurt can get a woman.
Yeah, but them bitches got 74-inch hips, my Nick. Our micro peen gang sign. Out.
Gang sign. Out. Out.
Wait a damn second. I didn't realize they seized them all at the time of the arrest with forfeiture. How the fucky rubber ducky can you be legally compelled to forfeit personal property? I could see a potential temporary forfeiture until the terms of your probation, but outright forfeiture? That sounds like killdozer time.
Yes, and again, to assert a right of ownership and to contest the forfeiture, I would have to do so, I believe it was 60 days, but it may have been 90. Within 60 or 90 days of signing the forfeiture acknowledgement, which would implicate my Fifth Amendment rights by forcing me to admit to ownership of something which may have been criminal at the time, at the time of ownership. So obviously, I believe that, I had to make the choice and not assert ownership of them during the pendency of the criminal case in which I was charged with possessing a firearm in proximity to drugs, which was dropped, by the way. That was dropped and dismissed out.
Okay. He's like, they're judicial records. He doesn't say why they're judicial records. His next sentence is, there's a right of access to judicial records. Well, that presupposes they are judicial records. You can't say these are judicial records and then say, well, there's a common law right of access to judicial records. You kind of have to prove they're judicial records first. Why are they judicial records? Talking about your right to access the records because they're judicial you haven't proven the predicate yet. You're killing me. I'm dying. But the common law is not the only source of this right. The Constitution, both Minnesota and the United States, provide access.
Where?
To which he's still not going to tell me where in the Constitution of either one, incidentally. As the Eighth Circuit explained, the right of access bolsters public confidence in the judicial system by allowing citizens to evaluate the reasonableness and fairness. The status of a document as a judicial record depends on whether or not a document's been filed with the court. Well, finally, he's fucking citing something. Jesus Christ. The status of a document as a judicial record depends on whether a document has been filed with the court or otherwise somehow incorporated.
I need to take a pee break. I'll be right back. So see you guys in just a second. Okay, sorry about that. It's coming up quick.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited for what you have for us when your being is through. When you have a small bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Now you're washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, so drink some when the stream is over. When you have a small bladder and no sphincter control,
Okay, sorry about that. Woohoo! I love how every time I play that song, people leave. They're like, oh, well, it's over. It's like, no, it's the peeing song. I said I had to pee.
Incorporate or integrate into a district court's adjudicatory proceedings. Citing Third Circuit. We're trying to determine whether they're court records for the purpose of Minnesota state law, right? So while I appreciate your Third Circuit citation, better would have been a citation from, the Minnesota Supreme Court. That would have been better.
Right. Instead, they use a Third Circuit citation. We're in the Eighth Circuit. This is a mess.
If I'm trying to determine what Minnesota law is and whether or not these are Minnesota judicial records, you know who'd be a really good authority on that?
The Minnesota Supreme Court.
So while I appreciate your Third Circuit site, you got anything better?
No, they do not. Spoiler. Kurt is going through this way faster than I am, by the way. I'm sorry. I'm an embarrassment to efficient streaming. Treasure Island says, so far, it's just me and Nick in the cartel. Awkward. It is awkward, but cozy. It's cozy in here. Real quick, here it is. This is Valhalla Awaits. I kept saying arises. God, I'm sorry about that. Here we go. 8-year probate case. Help give Val some closure. He's raised $4,000. This is to help pay for an attorney. His father passed away, and his father's estate has been unsettled for 8 years, and he needs to raise the funds to hire a probate lawyer and close out the legal proceeding around the death of his father. And so this is just at givesendgo.com/Valhalla awaits. And like I said, if you give with a, let's see, where is it? Here's my donation. Much love to my brother Valhalla. This is for my 1/10 stake in the naming cartel. If you just add Rekieta or naming cartel or whatever to your donation, when you make it, you can donate anonymously if you'd like. Then you are contributing to the naming fund. If you contribute to the naming fund and send me a receipt, and you would like a different name than the proposed Curticus micropenicus of the baby goat, you can do so by emailing me proof of your donation. Again, blur out any relevant details related to your payment, which I don't think come on the receipt anyway. But blur it out. So don't send me any of that stuff. I don't want your payment details. Just, it's a meme, guys. So it's just for basic proof that you are part of there. And if you want a different name, it will be considered and presented to anyone who emails me, and we'll make this a democratic choice, which means that you guys will all argue about it and vote on it. And then ultimately I'll decide. Matt himself too gifted 20 more memberships. Whoa. Whoa. Oh, whoa. Whoa, 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 whoa. Oh my goodness. We now have to update this to 145 new members today. You guys are amazing. The membership counter and micropene counter is, of course, sponsored by Kurt's Dating Advice and Chicken Shop. Get your dating advice in chicken in one convenient location. If you want a chicken to like or a chick to like you, Kurt's Dating Advice and Chicken Shop is your only destination.
As the Eighth Circuit noted, oh wait, no, that's the wrong part. All documents properly filed by a litigant seeking judicial decision are judicial records entitled to presumption, citing a district court of Minnesota. This brief sucks. This brief is sad.
It's very bad. It's very bad. Thank you, Kurt, for your honesty on that. We'll see what you say later, but thank you for your honesty on that. We have Palmyra Media dropping 10 more gifted subs. Oh my goodness, it brings us to 155. We are literally cooking with Kurt today.
I think all this butt hurt Kurt stuff is from his jealousy of not being invited to Twisted Tuesdays.
As funny as that would be, it was not a regular event. I think, look, regardless of relationship, if there are people you are comfortable with, strip twister, and if you don't want to be too awkward, just get down to swimsuits or something. Strip twister is one of the most fun things I've ever done. And believe me, it is way less sexy than anyone thinks. I don't know when the last time any of you played Twister as an adult was, but it is a hard game. Your muscles, unless you're like used to doing stuff like that, are not prepared for the pain you're about to endure. You are not in the mood to do anything anything raunchy afterwards. You're mostly just laying there crying about your thighs.
Let's be honest, the only people pushing for the body cam are the subhumans who are disappointed by the extent of your downfall and are unable to jack off as a result. These shit stains just want you in a ditch so they can laugh at your corpse while hiding behind fake righteous indignation. Fuck them all. People can be mad, but pushing for your utter destruction and humiliation is disgusting.
I mean, I was utterly destroyed and completely humiliated by my own choices. Like, that happened. I didn't need any help. I didn't need any help. But it's the internet, and that's how some people are.
The mere act of filing a document with the court clearly establishes a document is judicial record. But even where a document is not filed, it may still be a judicial record if the court interprets or enforces the terms of that document or requires that it be submitted to the court under seal.
Which didn't happen. Of course, there are no terms to a video that the court's trying to enforce, and neither was it required to be submitted under seal. This is a bad citation involving a completely different issue. I should update that we are 155, and I've updated the counter, 155 memberships today. Thank you guys so much for joining up to the show and helping others with access to members-only content. There will be members-out content later tonight. We will have a member-exclusive live stream, which we do every single weekend, and that is done on both YouTube and Locals. As soon as I can figure out how to incorporate Rumble, I will. The problem is I believe you have to use Rumble Studio to do members-only on Rumble, and Rumble Studio has a real glaring issue in that from Rumble Studio, you can create your Rumble stream in advance, and you can use it to create and control a YouTube stream, a local stream, a Twitch stream, X, Facebook. All of those things can be done. However, the other streams, the subservient streams to Rumble, do not manifest in advance. They can't be, you can't have a link set up for like the show will start in 4 hours, for example. They only start the moment you hit go live. Then they're created. Then you can go in and control them, which makes it impossible to announce those other platforms because there is no, you don't have a link to share. You can't push them out to other social media. That's my big problem with Rumble Studio. When using StreamYard, you create you create the stream in StreamYard, and at each destination that affiliates to StreamYard, Rumble isn't there yet, it will create a link and generate the stream in advance and schedule it for when it will start later, just as if you made it on YouTube. Rumble Studio needs to do this. It needs to be a feature. Having it set up on Rumble 3 hours in advance and having no link to share, even for their own platform on Locals or anywhere else, is balls for creators. It's just not good. If you're trying to get, now I know what they're trying to do is push creators towards using Rumble exclusively, but until they do that, until they create this, again, very simple, very user-friendly feature that other streaming platforms, multi-streaming platforms like Restream and EVMux and StreamYard all use and all understand the value of, until they give that added value, it makes it really hard for me to do it. And that's a problem. I like Rumble. I want to stream to Rumble. I want to, have those people who want to subscribe on YouTube and stay away from, stay away from subscribing on YouTube. I want to give them a chance to participate in the same content. Rumble needs to fix Rumble Studio to do that, in my opinion. Otherwise, it's just untenable for me, who still has a significant, if not majority audience on YouTube, to not be able to announce a stream in advance of it starting.
What's up, my knickers? Rackets, any word on Camelot's situation with YouTube shoving the world's biggest micropeen up his ass with lube or a courtesy reach around?
Not currently. I do intend to put out a short form video about it, not a live stream, one that's concise and explains the situation. When I get as much information as I can about it, I need to ask a couple more questions and see if Camelot will be able to answer them or not. If not, that's fine. I just want to make sure I've asked those questions before I do it.
Why are we writing these things? Why are we writing these things? Did we just start throwing darts at the Federal Reporter and
Yes.
we're just like citing, whatever pages we happen to hit? This, you're not really selling me, man. You're not really selling me on this, I have to say. Not feeling that. There's a presumptive right of public access to pretrial motions of non-discovery nature, which this isn't, by the way, whether preliminary, dispositive, and material in the field of contextions thereof. Some more Third Circuit opinions. I'm going to be sick. Here, the criminal defendant, and arguably, wait, is Minnesota even in the Third Circuit? I have to check my map. I have to check my map. Hold on. Is Minnesota even in the Third Circuit? Hold on. No, it's in the Eighth Circuit. Well, that's great. So not only are you citing cases from not only are you citing cases that are not from the Minnesota Supreme Court, you're not even citing cases from the controlling circuit for this state. Okay. Great. That's super great. That's just fantastic. Super well done. That's great. That's really great. Here, the criminal defendant inarguably filed certain evidence accompanying his motion to dismiss, which apparently believed would support that motion. The evidence was submitted was video footage and was so naturally not attached to the motion as exhibit might otherwise have been, but instead filed and served via the whatever system. Regardless how, the court required the material to be submitted, and the criminal defendant's brief cannot be fairly read or understood if the material to which its public site is unavailable. Yes, it can. I read it and understood it without reference to the material. I both read it and completely understood it without reference to the material. I don't even remember Nick Rekieta citing the footage anywhere in his motion. I don't remember that. And it seems like our applicant over here doesn't remember that either, because what would be really helpful, what would be really great, is if he started citing it. He's like, oh, it was in the motion to dismiss brief, silly uncivil. It was in the motion to dismiss brief on page 7 at line 4.
It's not there.
Clearly said, as shown in the body cam footage, here and attached, blah, 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 blah. I was like, oh, now I remember.
Again, credit where credit's due. Kurt is rightly frustrated by this. And despite Kurt's reasoning for being frustrated, which I think is his generalized anger at my poking, which again, he's rightly frustrated. I'm not saying that that's improper. But regardless of the source of his frustration, he wanted this to be better. He wanted the release of the body cam because he thinks, like other people, that it would be humiliating to me to have it released. Okay. But that's what all of this is saying. Like, it's plainly obvious. It's kind of funny, because I think he would try and argue that he's neutral on the issue, but he wants it out. He wants it released. Of course he does. That being said, his legal analysis here, though frustrated, is frustrated but correct. He's got it. This brief is no good. 200 Watt Studio says, are you saying after Kurt's divorce, he sought your advice on love? I don't think Kurt was ever married. I think he said he got close. He was engaged maybe and broke up, if that's what you're talking about. Or if you're just talking about like me and him not being friends anymore. No, at the time, you know, that at all times I spoke to Kurt, we were friends. I think he was frustrated with the last conversation I had with him because he wanted information that I wasn't going to disclose to him for numerous reasons, but mostly because he was asking for information that involved other people who have asked to be private. And I wasn't going to share or disclose that information to him. And sorry. And he asked me to answer for perceived hypocrisies, in which I provided what I believe was my personal defense of those perceived hypocrisies. And that's, I'm not changing the way you look at something isn't necessarily hypocrisy. Right. And so if he didn't like those answers, that's okay. Like, he doesn't have to like the answers or me or anything else, but that is the genesis of where this began.
Now I remember him saying it, but not so much. He's not saying that. I'm pretty sure because it didn't happen. Yeah. But he wants me to believe it did. Okay, that's great. It's going great. All right. Regardless, however, the court required the material to be submitted, and the criminal defendant's brief cannot be fairly read or understood if the material to which its public cited is unavailable. If the material cited in the brief were somehow not part of the brief itself, which it's not, the evidence Mr. Rekieta submitted to the court was clearly filed in connection with his underlying motion within the meaning of this case, which isn't even a case from the relevant circuit. Further, unlike unfiled documents such as discovery requests, the court actually viewed the thing. You're gonna actually like, okay. The trial court.
It says addendum at 21. It's actually cited in their addendum. I talked about this extensively when we reviewed the hearing itself. We didn't actually proffer the evidence and comment on its substance, and the court didn't actually view it. The court viewed it in May in response to the request for access. Prior to that, there's no indication that the court viewed it at all. In fact, I say the court viewed it in May, but I don't actually know. However, that would have been moot. That would have been irrelevant. It was after the pendency of the case that the court would have viewed it. And most importantly, the court viewed it on request of Hardin. And if you have any if you don't understand anything else, understand this. If you, anybody, Matthew Hardin, whoever, could request to see a sealed document and then claim that the court reviewed said sealed document and therefore it is now part of the record, but they viewed said sealed document in response to your request to release the document, and now you claim, well, the court reviewed the document, now it should be released, then sealing has no meaning. Then any document can be requested to be reviewed by the court, and the court would presumably review the document, which would then subject it to public scrutiny. That's insane. That's an insane proposal that invalidates the protections that the court has the ability to put over a document that is not for public consumption. And that's that. Like, there's very little else that could happen. Or very, very little way to interpret it other than it would completely destroy the ability of the court to protect any document. Now, whatever your position on the court's ability to protect documents may be, the idea that you can pierce individuals' privacy, individuals' right of privacy at your request leads to the ability ultimately to conduct what is effectively a private prosecution, because the court could then be taking judicial notice, which could then become part of an official court record of something that was inadmissible as evidence. And now it becomes admissible just because you asked the court to unseal it. That's crazy. Or to review it. You can't do that. And that's not a system that can be allowed.
Court candidly conceded that the M's relevant to the performance of judicial function are judicial documents. Yeah. The criminal defendant certainly thought the two body camera footage issues were relevant for the purpose of judicial function. Well, I don't know about that necessarily, but okay. Because he cited those videos repeatedly in arguing that all charges be dismissed. Then CEG, Mr. Rekieta makes 6 separate citations to 2 items of evidence in support of his motions to dismiss this hearsay. You know what I would have done? I would have just actually listed all 6. If he really this is the backbone of your case.
Yep.
This is the backbone of your case. If you really,
it's also completely like it still doesn't pass legal muster.
Really believe 6 times he cited the body cam footage, you bet your ass I would put all 6 in the brief itself, because it's the cornerstone of my case, right? He cited it 6 times, Your Honor. Here's all 6, and the court cited. Here's where they cited. Said we consider. I cite it all. You better bet your ass.
My ass is bet. With that, I forgot to announce, because I didn't see it at the time, Michael Tenemer has gifted 10 memberships as well, bringing us to 165 memberships for the stream so far. Thank you, guys. We are driving members. If you want to help drive your member, just go ahead and sign up. Or if you've already driven your member and want to bring a friend to have multiple members, you can gift memberships to as many people as you would like. Thank you to everyone who has joined up and gifted memberships.
Several times I probably cite it. But not so much, man. Not so much. Yeah, it's not going great. It was error for the trial court to somehow determine, after receiving the criminal defendant's briefing signed to the evidence, and after inarguably watching the relevant footage, which just quote the court if that's what happened, and commenting on its content, the records at issue were somehow not judicial records, or therefore not presumptively public. Because the records at issue are judicial records, which you haven't convinced me of in any respect, a presumption of public access applies. That presumption may be occasionally rebutted. Federal courts in the District of Minnesota have utilized a 6-factor balancing test for the purposes of their own records or for the purposes of federal constitutional law, because that matters, right? When the federal courts say, hey, records can be restricted and here's a 6-part test, are the federal courts saying that for the purposes of federal records and federal law?
Yes.
Or are they saying it for the purpose of the U.S. Constitution? Because if they're only saying it for the purposes of like the statutory law, then fuck whatever.
Even if they're saying it, if they're saying it for the Constitution, it matters a little bit more, because the constitutional protections are a minimum bar that are provided to everybody at the federal level. States can go beyond the federal Constitution. Of course, I said this earlier.
Right? Then, the federal courts are determining access to their own records. And for the purposes of determining access to their own records, they've got an exciting 6-part test. But unless...
This is a really good point brought up by Kurt that was, I believe... well, I don't know if it was addressed in my attorney's brief or not. I'm not sure. I don't remember. But this was not brought up at oral argument. The judges didn't have any question about it. But this is a great point by Kurt. And if he spotted this issue and saw it on his own and it's not in my attorney's brief, then good job, Kurt. And my attorney, Francis, you're fired. That's a joke. You're not fired, of course. But that being said, if he caught this and Francis didn't, that's great. And good on Kurt for doing that. But this is a great issue to say, hey, that's the federal court's determination of its own rules, which it has the authority to set. And doesn't have anything to do with the state's rules on their access to records, and does not create a constitutional right in and of itself. However, I believe that the right of public access is considered a constitutional First Amendment law under the U.S. Constitution, which does not validate the 6-part test that they're talking about, but which does validate ultimately some level of public right of access, in which the courts in the states would presumably develop or adopt their own test as they see fit. Fletcher Boy says Sunday afternoon Law Pope needs to be a weekly event. I would love to do that. And again, working on stabilizing things so that I have a schedule that is knowable and predictable for you guys, so that you can adjust your viewing accordingly, is high on my list and playing around with some different things. Thank you for showing up in droves tonight. I really appreciate it today.
Unless that exciting 6-part test derives from the Constitution of the United States, guess what impact it has on Minnesota? Fuck all. Fuck all would be the answer.
That's funny.
So
whoever said Kurt isn't funny is wrong. I don't know if Kurt always knows why he's funny, but he is occasionally very funny. It's why I talked to him and liked him for so long, despite many glaring things that I may have overlooked at the time. And for people that were affected by me overlooking those things, it became more and more apparent at the time leading up to my arrest. When I would bring Kurt on, the numbers would drop significantly. People would message me or say in the chat very clearly, I can't watch if he's on. And, I was very defiant and stuff in those times. And so I would just say, hey, fuck off. I'll have who I want on, which I still believe and adhere to. But I didn't consider all the reasons why people were frustrated with me having Kurt on. And he did abuse some of my guests in ways that I think were not appropriate and very frustrating. And then the most important thing is, if you're going to abuse a guest, you have to consummately make up for it by being wildly entertaining. And he didn't do that.
Did you know that? Did the person writing this brief know that? I don't think they did. I think they thought, federal court says something, therefore it must apply to Minnesota. That's not how it works. Okay, and then for this proposition, just to continue pissing me off, he cites the DC Circuit, which is also not the 8th Circuit. So not only is it, probably about federal records and the standards that apply to federal records, it's once again not from this circuit. But that's okay.
But it is funny that the citation is Seaman versus Midwest Bonding. Or wait, no, that's the next citation. This is US v. Hubbard. But Seaman versus Midwest Bonding that's a funny citation.
He has an unreported.
And lock it down. That is a Minnesota case. Unreported in Lexus.
Case from a district case in Minnesota, which cites this thing for some proposition, something World Star.
World Star? Where did that come from?
Okay.
That was funny.
Kurt, who wrote this brief?
Do that. You son of a... You cannot be funny right after I say that you're not intentionally funny very often. World Star. Wait, what? Where did that come from?
Why did they write this brief? This brief horrible. Okay. Oh, finally, he's going to cite the 6 factors. Oh, thank God. Not that it matters, because it's from the wrong circuit and probably doesn't concern this anyway. But he's going to cite the 6 factors. The 6 factors a court can use to evaluate can use. Oh, it's optional. Oh, okay. Can use whether presumption of public access has been rebutted are the need for public access, the extent of previous public access, the fact that someone's objected to the identity, the strength of any property and privacy interest, the possibility of prejudice, and the purpose for which the document, citing again that district court case, which itself was citing the DC Circuit. Okay, here the district court did not apply the factors at all, probably because
they don't apply.
Probably because it's not binding authority. That's probably one of the reasons they didn't apply the factors. One of the reasons they didn't apply the factors is because they didn't have to. Because it's from the DC Circuit. And they're not DC now, are they? No, not so much, no. Here, the district court did not apply some bullshit law that didn't apply to them anyway, possibly because that court proceeded to adjudicate Mr. Hardin's entire claim without the benefit of briefing, and possibly because that court's earlier error in determining the records at issue were not judicial records at all, which you still haven't convinced me of in any respect. Regardless, the Hubbard factors weigh in favor of public access. If only the Hubbard factors mattered. If only the Hubbard factors actually were like legally applicable in this situation, or had anything to do with the price of tea in China, that would be great. But not so much. No. First, there's a need. He's going to continue discussing it like it's dispositive. He's going to walk us through all 6 factors and why they do or do not apply, like it's controlling. I hate whoever wrote this brief. Was this pro se? It better have been. This better have been a pro se brief.
It's not.
I swear, if an attorney filed this, I'm going to punch somebody in the face.
But of course, Matthew Harden is an attorney. So even if it was pro se, it would be an attorney who filed it in this case. I don't know if Kurt knows that.
First, there's a need for public access to documents at issue in order to understand the criminal defendant's briefing, which argued his substantial rights were violated as police officers committed serious misconduct. What the fuck? Specifically, the criminal defendant argued the two officers had violated a third-party Miranda rights after the party expressly requested an attorney. If the state were to attempt to present evidence in violation of Miranda, that could be prosecutorial misconduct. What the fuck? The state said explicitly that they weren't going to use the statements against, you know, what's the whore's name? What's her name? I forget.
What's he going to say here? This will be interesting. He forgets her name. Okay.
I want to say Ashley, but that doesn't sound right.
How deeply have you been reading, Kurt? Well, if you're going to confuse April with Ashley, that means you've been heavily researching the dramatic elements of the subject and not just the legal elements. Why is that? Why is that? 200 Watt Studio 8 says, did you hear about SSRI versus ejaculate? It got reversed. I did.
Against the whore. So yeah, they said that they.
Wow. And there it is. Someone who's never spoken to or about Kurt, who has not commented publicly on this situation at all. He refers to as a whore. Wow. Little bit rude, if you ask me. Where is that coming from? Oh, I don't know. Why do you get 2 and I get 0? It's not fair. Okay.
They said they wouldn't use the information, so it's fine. April, thank you. I knew it was an April. I couldn't quite come up with it. April, thank you.
No, see, instead of referencing Aaron Imholt's ex-wife, you referenced his first ex-wife by first name, which means you've been reading beyond the legal issues. So curious for that juicy, juicy drama, aren't you, Kurt? I don't want to get involved.
Yeah, they said they wouldn't use it against April, so no problem.
Or me, or me. They also said they wouldn't use it against me either. Now, I don't know. I think it's actually more relevant to my case that they said they wouldn't use it against me, because that was what was at issue. And it was an interesting legal question. Can you assert protection for statements on behalf of the Sixth Amendment rights of another person? Because April's case at that point was, they had not even reached the omnibus stage at that point. So, it was, I don't know that she actually promised not to use those statements against April, whose case was ultimately dismissed. But that being said, the relevant part is they said they would not use them against me, which is, of course, what we were asking.
Dick, this is where Kurt shows the motivation. It's his loneliness and jealousy. It gets worse. Micropene.
We're at 8 micropenes now. 8 micropenes. Let's go with incel statements. We're going to add that to the counter. We're at incel statements 1 so far, and this is, of course, this counter is sponsored by Kurt's Dating Advice and Chicken Shop, in which the incel statement at question is him calling a person he's never met nor even spoken with and has no reason to believe a whore, which would state very, very frankly that she had sexual intercourse in exchange for money. I'm not aware of any such scenario in which that took place. But hey, you know, I guess Kurt thinks so.
It's fine. So this is speculative, and also the state itself said it wouldn't have done this anyway. Civil litigation is also a possible consequence. Miranda rights are violated. Yeah, hypothetically, but not really so much here now. It's impossible to understand Mr. Rekieta's argument and whether he's correct that the deputies violated Miranda, which doesn't matter because they weren't his Miranda rights anyway. It has nothing to do with him.
Plus, it is possible to determine if the deputies violated Miranda if we had litigated the issue, which we didn't. The issue was mooted by a pre-hearing agreement between the county attorney and my attorney. So the issue was taken off. It was expressly taken off. It's in the record. It's from the transcript that the judge says, okay, we will not need to address this issue and we will move past it and we will not address it.
And they weren't using the evidence at that point anyway. It might be a confrontation clause issue way down the road, but he has no standing to raise the Miranda issue.
Whether or not someone has standing to raise a Miranda issue on behalf of someone else for statements that they made but are inadmissible because they're taken in violation of the Sixth Amendment is not clearly fleshed out. It's an interesting question. That said, since those statements weren't going to be used against me, it became moot. They may have been brought up. If April's case had proceeded, she may have raised Sixth Amendment issues. We will never know.
Sure. Because it's not his rights. He has no Miranda rights relative to April. It's not a thing. He has confrontation rights, but that's at a trial way down the road. For the purposes, incidentally, of like an indictment or something like it might be able to be used. I mean, I'd have to get into the finer points of analysis of that. I actually don't know the answer to the question off the top of my head.
Yeah, very few people would know this answer off the top of their head. It doesn't happen very often.
Whether or not you can use like...
But imagine, okay, if the cops you're arrested with someone else at the same time. And in the course of that arrest, the cops can illegally induce statements from the other person in violation of their Sixth Amendment rights and in violation of Miranda, and then utilize those statements against you rather than them. If that's allowed, we have a problem. It's similar to the fruit of the poisonous tree. If you are illegally obtaining evidence, then anything derived from the obtaining of that evidence is similarly illegal in violation of the Fourth Amendment. Just because there aren't cases on this involving the Sixth Amendment, because Sixth Amendment issues are pretty rare, doesn't mean that someone cannot raise and assert those Sixth Amendment rights on behalf of a third party. And if they can't, if there's some ruling that says they can't, it needs to be distinguished out from whatever case you're in, and it needs to probably be clarified or even overturned, because now more and more statements are available than they have been at any time in common law history and in the country's history. And those statements, if they're illegally obtained, should not be used to implicate you, because otherwise they can just illegally obtain statements and decide not to prosecute a lesser party. And if they illegally obtain those statements in any other context than the Sixth Amendment, you're allowed to suppress those statements. Why they wouldn't be suppressible in a Sixth Amendment issue just because you don't quote unquote have standing, which is the wrong term, because standing is a federal issue, not a state issue. But asserting that you don't have the right to raise them is silly. Illegally obtained evidence is evidence that is obtained illegally. If the cops can just illegally obtain evidence and use it against you, then your protections are meaningless.
Statements obtained in violation of Miranda for the purposes of like a probable cause finding, you might be able to. I honestly don't know the answer off the top of my head. But in any event, it doesn't matter because it wasn't material to anything. So like, you know, whatever. Second, the documents at issue in this case were previously made open for public access. The court later determined that was an error, sought to correct. Yeah, that's what happened. That's correct. That's correct. It was deemed public access, and the court was like, "Oh no, it shouldn't have been," and then changed its mind. Yeah, just because it made a mistake doesn't mean it's bound by that mistake forever. That's
Correct.
not at all how that works.
Correct.
If a court makes a mistake, they're allowed to reverse themselves. Didn't you know that? Trial courts reverse themselves. Good trial courts do it with some frequency because good trial courts realize they're human and make mistakes. So, like, yeah, this is the weirdest version of I had ongoing rights because I had expected property or something. This is a very weird, established interest thing. Like, I had an ongoing interest and they took my interest away. It's like, I'm not buying any of this shit. Regardless, as a result of Mr. Hardin's original request for public access, at least 2 individuals were able to visit the courthouse and view the video footage. That's true. That's correct. That's what I understand. Unfortunately, Mr. Hardin himself was not able to travel to Minnesota and view the footage himself before his access was revoked. Well, that's unfortunate.
It's not that unfortunate. He was able to send 2 people as proxy. And make no mistake, they were sent as proxy for Hardin. Barbie World, thank you so much for the super sticker. Very much appreciated.
Previous public access to documents weighs in favor of future access.
Not necessarily, and certainly not in the instance in which that access was erroneously granted.
After all, once documents have been made public, sealing those documents or removing the access to ability cannot unring the bell. Well, it can to some degree when by public access, they meant you had to come down and view it in person. They were never released in the sense of being able to be viewed, by people on the web. Yes, 2 or maybe 3 people went down there in person and viewed it in person. It's relatively easy to claw that back. All we have to do is say no one else can come in and view it anymore. And so those 2 or 3 people have seen it, which, is 2 or 3 more people than, was ideal. But, it's not
Correct.
like now we have to let everyone see it forever, right? If I make a mistake and let, 3 people violate the law, do I have to continue allowing people to violate the law because I allowed these 3 people to? Right? This makes no sense. This makes no sense.
Spot on.
Right? Let's suppose
the idea that the court is obligated to continue violating the privacy interests of multiple parties is a silly one. That's a silly concept that is not in any way representative of how things operate. In fact, overwhelmingly in criminal, civil, and civil litigation, administrative litigation, all of it tends to involve at least some brush with the concept of mitigating harm. In some cases, even creating a duty to mitigate harm on behalf of the defendant, on behalf of the person who, or the plaintiff, on behalf of the person who is harmed. To say, hey, you have a duty to mitigate the harm you were receiving, because a reasonable person would mitigate harm in that circumstance if you have the ability and means and all that stuff. So not only is mitigation of harm considered by the court frequently, sometimes it's even required for recovery.
Objection! Your Honor, this incel Buffalo Bill looking motherfucker is turning into a tomato the longer this goes on. I refuse to participate in a system that uses mental and physical vegetables.
Overruled. The sexual predator tomato is welcome to spill his micropene seed in my cannoli.
Ew! Ew! Gross! That puts us at 9 micropenes, though. Thank you, Allie. Very horrifying. Thank you for that.
Suppose I'm a bouncer at a nightclub, and I let 3 people through the door, and then my boss comes up to me and says, "Hey, wait a second. We told you no more people through the door. We said, we're at capacity. The fire marshal's on their way, man. We're at capacity. Those 3 people put us over capacity, man. The fire marshal's on our way. We're going to get fined." I'm like,
And the doorman's like, but I got a blowjob for it. 3 of them.
oh my God, boss.
And the guy was really good.
I'm so sorry. I'm so sorry. Somehow I didn't get that communication. You know, I'm really sad. And the next person is in line saying, you let those 3 people through. And I'm like, yeah, but I wasn't supposed to. But you did. I'm entitled to go in too. Does this make any sense to anybody? Of course not. It doesn't make any sense. This is really dumb, right?
By the way, you're banned for saying cottage cheese cannoli. Thank you. Holly movie star, you are done. You're banned forever. That's horrifying.
I let 3 people park in the handicap space, even though they don't have handicap placards. It's like, yeah, that's a free space. Go ahead and park there. And then the guys, you know, then the people are like going to get tickets, and they blame me. And the cop comes up to me. Did you tell them you could park in a handicap space? Like, oh my God, I forgot. You know, despite the clear and obvious markings that somehow I missed. Right? I forgot. Well, don't fucking do it again. You need to let me park in the handicap space. You let those other people. You know, I mean, this is all sorts of dumb, right? After all, once documents have been made public, sealing those documents and removing their accessibility cannot unring a bell. Can a little bit in this situation. Third, the trial court should have considered whether any party objected the identity of the party. Here, the state and criminal defendant joined together without notice to correct the trial court record. It made clear the objection to disclosure. Yeah, because you don't have anything to add to the party. The irony of a criminal defendant as prosecutor agreeing that evidence should be kept secret should not be lost in the court. There's no irony in that. There's no irony. What the fuck are you talking about? The prosecutor and defendant agreeing that certain evidence shouldn't be made public? That's not ironic. It happens.
Correct. That's not ironic. In fact, parties to a lawsuit can often agree to the terms of how something should be handled, so long as there is a legal justification for doing so. In this case, though, the parties didn't determine how a document should be labeled. They didn't agree on the determination on how a document should be labeled. They agreed that an error was made in the labeling of the document itself. They agreed on the error, and the court agreed and corrected the error. It wasn't that they said, hey, the status on this needs to be changed. It's the status on this needs to be corrected to what it legally is. And what you have here is an error in a filing system versus an error of law. The court never changed the legal status of these documents. They were always private. They never changed from being private just because they were erroneously entered into a judicial record. Their status under the Data Practices Act was private. Their status as non-evidence was still non-evidence. You can't make something evidence by mislabeling it. Their status in regards to a piece of technology was incorrect. Again, akin to a clerical or scrivener's error, not akin to an actual legal determination. Life in General 101 says, random question, but I can't get it out of my head. If you stand in a wheat field and swing a lightsaber, will it just cut the wheat and that's it, or will it start a fire? Anyway, carry on. Also, I'm not sure Kurt knows what a whore is. I have no idea if he does or not. That said, to answer your question about the wheat field, I believe it would just immediately cut the wheat. There's a physical property of really fast moving heat passing by an object. To create a combustion effect, you need the right combination of heat that exceeds the specific heat capacity of the material, and you need a proper amount of oxygen able to be consumed by material that is further combusted. It would start smoldering. I think to start a fire, you would need a requisite amount of heat concentrated in an area for a sufficient amount of time, and a sufficient infusion of the materials needed to make the chemical fire reaction, which would typically be some sort of wind or like a bellows or blowing on it, etc. Similar to when you have an ember from like a flint and steel enter into like a pile of dry moss or kindling, and then you have to nurture that with containing the heat, usually by cupping over it and keeping the heat localized, and then adding sufficient amount of oxygen to create the reaction. So that would be my answer. I'm not a physicist, though. That's just my understanding of how it would work. I think if you cut enough wheat, it would eventually start a fire by raising the heat to the requisite levels.
Red light, green light, chloroform, white van, West Vagina hand puppet, you're my underaged muppet. The lotion is not going to rust the chains. Just rub it in precious.
That was horrible.
Whores are those adorable ladyboys I can buy for a carton of cigs and a $50 bill. I prefer them as they're jealous of my micropene.
That puts us in double digits, 10 micropeens for the stream. You guys are amazing. Thank you again to Kurt's Dating Advice and Chicken Shop. No whores allowed in the Dating Advice and Chicken Shop. Just stuff a chicken and a chick with the advice you receive from the Kurt's Dating Advice and Chicken Shop. Thank you for sponsoring the program.
Happens all the time. All the time. There's all kinds of evidence that the police capture and the prosecution doesn't want to offer as evidence, and neither does the defense. Yeah, it's ironic because the defense and prosecutor agree this shouldn't be made into evidence. If that's ironic, then ironies are occurring literally every day, all the time.
All the time.
Constantly.
Correct.
So, I don't know about that. The Minnesota Supreme Court and the U.S. Supreme Court both agree the need for public access to evidence is particularly strong.
We've got Adriana B. Custom Furniture says, love the suit and glasses. Offensive racist okay sign and a black heart. Happy Sunday. Hey, happy Sunday to you too. Thank you for being a member of the channel.
Citing a case that cites the U.S. Supreme Court. Okay. The crucial prophylactic aspects of the administration of justice cannot function in the dark. No community catharsis can occur if justice is done in any corner or any covert manner. This brief makes me sad. This brief makes me sad and makes me want to drink. In a criminal case, the community must have the ability to understand the truth, including whether a criminal defendant's very serious allegations of governmental wrongdoing are true or not. The video footage at issue will serve this exact prophylactic purpose. Fourth, the court must consider, not really, because even you earlier said may. You said they may, not must, and now you're going back to must, so you can't even decide. And also, it's not from the right circuit. First, this court must consider the strength of any property or privacy interest. Here, to be sure, the trial court recognized some privacy interests. Specifically, the trial court commented the footage the criminal defendant had filed with the court showed the interior of the home in which the search warrant was executed and certain minor children present at the time were executed. Which, incidentally, the court might know that without actually reviewing the underlying materials. Because maybe someone told them. Just because the court knows that doesn't mean it viewed it. Only the most compelling reasons can justify non-disclosure of judicial records. Even then, however, the remedy is not wholesale withholding entire documents or records. Even where a party can show compelling reasons while certain documents or portions should be sealed, the seal itself must be narrowly tailored. And it's not.
This isn't sealed. This isn't constructively sealed. This was never part of the record. Technically speaking, the court itself doesn't have jurisdiction over this document. The court only has jurisdiction insofar as the court mislabeled a document. The court has jurisdiction over the labeling of this document as evidence, not over the document itself. Again, the legal status of this document is controlled by the Government Data Practices Act.
Not enough for a party to simply point to privacy concerns in general manner and demand sealing. That's not what they're doing. They're not trying to seal it. They're trying to say it was never public in the first place. That's not quite the same thing. Fifth, this court must consider, and there's that word must again, the possibility of prejudice to those opposing the disclosure. Here, there's no possibility of prejudice because the criminal defendant has already entered a guilty plea after his motion to dismiss was denied, and the time for any appeal has passed. It therefore matters not where the evidence he submitted becomes public, because no jury can possibly be influenced by the evidence it alleges the police obtained improperly. Indeed, if the criminal defendant is correct, the evidence demonstrates police misconduct. Release of the footage may benefit him as the public rises up to demand reform and redress.
Yeah, except the defendant isn't arguing for that. So this is nice, trying to change the procedural posture of the parties by just merely asserting that it would benefit me for them to do so. But this isn't, if the criminal defendant is correct that the evidence demonstrates police misconduct, this isn't evidence. It was never entered into as evidence. I did not move for sanctions or sue the police on behalf of their alleged misconduct. I did not do so.
Sure. 6, the court must consider the purposes for which the records were
Ali Panda, welcome to Lawyer Status. Thank you for joining the stream. That's 166.
introduced. Here, the criminal defendant itself submitted the evidence at issue because it believed it would show police misconduct and the result in the dismissal of very serious felony charges. The defendant thus invoked judicial powers to seek a remedy, and the trial court exercised.
Actually, I don't know that we said that those statements, I don't know. They might have been. I don't know that we said that those statements merited dismissal of the case, merely that those statements should be suppressed, which the judge also said, by the way, that this was brought up prematurely, and the judge is opposed to the premature release of anything. And so he said this is properly before the court at a motion in limine once a trial is scheduled. We didn't get to that stage. That's another reason that the court didn't address this. So not only was it just by agreement from the prosecution and the defense, but also the court, on separate reasons, on its own grounds, said this is brought prematurely and is not properly brought in an omnibus motion. So we have another issue there.
His power to adjudicate the dispute, not by reference to the video cam foot. I mean, I'm struggling. I have not read Nick Rekieta's motion in a hot minute. It's been a while since I've read Nick Rekieta's motion to dismiss.
Nick Rekieta.
And it's been a while since I read any of the court documents, but I'm struggling, man.
I've been working out.
I'm struggling. I cannot, for the life of me, remember in his motion to dismiss him like citing the camera footage, and I can't remember any of that. I can't remember the trial court in its decision referring to the video. I don't remember any of that. I don't, and he's not citing it to me. He just said, trust me, bro, at one point. He said, trust me, bro. It happened a lot of times. Could you cite it for me? Could you quote it for me? Could you refresh the recollection of the poor uncivil over here? Because I'm not remembering any of this. Would you like to tell me at any point about it? No, you wouldn't? Oh, okay, that's great. The defendant thus invoked the judicial power to seek a remedy, and trial court exercises power to adjudicate. The public must now be permitted to exercise its right of oversight and inform its own view as to whether the police acted appropriately or inappropriately in Mr. Rekieta's case. Citing Nixon v. Warner commute. What the fuck? In short, the trial court erred here in two fundamental ways. First, it purported to determine the records at issue in this case were not judicial records at all because they were not received into evidence, which they weren't, despite they were submitted by the relevant system, which whatever. But once,
despite they were submitted via Mendes. Again, Mendes does not change the legal status of a document. Mendes is a requirement. It is a required rule. In case you're joining lately, let me just go ahead and point this out real quick. As of January 1st, 2025, any documents, photos, or audio or video recordings you want to offer at an evidentiary hearing or trial called exhibits or evidence for a judicial officer to consider must be submitted electronically before the hearing or trial through the Mendes system unless exceptions. For example, you must follow court rules concerning exhibits, including sending the exhibits to other parties involved in the case, blah, 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 blah. So the rules of evidence apply the same way they do to physical exhibits, because these rules can be complicated. It's a good idea to talk to a lawyer, et cetera, et cetera. But again, it is a requirement that any proposed document is filed there. It's not optional in Minnesota as of the 1st of this year. It actually hasn't been optional in Candiota County since mid-2023, I believe, because we were a test county for the Mendes system.
Once filed, records in connection with the motion are presumptively public cannot simply be unfiled or removed. The trial court should therefore apply the 6-part Hubbard factors, why, to the presumption of access. The trial court did not do so, but the 6 factors weigh in favor of access. Not really. This court should therefore review and hold a reverse, blah, blah, blah. Alternatively, Mr. Hardin was entitled to be heard. Why? Why was Mr. Hardin entitled to be to be heard? What difference would it have made? What difference would it have made? Mr. Harn was initially granted access to judicial records, but access was suddenly revoked without notice or an opportunity to be heard. Then, when Mr. Harn took upon himself to file a formal motion to intervene and present evidence as to why the issues were properly public, the trial court purportedly granted limited intervention by again denying Mr. Harn any opportunity to be heard. Well, I suppose it read your pleading, and there was that. Instead, the trial court made numerous findings of fact which were adverse to Mr. Harden, all without allowing him to challenge the factual findings. Were they wrong? Did the trial court make a wrong finding? What are we talking about? This would be error in any event. No, it wouldn't. But doubly erroneous insofar as the court had recognized him as a party. Limited at that. Parties before the court necessarily must be heard and presented to give evidence. That is separate and independent ground for reversal, not unless it makes a difference.
Again, Kurt's nailing this here, and you can see how depressed he is. You can see how depressed he is reading it, being like, oh, this is not going to work. This is not going to happen. Winston Smith says, glad you're back. With a $20 super chat. Thank you. Says, glad you're back. It felt like my favorite show was canceled. Your two best shows, in my opinion, were when you broke down Warren G's Regulate. Regulators! And when you debated that British tool, Duncan. Many good nights watching during bar prep. Hey, thanks, Winston Smith. I hope the bar went well for you. I hope you've since become a licensed attorney, unlike me, who is operating on a suspended license. I'm not actually operating. Oh, crap. That's going to be used against me somehow. I'm not actually operating on a suspended license. That was just a joke. That was a joke. But my license is currently suspended. But I don't want to represent you. I do not want to be your attorney or anyone's attorney at the moment. I am enjoying YouTube far too much. I will eventually complete my CLEs and rectify my suspended status. And then, at that point, I will hopefully be a licensed attorney again. But until that day, and at that point, I probably still won't generally want to represent people unless something changes. I'm able to do this and it more suits my desires for a profession than being a lawyer in general. Being able to communicate with people, hear stories, tell stories, explain the legal realities in a way that's digestible. That's what I love to do, man. It's so much fun. And we used to have a lot of fun doing it. And then I did a bunch of stuff that clouded that pure joy. I hope to bring that back purely without the social lubricants I was using at the time, which were covering up for a lot of other things that were going on that, were my responsibility to handle in a more responsible way. But, I broke that and I am sorry for that, but we're bringing it back. Like Justin Timberlake, he's bringing sexy back. I'm bringing legal analysis back.
First getting wrecked by the neck.
I want what I can't have. I look back at photos of me as a child, and as the ice cream drips on the glass or stains the yearbook page, the tears fall down my cheeks as I look at my old neck.
Holy shit. Keep that shit inside, dog. Your emotions should be like the 17-year-old girl you lured with pizza casserole locked down in your basement.
Curtis Careth asks, serious question. Did you put makeup on your nose today? No, I did not. And again, when my nose gets red, it's usually because I'm getting warm, either because I'm getting worked up or agitated, or because I don't have the air conditioner in my vault set high enough, low enough technically. And that is likely a result of years and years of consistent drinking, causing, chronic burst capillaries in my nose, which would increase the blood flow there. And maybe some damage from the cocaine and ketamine that I was snorting on a regular basis. At some point, I may go in to get it rectified, but that's what it's from. I mean, there's no real getting around it. As long as I keep, nice and cool and calm, things are good. It's like, it's like Rudolph or whatever. Whenever he got like horny and his nose, I think that's what the children's story says, right? Whenever Rudolph was Randy or whatever, his nose would get red. It's similar to that.
What difference would it have made? What testimony or evidence would you have offered? What error did the court make in its findings? Why does any of this matter? Allowing the intervention of a non-party lawsuit has significant implications. By the way, while I'm thinking about it, I want to make a couple changes to my audio. So if you would just bear with me for just a second, I'm going to fix something. real fast because I want to like make some minor improvements to my audio. Talk amongst yourselves. How are y'all doing, by the way? You doing good? We can talk about other things. Okay, let's see. Noise gate is on, de-reverb is on, de-click is on. I need to enhance that or something.
De-click?
I think I need to increase the sensitivity of this a little bit. Let's increase it to like 3.5.
I'm not going to make the joke. I'm not going to do it.
That's good. All right,
3.5 is beyond
low
micropene
latency.
levels.
All right, that's good. Frequency skew, click whining.
Science, micropenes are 2.9 or smaller.
All right, and okay, that looks good. Let's try that. All right, let's put on de-reverb. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Kurt Mueller, a licensed attorney in Texas, Virginia, and...
Did he say turn on reverb? Does he have reverb on for this? I'm feeling left out. Hold on. Did I hear that right? We're just going to go back a second. I got to know if he turned on reverb.
Hello, everyone. And...
I thought I went back far enough. I was wrong.
And, okay, that looks good. Let's try that. All right, let's...
How far back did he say that?
All right, let's try that. Low latency. All right, that's good. Frequency skew, click whining. Yep. All right, and, okay, that looks good. Let's try that. All right, let's put on de-reverb.
He's got some de-reverb.
Hello.
That's when your dick hits twice. De-reverb. You can find it. You can find out how to turn on your de-reverb at Kurt's Dating Advice and Chicken Shop, sponsor of the Micropene Counter, the Membership Counter, and the Incel Statement Counter. You can find all of that at Kurt's Chicken Shop, Dating Advice and Chicken Shop, which is sponsoring the counter. And of course, also you can learn about how to get your D to reverb and hit twice.
Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Kurt Mueller, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. Great. That will change those settings. That'll be a little bit cleaner. And the noise gates. Do I even want to have a noise gate? Let's try getting rid of the noise gate completely and see if that does anything for me. All right, let's give that a shot. Sounds a little echoey. Well, hopefully it's less echoey now. All right, great. Let's give that a shot. Okay. Allowing the intervention of a non-party in lawsuit has significant implications because an intervener essentially has the same rights as parties. Well, it depends on the nature of the intervention then. Here, Mr. Harn specifically requested limited intervention while a trial court purported to grant for the...
Which means your rights are limited to the purpose of the intervention and not actually the same as the parties. They're only same insofar as limited purpose.
Sole purpose of concerning access to the records. Yeah, the de-echo thing is not going to be perfect. It just tries to make it less obvious.
De-echo is just circumcised.
It's not the same thing as treating the room. It's just trying to like make it better so it's less echoey. It's pretty good though. I mean, it's pretty good. It's pretty sophisticated. It's just not perfect. It's pretty good for software.
But we all prefer hardware.
Here, Mr. Harn specifically requested limited intervention where the trial court purported to grant for the sole purpose of concerning issued access records. But even in the limited context of intervention, Mr. Harn made plain that he was requesting two specific forms of relief. First, they permitted to file a brief, and second, he permitted to add evidence. Like what? The trial court effectively denied Mr. Harn's right to present evidence and be heard. You know what mistake kind of happened earlier today, incidentally? I don't know why this happened, but I was like scrolling YouTube as I do, and there was a clip from Alyssa Clips with Nick Rekieta, and like, I mean, I don't know, man.
What happened? Did you watch it? Did you accidentally click on it? Like you couldn't help it?
I don't feel the need to address anything he says because he seems to do a pretty good job every single time, to my mind.
I do a pretty good job every single time to his mind, and that's where we end the stream. Nothing else he says is relevant.
Basically showing everything he says to be crap. There's
Except you agree with me on this entire analysis so far. So that means everything you say is crap too. Oh my gosh. Synchronicity, Kurt.
nothing for me to do. It's like I just let the man speak and he takes care of it for me.
Yes, I do. We take care. Here at Rekieta Law, fully endorsed by Uncivil Law. And thank God for that endorsement. I was worried about whether or not I should continue, but Kurt says that it's all in my purview and that I take care of it adequately and he does not need to comment. So perfect.
It's sad in its own way.
I know. It's really sad.
Yeah. Yeah. A district court abuses discretion by making findings of fact that are unsupported by evidence, misapplying the law, or delivering a decision that's against logic and facts. Here, the trial court erred precisely because it made findings of fact without affording a party to be presented. It's not going to work unless you tell me why it matters. If this court does not outright reverse and grant access, should a minimum remand so Mr. Hardin can present evidence? Like what? Specifically, Mr. Hardin proffers here he would have presented evidence. The material filed MNDS was received into evidence. The transcript does not reflect the evidence was withdrawn. Well, you can just tell us about that now. You can just tell us. Additionally, Mr. Hardin would have presented evidence that members of the public did access and therefore conclusion. This was actually written by an attorney from North Dakota?
Yep. Who's also licensed in Minnesota.
How? How is it? I suppose the North Dakota attorney got pro hoc, I guess.
Nope. He's licensed in Minnesota.
How is this?
Which is really interesting because his client, Matthew Hardin, is also licensed in Minnesota and could have easily filed this on behalf of the true client, which is Joshua Moon. Matthew Hardin is standing in as proxy for Joshua Moon, a fact that Joshua Moon has admitted multiple times. We'll see if that ever comes up. Who knows?
This is a horrible, horrible brief. This is really, really bad. This is a horrible brief. This brief makes me sad.
Why?
All right. Here was the right way to do this brief. Assuming the only way I can think to do this brief. Okay.
Well, that means there's probably several right ways to do it.
Assuming you have the cards, which I know you don't have. So, like, how would I write this brief? How would I write this brief knowing what I have to work with?
Well, I mean, you wouldn't probably, because I'll give that to you. I don't think Kurt acts unethically as an attorney. I haven't seen anything to suggest that that Kurt would do so. What I assume Kurt would do in this circumstance, and maybe this happened. Maybe this happened with Mr. Bromke or Mr. Hardin, but I assume what Kurt would do based on the person I know. And my problems with Kurt are not necessarily his ethics, but I would assume he would heavily advise his client against this action as, a waste of time. I think that's what he would do. Would say, you have such a low chance of winning. We don't have solid legal foundation here. But an attorney is ultimately a mercenary on behalf of their client. And if the client insists, then you either write the brief or say, I can't, I won't represent you in this case. It's not my thing to do, et cetera, et cetera, et cetera. So long as you're not making false representations to the court, which may have been done in this case, but let's, it's not being alleged at present. So let's ignore that. But as long as you're not making false representations to the court, then you have the leeway to make a legal argument, no matter how weak it is, so long as it is not frivolous. If it is not knowingly frivolous, then you can make a legal argument. And I'm not going to say that this isn't frivolous. I think the law is extremely clear. The Minnesota Supreme Court is extremely clear on this. And they're not actually challenging the Minnesota Supreme Court's ruling here. So I don't know that they'll even be able to go to the Supreme Court and ask them to overturn their own ruling, as that has not been, to my knowledge, raised by them in this case. So I think they've got, an issue there. But assuming the court finds it non-frivolous, there's no problem making a relatively weak legal argument on behalf of your client if your client wants to pursue it. That's part of your job, is to represent your client. But If he were to determine that it was legally frivolous, that would be a different story. But I think Kurt would argue that this is such a low percentage chance of winning and is not really worth pursuing. And then the client would argue some of the reasons that they may be doing it. And those reasons may be improper. And it really depends on what the client tells to the lawyer at that point. But I think Kurt would just probably say, I don't advise this. And maybe I'll refer you to someone else who might do it. That's my guess. Although he may act as mercenary too, which is fine. That's an okay thing to do. That's the job. That's the job. So.
I mean, you're just going to have to somehow try to sell it on the idea that there's public interest in it. That's what you're going to have to do. You're going to have to try to sell that this is a public interest thing. And you're going to have to try to use the relatively high profile nature of it, along with the scandal and coverage of it, as showing the public interest in it. That's what you're going to have to show. You're going to have to show.
But the public interest is not people who are interested in the case. The public's interest is a thing. And you would have to show how this manifests in the public's interest, not in interest demonstrated by members of the public. That distinction is really, really important. You can't just say, well, I'm interested and here's 100 other people who are interested in the body cam footage. You have to show the public's interest in it from a legal or constitutional matter. You look at this in police corruption cases, abuse of evidence and stuff like that. Really hard to do when a competent party is entering a guilty plea and there's no allegations or evidence of coercion of said guilty plea or anything else. It's very difficult to assert some sort of impropriety when none has been actually claimed.
So that the public's desire to understand this material and want this material is the public interest in the material itself. You're going to have to try to sell that. I don't know if you can sell that or not. It's not public interest in the normal way we think about it. It's not a police shooting that we need to see how the shooting occurred. It's not, a suspect being beaten up. So that's it's a run-of-the-mill, average, ordinary drug search. It is, presumably, no one has said anything to the contrary. Presumably, it is a paint-by-the-numbers drug search. It happens every single day. There's nothing particularly extraordinary about it in any respect.
Correct.
The police may or may not have violated April's Miranda rights is the only interesting thing about it. And even then, it's like, okay, if they violated her rights, which by the way isn't at all obvious. It isn't necessarily obvious they violated her rights. So we don't even know because that issue never got adjudicated. There was never a hearing.
And if they did violate her rights, it's mooted, of course, by the dismissal of her case, which predates all of this as well. Her case was officially dismissed on April 18th, which is before these requests were made and before intervention was sought. So you can't even suggest that that was an outstanding issue and that intervention would help resolve that issue because it was no longer outstanding at the time.
That determined whether her rights were in fact violated. We never got that far. But even assuming that they were, that's not particularly, extraordinary either.
And even so, what Kurt's saying here, I believe, is that Sixth Amendment violations happen. They don't, it's not the most frequent thing, but it does happen with enough frequency that just a mere violation of Sixth Amendment rights or a violation of Miranda isn't really in the public's interest. People know that police officers screw up procedurally in various criminal investigations. Those things happen. People go into jail and get brought out of jail. They may be a flash in the pan news story. Something extra or unique about it would have to make it, particularly of public interest or concern.
The police might have made a mistake. It's, there's nothing exceptional about this. This is not a public interest case. So the only thing you can do is try to sell them on the popularity of it and the public interest in the knowledge as being the public interest and try to sell them on that. That's the only way you can go. The only way I can see. So none of this makes any sense. All right, let's read the state of Minnesota's brief
Oh my goodness, we got time left here.
which I'm sure will be much better.
State of Minnesota brief was written by Shane Baker, the Candy, Ohio County attorney and elected official. I do want to point out that I want to clarify something that I wasn't sure of when I covered the hearing. Shane Baker did arrive to the hearing. Ultimately, he was just late and missed some portion of the petitioner's argument. So he was actually there. He was merely a few minutes late. And my attorney mentioned that lateness may prejudice his ability to accurately or adequately respond to the arguments that were presented.
By the county attorney. A much shorter table of authorities, too, which is cute. Table of authorities is very short. Okay, then they go through a little bit of a procedural history of the case. All right. So let's see what happened here. Okay, let's see if we can get on some of the timeline that happened that matters.
Winston Smith says, passed my first try, licensed in 2 states.
Okay, exhibits
Nailed
were received. Franks, plea hearing, adjudication, hard and receptive copies. They've been uploaded by defense counsel and marked as admitted, which I don't think they were. Observing the footage was marked as admitted, but restricting the review only to courthouse by appointment.
No, he's right. They were marked as, oh, I see what he's saying. They were marked as admitted. He said, I don't think they were. They were not admitted is what he was saying. They were marked as admitted, but they were not admitted. Very good.
State filed a motion, request district court issue were correct, that they were never offered as exhibits, which I don't believe they were. District court granted the state's issue.
And again, correct. They were never offered as exhibits.
That they were not accepted, which I believe is true.
It is true.
The footage of the body camera had been placed by defense to support the third omnibus issue relating to a possible motion limine. Both parties agreed their intent was not to offer the body cam footage marked as received. Therefore, it was meant to mark that it was not accepted, which, yeah. Filed a motion to intervene, blah, 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 blah. Okay. The district court issued an order denying Hardin's motion access to body camera footage. The district court rescinded an order granting limited access that stated while uploading the footage from the 2 body cameras, the status box was mistakenly checked to indicate the exhibits were admitted, which they weren't. It was a mistake. They were never offered as exhibits and they were never admitted. That was a mistake. The admitted status of the 2 exhibits was inaccurate and required correction. Yeah, that's true. That was a mistake.
Yep.
Yeah.
100%.
That's right.
And it was a mistake that we had nothing to do with. This is not something that was in the control of my attorney or Shane Baker. It was, it's either the court clerk or court administration. I'm not 100% positive on where the mistake lies.
Facts. In May 2024, information came to the attention of the Candy, Ohio County Sheriff's Office that Nicholas Rekieta was in possession of controlled substance. He sure was. He was also in possession of a woman that didn't belong to him.
All right. Okay. The incel energy has just dramatically increased. I'm sorry. In possession of and woman who didn't belong to him are some wild statements. I think that counts as 2. I think that counts as 2 incel statements at once. One, that I would be in possession of a woman unless I were, of course, like someone could theoretically be in possession of someone if they were involved in human trafficking or slavery, right? Which I was not, to be very clear. But also a woman who did not belong to him. The belonging of one person to another is a weird perspective. Very, very weird. So we are going to go ahead and mark that as 2 incel statements. So that puts us up to 3 incel statements. And again, the incel statement counter, along with all counters, including your countertops, is sponsored by Kurt's Dating Advice and Chicken Shop. Find out how to stuff your chick and chicken in one convenient location. Kurt's Dating Advice and Chicken Shop. Thank you for sponsoring.
And at the time, belonged to another man.
Belonged to another man. Again, we're He's going to do this a lot, I think. We're up to 4. Belonged to, at the relevant time in question, the time of the arrest, those two were separated and pursuing divorce. So I don't know that belonging to someone else and condemning them to remain with said person who has admitted to physically abusing the person that they presumably owned, has admitted on a live stream to that person was being, that the person that belonged to them was being just too loud. And so he admitted to squeezing her forcefully against her will and without her consent until she would just be quiet because she was just too loud. This is not an allegation. This is his description, because they were arguing and the kids were around and she was being just too loud. So he needed to squeeze her until she was quiet against her will or consent. And also to gingerly press his forehead hard into hers so she would understand she was being too loud. She belonged to him though, right, Kurt? Whew. This incel statement counter is going to go up quick. I have a feeling. Kim Boley says, why, oh, why are people interested in your body cam footage? This is insane. You have to ask insane questions, get insane answers. Ben Ryder says, wait, for real? Yes, this is beyond allegation. Again, this was his explanation of the event. His personal explanation was that they were arguing, she was too loud, and he needed her to be quiet so the kids didn't hear them arguing, so he squeezed her until she was quiet. It's on his own live stream. Look at how salty he is. He's not mad about drug possession. That's not his problem. He's in possession of a woman who didn't belong to him, but belonged to another man. Who have you been talking to, Kurt? I wonder who it is. Oh no. Did I hack the Googles?
On May the 23rd, 2024.
Mr. K, she was under 35. Yes.
At approximately 9:13, the search warrant was executed at Rekieta residence located in Candido, Ohio County. A search occurred with 2 deputies operating Bodycam. The videos are at the heart of the dispute. Candido County Sheriff's Office discovered cocaine during the search of the residence, and Rekieta was charged by complaint with possession of controlled substance. The Minnesota Digital Exhibit System is a newer process to streamline exhibit management, providing a secure and standardized means for submitting, accessing, and managing exhibits. MNDES requires party to upload and exchange proposed exhibits before a hearing. MNDSS has improved efficiency and remote access, but has introduced challenges. On August the 18th of 2024, Rekieta's attorney filed an omnibus motion.
Even the county attorney can't spell my name right. In the case, it's captioned. Nobody can spell it right. It's I before E.
Asking court to suppress all evidence collected and derived from the unlawful search and seizure. Hold that the warrant was not supported by probable cause. That the Rekieta's arrest was unlawful, and suppress any statements made by Rekieta subsequent to arrest. Suppress any statements made by April, the whore, Imolte, subsequent to her Miranda.
There we are. 5 incel statements. Again, calling a woman he has never met or nor talked to my knowledge, a whore for no apparent reason. Amazing. Amazing. Who have you been talking to behind the scenes, Kurt? You sound like someone. Who do you sound like? Who do you sound like? I wonder. Maybe it's the man she belonged to.
Invocation and consequently dismiss counts 1, 2, and 3. With the motion, the defense attorney submitted a pre-omnibus argument. Additionally, he uploaded onto MNDES multiple times, including application for
multiple items,
search warrant, Rekieta video, PowerPoint, KCSO supplement, Rekieta picture, letter from KCHHS, recording of the Steel Toe morning show, Holla, Detective Pomplin.
Holla. Oh, very interesting. It's very interesting. Who have you been talking to, Kurt? Who have you been talking to? The person who so abused his ex-wives that both of them made statements about physical abuse. Both of them. Both of them have expressed fear of this person. Holla, right? Like, he's all good with you, right, Kurt? I'm not surprised in the slightest because Kurt fucking hates women. He hates them. He hates the idea that any woman might like me at all. He hates it. He is so in his feelings, so jealous of the concept. Why don't I get one? They're mine. They belong to me. Holly Movie Star says, do you think you take sexual frustration out in food? I hope not, for the food's sake.
Body cam footage from the search warrant execution and Detective Sergeant Brandis's body.
Wrong. Swami says, women hate you, dude. I don't know if that's directed at me or Kurt, but true in both cases. True in both cases. I didn't say that women love me. I said that any woman might like me. That's what I said. The number of women who hate me is going up by the moment, and rightly so.
Cam footage from the search warrant execution. On April 21st of 2024, the omnibus hearing was held. The court asked defense attorney what the issues were. When the issue of...
Wait a minute. What was that little Freudian issue? Who's on your mind, Kurt? Why are you thinking so much about April? This is weird.
Body cam footage from the search warrant execution. On April 21st of
April the 21st? I thought it was August 21st. Very, very strange. Who's on your mind, Kurt? And why? Why is that? What have you been doing lately?
2024, the omnibus hearing was held. The court asked defense attorney what the issues were. When the issue of Mrs. Inholte statement, otherwise known as the whore, was...
Good Lord! Wow, we have now... I don't know that his longing thought that made him think of her instead of August counts, but... he did call her a whore again, which brings us to 6 incel statements. And I have a feeling this is going to keep going up. Will the incel statements rival the membership counter at some point? Maybe. The only thing you can do to protect the membership counter is to gift some memberships or join up on your own if you are not already. We would love an all green chat. But of course, that is not required to watch this show. It's just fun.
Was reached, the district attorney interrupted and stated it appeared to be a motion in limine. Discussed that the case was set for trial. It was. It's like, yeah, it was way premature. Yeah, Nick Rekieta.
Kurt is an expert in the premature, I'm guessing. Yeah, the judge told us the issue was premature. We agreed with the prosecution on it. Everybody involved was like, you know what? This isn't right. This isn't ready. This is not it. It was so unripe and so unready. We offered the issue wine and pizza casserole.
Bringing it up when he did was way premature. It's a motion in limine. The trial court was correct to note it's a motion in limine. That's an issue way down the road. Way down the road. And it's not for now, man.
Not for now.
And this has nothing to do with anything.
Nothing to do at all. Kurt's right. That's what the court said. We raised the issue, and actually, that's what my lawyer said at the hearing. He said this issue may be premature. I don't know if that's the exact wording, but he said this issue may be premature, but we brought it under an abundance of caution to make sure it is brought at the proper stage, because when it is to be brought is not clear, as there's not much authority out there on the assertion of Sixth Amendment rights on behalf of someone else. And specifically, the rules about an omnibus require that all dispositive motions be brought at the time of omnibus, in which case, if the court were to determine that these statements were improperly gleaned, and if the court were to determine that that the ability to assert a Sixth Amendment right would be possessed by me, on behalf of someone else, would be possessed by me, and if the court determined that the gleaning of those statements led sufficiently to the prosecution or the gathering of evidence that would be used against me and critical to the matter, then it would be a dispositive motion. It would have been. So the question of whether or not it should be brought at a motion in limine or at omnibus was kind of open, which my attorney acknowledged in court. And, the judge said, I think this is more proper in limine. And we did not address the issue or offer the evidence that's critical. Geocached sent 5 gifted memberships. That brings us up to 171. We're in striking distance of 200 memberships. Actually, we just got another 5 from Grifty, which is 176 memberships so far on this stream. Thank you, guys. Also, thank you to our sponsor, Kurt's Dating Advice and Chicken Shop. Life in general says, starting to think Kurt is a communist or just a spoiled brat. First, he threw a tantrum over you not sharing money. Now he's pissed you didn't share April and the wonders why people don't play well with him. Well, I mean, anyone who looks at a woman or man and decides that they should be owned or belong to someone else is wild. Unless that person, I guess some people could be in a consensual, submissive relationship in which they consider themselves to be owned or belonged to by someone else. Like I guess that could happen. I'm not aware of that in any instance that is relevant here.
Someone said, can I not be a disrespectful pig? Well,
again, be disrespectful to me all day. Why are you mad at April? He has no reason to be mad at April. He's not involved with anyone involved. Well, he might be. He might be involved with someone in this situation, but he's not involved with anyone in this situation in the way that would allow any reasonable anger towards April. Nothing at all. Nor Lady Raggets for that matter. Right? Like there's nothing here. He has every reason to be annoyed with me, and predating me making fun of him. He still has reasons to be annoyed with me. That's fine. I've never suggested that he shouldn't be annoyed with me or mad at me. I suggested that it was frustrating when he made false statements about me and took glee in, the prospect of me going to jail and stuff like that. I didn't think that was very friendly behavior, and I had not done anything to him at that point. Since then, of course, I have mocked him over and over again, and will continue to do so. I have no reason to stop. But he has no reason to be mad at anyone else in this scenario at all, unless he's joined forces with another person with a similar potential status in the penile area.
you can put a dress on it, but a pig is still a pig. It's...
Yeah, you are. Someone said, can you not be a disgusting pig? That's really funny. As Kurt would say, self-own, which is also an interesting thing because I know someone else who makes the self-own joke. Who have you been talking to, Kurt? It's really interesting that he would do that, but this is a self-own because let's listen to the question.
Someone said, can I not be a disrespectful pig? Well,
so he's the pig, right? Like that's the implication of the question.
Well, you can put a dress on it, but a pig is still a pig.
Self-owned right there. Yeah, Kurt, we know. How many times do you put dresses on?
It's like, I mean, that's a dumb comment.
Is it?
Would you prefer I call her a vacuous free use slut? I mean, I could do that.
Vacuous free use slut. And now we're starting to get into Kurt's porn preferences. Free use is a category of pornography. Also, Kurt, how deep are you involved in the lifestyle, or do you want to be? Because that is another term that, if not associated with pornography, is associated with lifestyle behavior. Lifestyle is a coy, general term that encompasses the exploration of maybe alternative or taboo sexual fantasies or kinks. If you don't know what free use means, as either a porn category or a lifestyle exploration, it's the same thing. It's the idea that you have a standing consent agreement for some period of time, maybe even forever, whatever, with someone else, that at any time, you have consent to sexual activity at any and all times, hence the free use. Yet again, I'm not aware of any such arrangement by anybody that I know at all in my entire life. So his assertion that she is a free use slut is not really appropriate, nor accurate. That's very, very incel energy, and we are up to 7 incel statements at this point. Look at the anger towards someone he has never even met. It's crazy. Kim Boley says, wow, this man is a woman hater. Not good for his micro-peen. Thank you for that. We are now up to 11 micro-peens, and we are still going strong. The incel statements seem to be about to catch up to the micro-peens and may even at some point rival the membership counter. We will only know by the end.
Instead, if that's more of a nomenclature, although she did use cocaine, so arguably she was being paid in cocaine, or so. I mean,
arguably she was being paid in cocaine. Again, these, like, the level of fantasy involved in these people's assessments of someone that they don't know in a situation that they don't know is unreal. And let me just go ahead and tell you flat out that Kurt knows that that's not true. He knows that that's not true. Which makes him a massive pile of trash. Absolutely unreal.
Or she was paying in cocaine.
Or she was paying in cocaine. That now we're up to 9.
I don't know. It could have been.
You don't know? Those factual assertions that you made, because Kurt, as you know, factual assertions about specific activity, particularly criminal activity, in which both prostitution, which is being compensated for sex directly, not in some indirect manosphere way, but directly, and the distribution of drugs, also in exchange for sexual activity, are illegal. And you have accused 2 people, well, 1 person directly and 1 person by implication, but maybe more than 1 person by implication, of engaging in that criminal enterprise. And you've now said you don't know, which means you entertain serious doubts about what you're saying.
Rackets, your crazy stalker is in the chat. She got one of my gifted membos. Find her and ban that psycho. Timid Tiger something. She deleted the message before I could boot her.
Timid Tiger is a rather insane person, but Kurt here is engaging in defamation of potentially a public figure, also potentially a private figure who has been silent for quite some time, by asserting specific acts that have that happened that are criminal in nature, when he knows for a fact or has been given reliable information that that is not true, which is very, very disgusting of him. But it also just shows that he's a giant incel bitch.
A lot of things, but I don't think me being disrespectful is the problem here. I really don't.
You don't? Again, you're not being disrespectful to me. Be disrespectful to me. You're being disrespectful to someone who you have no connection to, except for that kind of glaringly obvious connection that you have subsequently made.
Also, she's a disrespected person, so fuck her.
A disrespected person. So since other people have disrespected someone it is now sufficient to disrespect them as well. Which, I mean, that's an ethos.
Or I would have, but Nick Rekieta took care of that for me.
I didn't disrespect her at all. I would never say those things in any capacity. That's crazy.
To be honest, so I think she's got that covered. Defense attorney, after expressing concerns.
Again, the person concerned about the status of this woman is the person who has obviously been talking to her abusive, self-admittedly abusive ex-husband, borrowing phrases and expressions from him, reveling in calling that person's ex-wife a whore and other names. Very weak energy, bro.
About needing to raise the issue early enough, then know the state had conceded the issue. The conversation switched to discussion of the items placed in the MNDES. The court asked the defense attorney to detail what exhibits are. Maybe just use her name. No, I prefer whore or slut. No, I don't think. Sluts and whores don't get names.
There we go. That's 3 more statements. He prefers whore or slut. Sluts and whores don't get names. Amazing. Why do you prefer those? Again, what interest is there for you in any of this? This is phenomenal. I haven't seen this, by the way. I heard some nasty things were said. That's about the extent of it.
Yeah.
Oh, by the way, I haven't seen this, but I was reading the chat. Let me be extremely specific. I was looking at this on mute because I wasn't in a place where I could listen to it. I was reading his chat, and many members of his chat fully endorsed this, completely on board with it. So it's good because Kurt will always have an audience.
Yeah. No. Yeah. Yeah. They don't get names. Yeah, no, that's okay. Defense attorney responded, I'll get rid of the 2 easiest ones to get rid of. There are 2 body cam videos because the prosecutor is conceding that's not necessary and those relate solely to the 3rd issue I raised. Those are not particularly relevant. Oh yeah, no, Nick Rekieta's wife was also doing all that stuff too. So if you want to say that about Nick Rekieta's wife, that's true too.
Oh, is it? My wife was also doing that stuff too, and you said that's true. So again, making a factual statement about someone who has wanted to be private. One moment. Hold on just a second, guys. Sorry about that. The question of car keys that needed to be located came up. So there we go. There we go. This is a woman he has met multiple times and who is nothing but exceedingly kind to him. Nothing but exceedingly kind. Who, by the way, did not engage in said activities, Kurt.
Just talking about April right now, but yeah, I mean they all were breaking vows.
What vow?
And yeah. So yeah, all those things. Yeah. Yep.
Very interesting take from someone who is unaware of any vows or the breaking thereof.
On September 24th, 2024, Judge Wenzel issued an omnibus order. On the first 2 pages of the omnibus order, the court specifically exhibited the exhibits. And I suppose also Nick Rekieta is also a slut, and also
yes,
Steel Toe is also a slut. They're all sluts and whores.
Maybe, I don't know. They're all sluts and whores. I'll take on slut gladly, happily to do so.
Yeah. So, but I need to.
Again, disrespect me all day. I don't care. I'm sorry, Kurt. Did I have too much sex for you? I apologize. I apologize that I exceeded the Kurt sex threshold. I need to get specifics from you, Kurt, on what the Kurt sex threshold is, where where observational consent has been exceeded, where two people go, I consent, and a third person goes, well, I don't. Nobody asked you.
I need a way to distinguish them if I'm going to not refer to any of them by name. Because if I call them all sluts and whores, it's going to get confusing.
It's also wildly defamatory and very inappropriate in general. Again, of a woman you've never met, who's never said anything about you at all. A woman you have met who's only been kind to you. Me, I don't care if you call me a slut or a whore. Like, go for it. Plenty of people can make that determination based on things I've said publicly. Go ahead. It doesn't bother me.
Using who I'm talking about. I'll figure it out. The court stated at the hearing the defendant offered and the court received without objection Exhibit 1, application for a search warrant, Exhibit 2, Exhibit 3, supplemental report, Exhibit 4, Exhibit 5, letter from KCHHS. Defendant offered and state objected to Exhibit 6, recording the steel toe show. The court took admissibility of Exhibit 6 under advisement. After review, the court determined Exhibit 6 is admissible as an offer of proof. The body cam videos are clearly not listed as, well, we could call one DS9 whore. We got DS9 whore, blonde whore, steel whore.
So we're now up to 15 incel statements. He's getting wildly personal here again. The only person involved in this situation who tangentially affected Kurt is me. Whose actions, and not these actions, by the way. The actions of getting arrested and, having this public scandal tangentially affected Kurt, because Kurt is someone who has, been associated with me and stuff like that. And so I guess by the barest tangential association, I will be very clear. Kurt never engaged in any degeneracy with me. In fact, when I was engaged in various degeneracies and Kurt called or texted me, I ignored it entirely or told him, not now. I'm not going to talk to you right now. That happened plenty of times because, when I was engaged in various degeneracies, I didn't want to be anywhere around Kurt, the most depressing monster on earth. Holy shit. Bring Eeyore to the strip club, will you? No. Dear God. Whew. That being said, nobody's activities in any of this, other than my tangential effect on Kurt, affected him in the slightest. So this is crowing about something that is not relevant to him.
Grown-ass women do grown-ass things without permission from anything pretending to be a man. Grow some balls, Kurt, and stop expecting adults to toe your line of stupid expectations.
Nailed it. Nailed it. This guy right here is going to tell you how women should behave. Can you imagine? Holy shit. I can feel vaginas getting female circumcised sua sponte across the nation right now. There's a psychic wave of vaginal crying out at this moment. I'm going to tell you how to live. You belong to some alleged man.
And coke whore? Is that unambiguous enough?
I think I'm the coke whore.
We could try that.
I think I'm the coke whore.
Well, we'll give that a try. See how that goes.
I'll take it again. I'll take all the whoring accusations you can levy.
The issue of blonde whore statement was not addressed in the order. On January 24, 2025, coke whore entered guilty to a felony drug possession charge and was sentenced on April 18th.
To be clear, the membership counter I'm going to update, or the incel statement counter I'm going to update as we go, as I can. Any statements he makes about me, I, of course, am not including, well, so far, I'm not including in the incel count. He can call me a slut and a whore all he wants. I don't care.
2025. On April 22nd, 2025, the appellant requested from court access to the court camera video submitted a Minnesota Judicial Branch copy request form. On May the 1st of 2025, the court granted an appellant's request, observing that they were marked as admitted but restricted interviewing only at the courthouse by appointment. On May the 29th of 2025, the state filed a motion to correct court records in the criminal file to indicate that 2 body camera videos were never offered nor received as exhibits in the omnibus hearing. On May the 30th of 2025, after receiving the transcript, the court granted the state's request to correct court records. Yeah. On May the 30th and June the 1st, after the court's order, the appellant filed the notice to motion to intervene for the purpose of asserting the right. The appellant sought to intervene to consider briefing. The appellant filed this up with supplemental authority. Concubine whore. Yeah, wife.
Concubine whore. So that's a new one. New incel statement. Again, neither being technically accurate, I don't think. Although, let's see.
Wife whore and concubine whore.
There's 2 more. I can barely
Maybe
keep up.
Maybe that's the way to go.
Yeah, that's the way to go, Kurt.
The case involves an attempt by the appellant to obtain data in the form of 2 body camera footage not offered.
By the way, to anybody asking me to stop going after Kurt, no, I won't. Not a chance.
Into evidence into any court hearing. The law is clear. Appellants no rights to state it wants to take advantage of an error by the court administration in labeling the data submitted through the new process. The court should deny. A district court's decision to restrict access to court documents is reviewed for abuse of discretion. District court findings of fact are reviewed for clear error. In applying the clear error standard, appellate courts view the light and evidence most favorable to findings. Appellate courts will not conclude that fact finder clearly erred unless on the entire evidence they are left with a definite firm conviction the mistake has been committed. When record reasonably supports the findings at issue in appeal, it's immaterial the record must also provide a reasonable basis for inferences and finding the contrary. Uploads in MNDES but not offered or received are not case records. Whether the body cam videos are publicly available depends on the data is received as evidence. To understand the question, one must understand the MNDES process and a review of what occurred at the hearing. The Minnesota court system has switched to a process where potential exhibits are entered electronically. In this case, Rekieta's attorney filed an omnibus motion making various challenges to state evidence. One such issue...
I'm surprised that by now Kurt has not filed a complaint with his local county for not providing him a woman that he is entitled to belong to him.
So Micropeen is upset you didn't give him the Macropeen?
Apparently. We're up to 12 micropeens now. 12 micropeens, which are trailing behind incel statements by a massive 7. 7 behind. I don't know if you guys can catch it up or not. Like this is really frustrating.
Relayed was evidence of co-defendant statements, which were recorded on 2 body cam footage of 2 deputies involved in execution of the search warrant. However, when the omnibus hearing was held, Rekieta's attorney indicated this was no longer an issue, as the prosecutor conceded, which she did because she would have, right? I mean, it's an issue of confrontation clause. Unless they put April on the stand.
I mean, it is a Sixth Amendment issue. It's just on behalf of a third party. But exercising rights on behalf of a third party, which led to the illegal obtaining of evidence, might actually be relevant. It's hard to say. It's not a common issue.
They can't use the statements against them because it's... because it's a confrontation clause issue.
I mean, it's a confrontation clause issue if they refuse to call April to the stand. I have a feeling if we would have gone to trial, April would have been called to the stand by the county attorney. Like I just have a feeling they would have run into Fifth Amendment issues with her probably, unless they resolved the case or made an agreement that she would be immune to prosecution, which they had filed against her, if she made statements against me, something that is rather commonly done. They could have tried that. I'm not aware of any attempt, but one may have been made, but we never really got to that stage. So it's not really a confrontation clause issue quite yet. It could have been, but that one's definitely reserved for trial.
When the court asked which items upload to MNDS were being offered to evidence, Rekieta's attorney statement is getting rid of the 2 body camera videos as they is no longer relevant. There remained any doubt or confusion about what exhibits were offered and received. The district court clearly offered and received it in its order. Statement does not include the 2 body camera videos, demonstrating the body cam videos were not exhibits. Further review of the omnibus order demonstrates the issue of co-defendant's statement. The issue originally identified by Rekieta's attorney as being the issue the body cameras would be relevant on was not an issue the court resolved or addressed. It did, because it's like, this is premature. The court was correct. There was no reason to address it at that time. The court's like, this sounds suspiciously like a motion in limine. This is way down the pipe. It's way...
Pike. Pike. Weak Speech W. Welcome to paralegal status. Thank you for joining. That's 177 members now. And Kurt must be thinking about pipe, otherwise known as members. As he's saying it's way down the pipe.
Way early for this. Yeah. The body cam videos were not evidence offered and received. The district court found as much. The issue thus turns to the nature of the MNDS upload. The applicant claims plainly a judicial record. The claim relies primarily on opinions outside Minnesota, and not from this circuit at that. But the Minnesota Supreme Court has ordered otherwise. Well, that's pretty fucking good authority.
Yep.
You know, who has a pretty good authority about what is or is not a Minnesota court record? You know who would be a really fucking good authority as to what is or is not a Minnesota court record? The Minnesota Supreme Court would be a really fucking good authority. So if the Minnesota Supreme Court says it's not a court record, guess what? It's not a court record. That's how that works. That's how that works. By an order of August 30th, 2024, entitled Order Regarding Use of Minnesota Digital Exhibit System in Minnesota District and Appellate Court, signed by the Chief Justice, the Supreme Court stated, exhibits in MNDS offered in court proceedings are case records as defined by Rule 3. Exhibits uploaded and stored in MNDS but not offered to the court are not case records and are not publicly accessible. Well, that sort of clears that the fuck right up.
Yep.
I mean, that issue.
And the Minnesota Court of Appeals doesn't have the authority to overturn the Supreme Court on this. They should have styled their appeal as one that suggests that this needs to be changed, that acknowledging this is the law, but that it needs to be changed for public policy reasons or other statutory reasons or constitutional reasons would have been the way to go, but they didn't do that.
It's like over. I mean, the Minnesota Supreme Court says that if they're not offered and they're not publicly available. So that really solves that issue right the fuck up. It's like we can.
Bendo Jail says, I really hope Nick didn't recommend Kurt those glasses. Kurt has followed none of the stylistic advice that I gave him. He should have. He would be happier now.
Probably stop reading at this point because everything else is futile. As the 2 body camera videos were not offered and received, the Supreme Court clearly identifies as not publicly accessible. That's pretty good authority. The district court likewise concludes the uploads not offered in evidence are not publicly accessible. This conclusion was based Minnesota Supreme Court and U.S. Supreme Court case law. District Court said the Minnesota Supreme Court has held private documents generated during discovery and not filed with the court are not subject to public access. This principle supports the notion that exhibits not admitted in evidence do not become part of the public record. Restraints placed on discovered but not yet admitted evidence are not a restriction on traditional sorts of information. For an exhibit to become part of the judicial record and therefore accessible, it must be admitted or used in the proceeding. Well, that sounds fucking right to me, right? Unless it's actually used in the proceeding, it doesn't count. That sounds correct.
It is correct.
The applicant seeks to circumvent this determination by relying on errors made by the court administrator incorrectly identifying the data as admitted and allowing others to access based on the...
There we go. There's the answer. It was done by court admin. I wasn't sure if it's court admin or the court clerk, but it's court admin. By the way, I have lingering suspicions about the source of various leaked documents. And I'm not entirely sure that the mislabeling only of the body cam footage in this case was an accident. Lingering suspicion. Who knows? Maybe it'll come up somewhere.
Error, or the district court in saying it was public.
Winston Smith says, I get your rage. I had someone I thought was a friend make fun of me for a life-threatening medical condition. Anytime I can insult him, I do. I don't really care if Kurt makes fun of me. That's not been the issue, although I understand that. I care a lot more about the other things he does to the people around me.
book based on the same error. But these circumstances are not situations. Yeah, the court made a mistake. Even
Stop
if the
rubbing
court
your
said all
nose,
those
make
things,
me
the
do
court
it.
made a mistake. It's
You're
not bound
making
by
me
those
miss
mistakes
stuff.
forever, right? If the district court made a mistake, it made a mistake. So it corrected the mistake, which you want courts to do. You want courts to make the mistake. You want them to correct mistakes. If I ever become a judge, you better bet your ass I'm going to make mistakes. I'm a human being. All I can hope for myself.
Neurodivergent asked, he says, he wasn't calling your wife a co-core, was he? That would be below the belt even for Kurt. No, co-core was applied to me. That was what he said. Although he did say that she engaged in those activities, referencing to the exchange of cocaine for sex, which is absolutely not true and insane. So if you want to do that, if you want to say that he did, like, you can. He didn't expressly say those words. The term coke whore was me that he was talking to.
Is that I'm wise enough to fix my mistakes. You know what's going to happen. I'm going to blow some calls, potentially important calls. I'm a human being. I'm going to make.
Who else are you going to blow?
Make mistakes too. I know I will. I'll do my best. Hopefully I'll fix them. The district court did not abuse
Gonna be tough to fix this one, Kurt.
Discretion in its decision to restrict access to the uploads not offered or received evidence and process on this decision. The appellant asserts a right to intervene with citation to Rule 24. But as the district court noted in the order of the motion to intervene, April remarried? Well, I don't care whether or not she remarried or not. Also, if I were her new husband, what's the saying? You can't shake the whore tree and expect a wife to fall out?
Whoa. 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 Whew, we just have the incel statements. I wish the incel statement count could accurately capture the incel rage that's going on. Like, I'm not a huge fan of that term, but it is here. I mean, it is legitimately at this point, I think it is safe to sufficiently call this whatever incel rage is. This is it. I mean, this is someone who is so clearly angry at women for making decisions that do not affect him in the slightest. In the slightest. Women who would never give him the time of day either, but never be rude about it. They would never be rude or mean to him in any way. At least one woman who has asked me, maybe, maybe even in light of everything, maybe, are you sure you want to do this? I wonder if she'll have the same opinion now. That's something I guess I'll have to explore. Chad Parsons says, to be fair, you did call the judge in the Montegraph suit a fucking moron and then act surprised when you don't have local friends. That judge was removed from the bench for being a fucking moron who didn't know the law and acted in a retaliatory manner against several colleagues, lawyers, and defendants. Openly prejudicial towards defendants based on various statuses that they possessed. That judge was a fucking moron. I don't know, though. Maybe I was wrong. Maybe I shouldn't have done that. Also, you're surprised you don't have local friends. One, I'm not really surprised I don't have very many local friends because I don't go out and socialize locally and haven't in several years. I mean, like I may go to events or whatever, but I'm not running around trying to make friends. My friend-making capacities were aimed in different directions over the past couple years. So that doesn't really surprise me. But do you make friends based on how you think about local judges? Like, to me, that's way more interesting. Like, if you're like, man, if I called a local judge a fucking moron, I mean, I wouldn't have any friends either. bro, there's other reasons. Let me just suggest you may need to explore the other issues that are present, because I don't think that one's actually driving people away. But thank you for your super chat. I appreciate it.
Good luck to you, sir. Whoever you are out there, Godspeed. Did Kurt drop 10 pounds? Hopefully. Kurt has been exercising a lot. Kurt, why am I talking about myself in the third person now? I've been going.
Why? I'm glad you noticed. There are several reasons why you might do that, Kurt. We don't need to get into them here.
Going to the gym a lot. I've been going to the gym quite a lot. I've taken up powerlifting.
Like a lot. I've taken up powerlifting.
It's going really well for me, by the way. I'm hoping to hit 3 plates for my big 3 lifts on my birthday, January 13th. I'm basically there on squat and deadlift, and I've got about
Are you basically
20
there,
pounds or so to go.
or are you
on
mathematically
bench.
there?
But it's going really well. I was at the gym today. Today we were doing some belt squat. And we did some dumbbell RDL, and we did some.
Who's we? We did some. Kurt's posted plenty of videos of him going to the gym. I'm not aware of another person. He uses an AI gym coach on his phone to help him plan workouts, which is just fine, of course. But who's the we?
Some landmine twists, and we did a 1-leg leg press in lieu of lunges. It was great. I am not Aquarius. I'm Capricorn. Don't disrespect. While a Minnesota authority directly addresses a right to intervene in a criminal case, the district court exercises discretion and allowed limited intervention because the highly potentially criminal. I'm glad to have you here. Because I don't mind the diversion. We can talk about the gym. It's great. I did it like a 90% lockout on a 335 deadlift.
Yeah.
Yes.
Jargon. I go to the gym and lift weights too. I just pick up stuff and lift it. And I go, oh, I can lift this because I'm cool, or I can't lift this because I'm a total bitch. That's it. And he's like, yeah, jargon. Lawyers love jargon. It's funny to me.
We is me and my micropene.
Oh, no. That's a micropene counter of 13, again, brought to you by Kurt's Dating Advice and Chicken Shop. Buy your chicken and refer to women who have nothing to do with you as sluts and whores. That is direct advice from the Kurt's Dating Advice and Chicken Shop. Get all of your dating advice and chicken from Kurt's Dating Advice and Chicken Shop, a proud sponsor of the counters on this show and in your kitchen.
Yesterday? Or was it the day before? It might have been yesterday. I'm not 100% sure at this point.
You don't remember when you lifted something?
It was yesterday or the day before. I did, which was more than I intended to lift.
That's a lot of physical activity. I lift anything so rarely that I never, I can always remember exactly when it was because it never happens.
I miscalculated the amount of weight.
Calculated.
So I put too much weight on it. But I did
Oh, so you were a little bitch. Too much weight. Who's ever heard of that? Whenever I lift too much weight, whenever I fail, I call myself a little bitch every time. Which is all the time.
I did like a 90%.
Sorry, he muted that in an attempt to stop us from hearing, but I have magnetic ears to weirdness. Listen to this.
Much weight on it. But I did a
sneeze. Unmute.
I did like a 90% lockout on a 335 deadlift, which was exciting. This is all great news. It's all fantastic. Everything's coming up on civil, man. Let's see. While no Minnesota authority directly addresses right to intervene in a criminal case, the district court exercised discretion and allowed limited intervention because the purpose was determine access and review of outside jurisdiction, shown in a number of jurisdictions allowed intervention in criminal cases for a limited purpose of access records. Would you like to see my lift attempt where I came 90%?
What? Who describes it? Would you like to see my lift attempt? Yes, where I came 90%. No. You changed my mind in just a couple words. Faster Flash says someone should tell Kurt he doesn't need the gym. Adjust diet and go outside for a walk. I lost 66 pounds since September last year. Also, micropene. Thank you for that. Updating the micropene counter to 14. And this is what large people who want to lose weight often get caught up with. You're not gonna trim down and lose the weight if you're converting fat to muscle. You already have a ton. You are monstrously huge. Your body has to, like, just laying on your back and breathing means your abdominal sheath is really strong. It's just pushed out by all of the adipose tissue. You are strong underneath that fat body. You really need to cut the weight. That's more important than trying to add a bunch of strength. I mean, you're strong. Fat guys, whenever they stand up, they squat hundreds of pounds. They squat more than the average person can squat on their own just by getting off of a couch. It's like, you ever see fat guys do like a seated leg press where they're not lifting their own body weight? They can lift massive amounts, like 700 pounds, no problem. Why? Their body does it all the time. All the time. Let's watch this lift where Kurt came 90%.
Let's see if I can pull it up.
Wrong phrasing.
That's records. Would you like to see my lift attempt where I came 90%? Would you let's see if I can pull it up.
Holy shit. Andy Montemayor says, Nick, is Kurt taller than you? No, he is not. He's not short. He's a very big man in general, like all around, but he's not taller than me, no. Watch him come 90%.
So you can hear this, I guess, for whatever value the audio has in this thing.
Miss Jessica NB, I am 6'2" and a half. I only mention the half because everybody who is 0 inches, which encompasses anyone 5'11" and under, gets really mad at every minuscule amount over 6 feet that you are. So 6'2" and 1/2.
So you see, it's a 45 plate, and then it's 4 25s on each side, in case you're wondering what that is. So that's 335. So that's what that is. Because the 25-pound plates are smaller than the 45-pound plates, and therefore much easier to put on and take off. So it has too much weight because I was lazy. That's what's happening right here in this shot. Okay, pressing on.
Do you think Kurt could defeat you in a fight based on his enormousness alone? It really depends on the circumstances of the fight. If the fight goes to ground, it would be like, it would depend on if I were able to get into a mount position, which both of us would like, I'm sure. But if Kurt were able to get on top of me in a mount position or really even in guard, it wouldn't matter. It would be really, really tough. I have sparred with guys who are, well in excess of 200 pounds. I've not taken on any 300-pound plus monster, but it gets really, really difficult to get out from under someone who does that. When I was younger, I could. Now, after shoulder injuries from fat cheerleaders, I don't know if I can. I haven't tried in a really long time, and my jiu-jitsu is probably really, really rusty. But you don't ever want to get under someone who's that much bigger than you. I mean, Kurt weighs twice as much as I do. That is hard to get out from under, no matter the skill of anyone involved. So it all depends on how the avalanche lands. And if you've ever had a fat stomach pressed on your mouth, like when if they gain a top position, it is one of the most terrifying things ever because you don't know if you'll be able to breathe. Every time you inhale, it's sweat and hair and flab, and it's fucking terrible. And trying to push them off of you is hard because they're so squishy that you push in and like your hands just get absorbed and subsumed into their enormous girth. Look at how proud he is of himself. I love this part of Kurt. This is the part of Kurt that I genuinely like. I love that he's proud of himself. I love that he's working on himself and improving. Like, I may mock him for using jargon and weird things. Like, I balance my macros. Like, okay, yeah, me too. I may mock that stuff because it's funny sounding. But, like, I love how proud he is of this hobby that he's got and that he's improving himself. I've always wanted him to do that. That doesn't change just because he's a horrific monster and a giant asshole. Like, but hey, you know, I like this aspect. And he came 90%.
It's close, ma'am. That was close. So close. Damn.
Look at this. I legitimately don't understand other body shapes in this way. Like, I don't understand how it gets there. I know that some of you may have a similar body type. I'm not trying to be insulting. I just, the anatomy never makes sense to me. I marvel at it. I'm like, how does this even work? I don't get it.
And taste it. Taste it. Shit. Next time.
Go get it. Look at his smile. See, this is the part of Kurt that's great. The incel energy and calling women you don't know whores and stuff like that, not so much. Calling women you do know who've only been nice to you whores and implying that they engaged in illegal sexual activity is really gross. But this part of you is actually likable. I wish he would focus more on this type of stuff, but he can't. Because no matter how proud he is of this, he is still self-hating and wildly depressed, and he's mad that God in the universe didn't hand a woman to be controlled and domineered by him.
All right, where was I? Let's see. The appellant also claimed, thank you, Tall Skinny Geek, that's appreciated. The appellant also claims they should have been allowed to submit briefing and present evidence, but the appellant did not submit legal argument authority with his motion. The court found the issue to have been fully briefed. No rule requires a set procedure for the courts to use in such situation where the data sought is not actually a case record publicly available. Judicial power encompasses inherent authority to control the performance of judicial functions, which includes control of court records. We could also view my recent squat at 3:15 that I actually did succeed on.
Now he's locked in. He can't let it go. So now you're subject to Kurt's pride in his own achievements, which again, I think is the most likable part of him. I think it's funny. I think he should do more of that. I think that's great.
I already posted this one though. So some of you guys may have seen it, but we could post. Let's see if I can find my squat that I actually did recently. Is this 3 barbell? Is this 3 dumbbell squat? I think this is the right one. Yeah, we're gonna 3 plate this squat. Oh yeah, let's go, baby. Let's three.
Every part of him is a Fibonacci sequence. It's all perfection, all golden ratioed.
Let's 3-wheel this bitch. Let's go.
Oh no! Even his shirt is retreating from his pants. Whew.
Come on.
Yeah, and the camera has a greasy haze. It is not just omnipresent in his kitchen. It is a greasy haze at all times. Can you imagine the smudges on everything he owns? On everything. Everything you touch would have so much DNA on it.
Yeah!
Yeah! Yeah! Get it!
Yeah! Yeah, kick ass.
For the record, I cannot even come close to squatting that much weight. I cannot do it. I can only squat my own body weight, which is not your full body weight because your legs have weight to it, plus the body weight of one other significantly smaller person. I cannot squat, 335 pounds plus your own upper body. Like, that's huge. Massive, massive squat. I applaud him.
Yeah. No rule requires a set procedure for the court to use in situations where data sought is not actually a case recorded.
Anyway, did he just do 2 pumps and quit? Many, many such cases. Hey, what's up, Aussie? How you doing? You're not a moderator on my channel. That's about to change. Please don't do anything. Just it's just so I can see you when you're here. Glad to have you, man.
Publicly accessible. Judicial power encompasses inherent authority to control the performance of judicial functions, which includes the control.
Yeah, the video is still playing in the background. His chat would inform him of this in a minute. But yeah, that's why you can still hear it.
Of court records and agents of the court. Here, the district court allowed the intervention to decide the data access issue. It heard and considered the appellant's arguments and authority. It decided no additional process needed as the data is not publicly accessible. You can still hear.
He should be able to hear that. Like, he should be able to hear that, I would think. I don't know what his setup is like that he can't.
Audio. Yeah, sorry about that. No worries, I'll get that. Sorry. My bad. Thanks for letting me know. Yeah, thanks for letting me know.
Less than 20 minutes left. I can do this, y'all. I can do this.
Decision making was well reasoned. It balanced the importance.
Too lazy to think of a clever name says, I thought you said you didn't watch this. Correct. I said that, and then I corrected my slight misspeaking. I did not watch this with audio. I was reading the chat and watching on mute. I was skimming through it. I was not in a place where I could watch it with audio at the time. So I mentioned that earlier. But yes, I did say at the beginning I didn't watch that. That was mildly incorrect. I meant I haven't seen and heard everything in the video because I, again, was skimming through and I was reading the chat, which I could read the chat without having the volume. That's what was happening when this was initially presented to me. And yeah, so, but I did correct that a little bit earlier. Thanks for catching it.
Of determining whether data is available with criminal rules that do not specifically allow for any type of review. The appellant said he was looking for access to the body cam footage. Whether access exists based on the issues noted or whether the district court received the body cam footage and the evidence and nature of the state, the district court, in fact, made this review. The appellant's alternative relief should be denied. Yeah, that all makes sense.
100%.
This motherfucker looks like a more retarded version of Charles McGill.
Thank you, Ronnie.
Woo. Yeah, the grunting added to the atmosphere. Yeah, shows context is everything. Yeah, so yeah, so that was the 315 deadlift, a 315 squat, and then we did that 335 deadlift I showed you, and our last PR on bench was like 270 or 275 times 3 or something like that. It works out to like 300, 305. So the bench is still a little short, but I will
I don't think that's the only thing. But that being said, I love this how he mathematically lifts, which I know a lot of people do this, but I was always like, if I ever came to anybody saying, "Hey, I mathematically can bench X amount of weight," they would be like, "Oh, okay, sure." By the way, my mathematical bench is very low, single digits.
3-plate this bitch by my birthday. If I will 3-plate this bitch.
I will do it.
And then I'm gonna 4-plate this bitch.
You can 4-plate this bitch all you want. I prefer to 4-play it.
That 4-plate bench. I must have it. I must have my 405 bench. So we will get there.
You'll get there.
I only have to pick up another 110 pounds.
He's trying to do a 405 bench, which incidentally, I believe is Camelot's max. Maybe Camelot did a 410 bench. Of course, Camelot actually did it, to my understanding, but maybe that's it. But I thought it was either 405 or 410.
You know, how hard is that?
Pretty hard.
Yeah.
Look at that weird smile. Like, look at that. Again, this is the part of Kurt that's enjoyable. I wish he would do more of this. His like self, his being proud of himself. I'm not calling it pride. Like there's a difference between having pride, although he may have some of that. I'm not accusing him of it. And being proud of your achievements. And I think he is rightfully proud of his achievements. And it's so adorable. I wish he would just do that instead of, everything else on the planet. Enjoyable is a strong word. I said most enjoyable. It's a relative statement. Adriana B. Custom Furniture says, oh no, just got to the Kurt came 90% comment. Yeah, you're a Johnny come lately. We all came 90% with Kurt a long time ago.
All right, and so that's the end of that thing. And then we will read Nick Rekieta's brief.
Hell yeah.
For all of its glory.
All of its glory. And again, I don't know how many times this needs to be said. I hired counsel to represent me in all of this. I haven't drafted any briefs at all. It's all referred to as my thing. It comes from me, yes, and it's typical. But people have also put on me like the either the good or bad qualities of the brief, neither of which am I responsible for. I have hired a lawyer to do this. I have ideas about things, the way things might go or could go. I send suggestions to, my lawyer about those things with frequency, of course. That's just regular communications like, hey, maybe we should talk about this or do this. But he's the one directing the strategy, doing the drafting and the arguments. I have to sit there, which is sometimes kind of annoying, but it's also the right thing to do. Quiet Part Pod has rated this stream. Thank you so much for doing that. Very happy to have you. Welcome to your viewers. Welcome.
I'm enjoying going to the gym. I've become a regular now. I'm fist bumping people and doing the bro nod and the whole thing, man.
His storytelling is remarkably similar to someone else's. Yeah, I'm fist bumping people, doing the bro nod. The bro nod? I bro nod at people who I've never met all the time. So it's like a reverse nod. It's like a reverse curl even.
I've annexed a cubby at the gym. And not told anybody.
He annexed a whole cubby.
So I can keep my stuff there.
Most gyms just allow you to rent out a locker or a cubby or whatever for a very small amount of money, like $5 a month or something. What do you mean you annexed one? You took it over. It's mine. It's mine. It's my garbages. What is with these face movements? Oh my God. I just felt 8 women orgasm from that. Good Lord. All of them are in prison and watching on their tablets. Make sure you refill your minutes, ladies. How much coke has he done? My goodness. I cannot, even in my prime, I can't imagine doing having that level of nasal congestion.
All right, legal issues. Is appellant Mr. Hart entitled to review records uploaded by respondent Nicholas Rekieta into MNDES and cited in a memorandum of law filed with the district court?
Voice crack there. District court.
Pursuant to the Constitution and common law right of access. These issues were raised in pleading. District court ruled that intervener was not entitled to review or access upload that's been offered evidence. The issue was preserved for appeal by order entered. Is appellant Mr. Harden as an intervener?
This will be interesting because, my lawyer is substantively correct on the issues that he briefed. And Kurt doesn't like the fact that I have a lawyer, I think. He doesn't like me or anything that's in my defense. He praised the state's attorney. I'm curious what he'll say about my lawyer's briefing on this. I assume he will be overtly negative about it, but we'll see.
Did I hear that Kurt came 90%? I'll help him get to 100%. Yum, yum, get me some more goo for me. Hell, I'll even take his nose oysters, too.
Ew.
Another win for the toe.
That's disgusting.
You're in criminal matter entitled to be heard and present evidence. This issue was raised in plain district court rule. The interview was not entitled to oral argument nor evidentiary hearing, which, by the way, he never said what evidence he would have offered that would have made any difference. Well, district court issued an order denying appellant's Harden's motion to access to body cam videos. The district court thereby vacated its order, granting limited access to two body camera videos. The district court found that when court administration marked up the uploaded footage, the status box was mistakenly checked to indicate they were exhibit admitted, but they were not. The administrative error of these two exhibits was inaccurate, required the district court to correct and prohibit access to non-public documents. This appeal failed. Yeah. I should wear Snap-on gloves to lift. That'd be good. That'd be funny.
You should wear some of one of those nose things that opens up your nasal cavity so you can breathe like a human instead of like a, like a pig.
Yeah, get myself some Snap-on gloves.
Can't put a dress on yourself. Well, I mean, you can do whatever you want.
On May the 23rd, 2024, at approximately 9:13, a search warrant was executed at a residence in Candia, Ohio County, at a residence. Notice this is Nick's brief, by the way, but he says a residence. You mean?
Liar, I haven't worn briefs in years. This is factual at a residence in Candia, Ohio County. I don't see the issue. Is he saying because he didn't say my residence, a defendant's residence? Is that necessary here? I don't think so. I don't think there's any question. There's a whole court record leading up to this about exactly which residence it was. So I don't think so.
Your residence by two deputies were.
It's not his residence, Kurt. He can't say at my residence because he's not me. He doesn't live here. I offered. I was like, you want to live here? Do you need to? Francis, do you need a place to live? He's like, no, I have one. So it was okay. But yeah, why would he write my residence? He could say at respondent's residence, I guess. But it was a residence. Other people live there too.
Wearing functional body camera equipment which record the search. The resulting video at the heart of this dispute, as respondent Nicholas Rekieta filed a motion to suppress their usage in the resulting criminal proceeding. Digital copies of these body camera videos were uploaded into the Minnesota Digital Exhibit System in support of the motion. MNDES.
How much crud has he pulled out of his nose on stream so far? Presumably it's going right into his lap. It's really, really disgusting. And I've watched so many cooking videos. I know that Kurt doesn't wash his hands ever.
This new computerized information system designed to streamline exhibit management, providing secure and standardized means for submitting, accessing, and managing exhibits. MNDES requires...
He's taking time digging in there. Whew.
Requires to upload and share proposed exhibits before hearing. MNDES has approved efficiency, but introduced challenges. On August 18th of 2024, Nicholas Rekieta filed an omnibus motion asking for a whole bunch of things. Accompanying the motion, he uploaded MNDES, the application for the search warrant, a Rekieta video PowerPoint presentation, a supplement, a picture, a letter, a recording of the Steel Comb Morning Show, and some body cam footage. At the August of 21st, 2024 omnibus hearing, the district court asked defense attorneys what the issues were. When this issue of, what are we calling her now? What was our latest version of this? The succubus's statements were reached.
The succubus? Do you know what a succubus is, Kurt? A succubus is a medieval excuse for a man cheating, because what he would say is, I was lying there in bed sleeping innocently, and a demon from the nether hells came up, and I was forced by the demon's coercion to have sex with it. Also, it was a big titty goth girl, but with bat wings, and it was hot as shit. And like, as much as whatever is true, like that, I don't think anybody involved was a big titty goth demon from hell who came in the night and then came in the night and then made me come in the night. I don't think any of that happened. But yes, that was a medieval excuse for men cheating, was to create a demonic entity and suggest that the demonic entity tricked them viciously into sex and then took their sperm. This is a really important part. Took their sperm to an unwitting sleeping woman and impregnated her with the sperm. Very clear how succubi came about. What are you talking about, woman? I didn't have sex with that peasant girl. It was the sex demon that stole my semen in my sleep while I was just happily and unwittingly dreaming about you and our love together. And then she put it in that peasant girl. This is the same. Women had the same thing, by the way. An incubi would be the male demon that would come and force himself upon the woman while she was sleeping and miraculously got him pregnant, and the baby was black every time. Like, this is This is so great. I love the folklore around incubi and succubi because it's so funny. It's so blatantly apparent what it was for. But no, there were no demons were harmed in the making of this drama, although some of them may have liked it.
The district court interrupted and stated it appeared to have been more of a motion limine discussed that the case were submitted for trial. Defense attorney
21 incel statements, by the way.
After expressing concerns about
again, I think Kurt is mad that a succubus hasn't visited him in his sleep.
not needing to raise the early issue enough, then know the state had conceded the issue. Conversation switched to discussion of the upload. The court asked defense attorney to detail what exhibits are. Defense attorney responded, I'll get rid of the two easiest ones to get rid of. Those are the two body cam videos because prosecutors can see they're not necessary and those relate solely to the third issue I raised. Those are not relevant. Discussion continued on what items were being relied on. The download items identified as defense exhibits were the Steel Tone Morning Show, the search warrant, the letter, the PowerPoint presentation, the supplement, and the screenshot. On September the 21st, the judge issued an omnibus order stating what things they considered. The body cam footage is not listed as being received into evidence. A review of the omnibus order shows the court did not consider the body cams whatsoever. The issue of the wenches statements were not addressed in the
So much anger at women, again, who are not involved with Kurt in any way. I mean, which describes pretty much all women.
order. On April the 22nd of 2025, appellant requested from the district court access to two body cam footage submitted by the Minnesota.
Wenches is also a very, very interesting phrase. Who have you been talking to, Kurt? Who have you been talking to? I know someone else who used that phrase. And I know another person who told that person, hey, maybe we need to work on how you talk to women because it's kind of killing any mood that could possibly exist amongst any person ever. Drier in the Sahara every time you talk.
Minnesota Judicial Branch copy request form. On May the 1st, 2025, the court granted appellant's request, observing that they are marked as admitted, but restricting their viewing only as courthouse by appointment. On May the 29th of 2025, the state filed a motion to crack court records and criminal file to indicate that two body cam footage were never offered nor received as exhibits by the omnibus. On May the 30th, after reviewing transcript, the court granted the motion. On May 30th and June 1st, after the court's order, applicant filed a motion seeking to intervene for the purpose of preserving the right of access. Applicant also sought to intervene to consider his briefing on whether the two body camera footage were publicly available. The appellant followed up with supplemental authority. Respondent, Nicholas Rekieta, submitted a memorandum in law stating Minnesota's position the body cam footage was not public record and the court had the right and responsibility to correct administrative records. Yep, all those things. Standard review. A district court's decision to restrict access is reviewed for abuse of discretion. District court's finding of fact are reviewed under clear error. Upload to MNDS but not offered or received an exhibit are not case records. Whether the body cam footage are publicly available depends on whether data was received. To understand the question, must understand. This is the same brief the government filed. This is Nick Rekieta's brief, right? This is like almost verbatim the same. It is the same. Well, it's his brief, but it's almost word for word. Did they just plagiarize or did they write together or what? It's like almost word for word the same. Okay, does he have anything new to say on this issue? Let's see. Getting rid of, confusion, blah, 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 blah. Judicial record applies primarily on opinions for foreign jurisdictions. They're determined otherwise. Yeah, it's like they... Did he just plagiarize the government's brief? I mean, it's almost exactly the same. Why didn't he just file a joint brief? He could have just filed a joint brief. Why did?
If it's almost exactly the same, they wouldn't file a joint brief because they're almost exactly the same. Right? Like that seems to make sense. But maybe I'm crazy. I have no idea, by the way.
They just take the time to file almost the same thing verbatim.
Almost.
Or I don't get it. Okay. Did he copy them or did he write theirs? I'm gonna go with it was this. I'm gonna go with it was the state of Minnesota that wrote it. Between the possibility
Why?
that it was Nick that wrote it.
Wait, what? I didn't write any briefs. I have representation. What are you talking about? This is something. This is something. Like I said, I have no idea. I believe the state filed first. I have no idea when anything was drafted or whatever. I don't know if they collaborated on it. I believe the state filed first because if I'm not mistaken, my attorney requested an extension of time due to, I think, having a trial or something during the briefing window, and it was granted by the court. So I'm not sure, but I believe the state filed first. As far as the nature of the drafting of the documents, I don't know. I guess if my lawyer plagiarizes the state will be really mad at him.
And the state that wrote it.
I mean, we won't get into lawyers and plagiarism and all that stuff, but I guess the state will file a copyright claim. That'd be good.
I'm gonna say it's the state that wrote it. Yeah, I'm gonna say that they are the one that did the heavy lifting on this one.
Kurt, I want you to squeal like a pig. I would like that. Have cheerleaders ever broken your shoulders, Kurt? I order you to stop and do the helicopter with your fleshy overhang.
Ew. Fleshy overhang makes me feel horrible. Yeah, Kurt, have cheerleaders ever broken your shoulder? That girl was large. She was not as big as Kurt. I mean, she was very large.
And that's what I'm going with.
Cat Slave is right. Kurt Nick couldn't file a joint brief because he can't be caught in possession of a joint. Exactly. Thank you. Legal, lawyered, litigated, defeated.
Body camera footage were never offered nor received. The Minnesota Supreme Court clearly identifies upload MNDS is not publicly available, according to this court said. Blah, blah, blah. Relying on foreign authority, blah, blah, blah. The body cam footage were never properly filed, blah, blah, blah. Yeah, Hilbert is not binding on the Minnesota District Court. No shit. Persuasive authority for the District Court of Minnesota. It never adopted the test. This court should reject such authority. Yep. District Court did not abuse.
No, that's not from the state's brief.
Discretion. Cites a foreign case, foreign law. Yep. The brief sucks. The appellant asserts a right to intervene in.
What? Wait a minute. Why does this brief suck? Besides your personal animus, Kurt, what about the brief sucks? Hey, just a second, guys. I'll be right back. Okay, sorry about that. Had a little skirmish to resolve, as we sometimes do. But hey. Here we go. My headphones back in, and then we will continue on. I'm trying to get done with this. We're trying to finish this up, of course. This has already been a monumentally longer stream than anticipated. That's what she said. And we still have a stream to do later tonight, a members-only stream. So we have 8 minutes of video left. Let's get going. Nakadashi Tomodachi says, 5 hours of Kurt seethe. Yes, Kurt is seething in this. That is correct. This man knows what the audience wants. 400K subscriber party win. As soon as I get there, I'm aiming for it. We're trying to get to 400,000 subscribers. It'll be fantastic, and we'll have a lot of fun when it happens.
Underlying criminal case. Is it too late to file an amicus in this thing that they've had oral argument? First of all, I need a Minnesota attorney to file it for me.
Yes, it's too late to file an amicus brief. To answer your question, I think you know that. Second, you would have to demonstrate what the amici's interest is. Third, the last time you were hired to file an amicus brief, it didn't go so well. So I don't know about that.
But if I write an amicus, you think it would help? It can't hurt.
Or wait, maybe it wasn't an amicus. Maybe it was a petition for cert. I can't remember if it was a petition for cert or an amicus in support of a petition for cert. One of those two, either way.
Hurts at this point. I'm not sure anything can save this appeal at this point. But I could try. Does anyone happen to know?
I would love nothing more than for Kurt to try and help the appeal. That would be that would have everything that it could possibly have in it. That would be something.
An attorney in Minnesota who would like let me file or sponsor me for pro.
Wait, so are you going to hire an attorney in Minnesota or hire an attorney to sponsor you pro hoc vice so you can file on behalf of which amicus would you be filing on behalf of? Who would be the party? Would it be a pro se amicus brief? Not sure which one it would be.
Hoc, or so I can file a brief.
Who would your client
reach out to Hardin? Well, Hardin's lawyer himself is pro hoc. He can't do it. Yeah.
Hardin's lawyer is not pro hoc. Both Hardin and his lawyer are Minnesota lawyers. They could sponsor you, both of them. They're both licensed in Minnesota, and they could sponsor you pro hoc vice. They could get you in there.
Hardin's lawyer can't do it because he himself is pro hoc. He can't sponsor me.
Incorrect.
So, Bruce Rivers? Dress right. He should also claim to submit briefing. No rule near criminal requires preset situations. Blah, blah, blah. Blah, blah, blah. Yeah. Okay, great. So.
I love it. I love it. I love it. He says it's bad. He doesn't even read the brief. Kurt is so angry. So angry. He doesn't know how to channel his anger. He's trying to hide it, right? Claiming that he'll be objective, trying to do all that stuff, but also just randomly lashing out at two women who have never in any way harmed him or even been in a position to cause him harm. One of whom specifically was kind to him, even though he smells disgusting and is horrifying to be around. And I can personally verify that, and so can several women who have been in his presence. Unanimous decision that he is insanely disgusting and creepy to be around. From every single woman I know who has been around him. All of them.
All that stuff, yeah. So, yeah, Nick Rekieta is right, and he will almost certainly win.
Correct.
Because he's correct.
But he's also right. It's almost certainly win. By the current reading of the law, there is no right of access to this body cam footage. I hate to be the one who has consistently reported that. However, just because the law says one thing does not mean that a panel of judges will not say otherwise. It is certainly possible that they will. Something I've maintained the entire time. You must always account for the human element in any judicial ruling. Judges are people. We like to pretend that they're automatons and logic machines, but ultimately they are people, and they have different unknowable concerns. We can always try and discern them from observations, but those are always unknowable concerns unless you're personally connected to them in some way and have direct access to that person, which we do not in this case, of course, have any direct access to them. So their personal interests aside, which could in theory cloud a decision, I don't think it will. I think the likely outcome is that we will prevail at the appellate court level, and if it goes to the Supreme Court level, I doubt the Minnesota Supreme Court would grant cert on the issue, and I believe we would be, even if they did, I believe we would prevail there because the Supreme Court has issued a ruling on this specific issue that is in our favor, and the opposition has cited nothing to suggest that that should be changed, nor have they even suggested that the Supreme Court should change it or that the appellate court should rule in the opposite manner. They've just really glossed over that Supreme Court ruling and attempted to not address it at all. But it is directly on point, and that is a huge problem for them. It's a huge problem. Again, this isn't anything special. This is nothing that I did or anyone else did. This is just how the law is. It's how the law has been the entire time. There's no clever lawyering going on that makes it like some big victory. It is just the application of facts to law in this case is pretty plainly in favor of my position. Now, again, I could always go the wrong way. That's how court works.
Correct. He's correct on the procedural grounds and the argument.
Chad Parsons says, and we did not go out of our way to call the judge a freaking moron. Again, not the judge in this case at all. And that judge was a fucking moron who was removed from the bench because of her specifically freaking moronic behavior. Vindicated, even though it probably has a lot to do with why the search warrant that she approved was executed and why it was signed in the first place, I'm guessing. So dumb move on my part. Criticizing a government official.
To the argument to have the footage released is the wrong argument. I don't know whether or not the right argument could have won, but this argument can't win. This argument is based off of a
shouldn't win. Any argument can win. Again, you can have all kinds of issues. If they did win, that would be something that I believe the Supreme Court would step in and correct. But hey, who's counting?
Checkbox that was checked that was a mistake, and when the court realized it was a mistake, they unchecked the box and sealed everything again because it shouldn't have been released in the first place. So this argument doesn't go anywhere.
Correct.
This argument is dumb, and it should feel dumb. So
the elusive fan says, my favorite part of that is that Kiwi Farms accused you of having some kind of pull to get her debenched. If I had the pull to get that judge debenched, I would have had the pull to utilize the judge's improper actions literally during the time frame in which she signed the warrant. Those actions were retaliatory actions against people who spoke out about or acted against her or, defied her in any way. Included lawyers, included plaintiffs and defendants, included other judges and other colleagues, included court staff as well. She retaliated against everybody. That was the accusations levied against her, and it was literally during the time that she signed that warrant. If I had the pull to get her debenched, or my family bought the entire county to get her debenched or whatever, do you not think that the charges would have been dropped because of that action? Like, do you not think that that would have happened? Why do I care if she's debenched or not? I care much more about whether or not I have a criminal issue. That's crazy. Why would you use your pull to get someone removed if it doesn't profit you in any way?
So Nick is going to win this argument easily. He's going to win it easily. I don't know if you could have won another argument. The only argument you could win would be you'd have to go in.
You'd have to make a constitutional challenge to the underlying rules. You'd have to say that the underlying rules are unconstitutional, either under the Minnesota or U.S. Constitution, which they kind of said just by claiming over and over right of public access. But the right of public access is defined. It is definition that has survived strict scrutiny, which means it has to serve a compelling government interest and has to be narrowly tailored to serve that interest and not overlap with other lawful activity. And, you know, like that, it hasn't happened here. They didn't make that argument. So, you know, it's a real thing, and they did not apply it correctly. The only thing you could do is challenge the constitutionality of the rule or statute itself, and make an argument that it violated the right of public access, which they kept saying they were doing, but not actually pulling off, you know.
Pro Hack Vice or Pro Hawk Tua?
Pro Hawk Tua.
Well, you'd have
Citizen Ham says, I thought Kurt was wrong, Nick. I've said he's been right about so many things in this video. I don't understand where you would get that. When he is wrong about certain things, he is wrong. Yes. And when he's right about them, he is right. I'm not sure where that one is. I didn't make a blanket statement that Kurt was wrong. I jokingly said that everything that Kurt agrees with me on is crap, because Kurt said everything Nick Rekieta says is crap, which is funny because he agrees with me on a lot of his analysis. So that was a joke, though.
Have to go in through a public records request is the only way to do this. You'd have to do this. You'd have to file a public records request.
Citizen Ham says Nick turns on subs only to make you have to sub to call him on his BS. Yeah, I turned on subs only years ago. Every stream going back, you know, I think maybe even before Johnny Depp. Yeah, you need to be a sub to the channel to comment. That is correct.
And then when you're inevitably denied, which you will be, you'd have to sue on the basis that your public records request is in the public interest, citing the internet reviews and cases that have been discussed and the videos that have been made and discussions that have been made. That's the only way to do this. And I don't know whether or not that would work, because the fact that the public wants to know isn't quite the same as as public interest. Right? Public interest normally means like.
Correct. I mentioned this earlier. I'm glad Kurt's addressing it. I didn't know if he would. He didn't address it back at the time that it was made, but I'm glad he's addressing it now. Let's see what he says.
You know, it's more in the vein of like an officer involved shooting, or an officer beat up a suspect, or more in the vein of like, not based on its popularity, but based on like the egregiousness of its violation of the civil order, right? It's not based on whether or not people want to know about it. It's based on whether or not they need to know about it, I suppose, is a better way of viewing it. So that's the better way of looking at public interest. So you're basically wanting to use popularity to overcome all that. And I don't know that would work.
Man, I must be super popular or whatever. No, that's not what it's for. The public interest is not what the public is interested in. It's the public interest. It is a thing. The public interest is a thing. And is this in the public interest? Not is the public interested in this? I saw someone else lay that out somewhere, maybe in the comments of Kurt's video. I don't remember. Might have been whoever said that was nailed it so succinctly, very brief. And brevity is the soul of homosexuality.
But that's your only line of argument. And incidentally, by the way, you could still do that, because this decision won't prevent that, because this decision is coming at it from a completely different viewpoint. So the only way to try to get access to the body cam footage at this point would be to request the public record, be denied, sue, lose, and then appeal and hope for the best. And that's it.
Pretty much.
Are there controlling cases on body cam access? I'm sure there are, relative to public interest. So you.
Ben Ryder says Kurt isn't gay, just an incel. Nick, I didn't say Kurt was gay. I said that whoever wrote that was gay. Brevity. No, I said brevity is the soul of homosexuality. But Kurt didn't write that. That was a different person who wrote that. So I wasn't. How dare you?
You'd have to go dig into the case law to find what authority there is when it comes to public interest, and try to find cases that are analogous to this case.
Auntie Deb thinks Kurt is gay. It's possible.
You'd want to find cases where it was deemed to be public interest that could be in some sense be of the same kind, to use that as a foothold. So yeah, I'm sure there are cases that are on point. I don't know what they are because I haven't done the research. The cases that are on point probably mostly relate to the more egregious stuff, right? They relate to the shootings and the beatings and that kind of thing, right? Those are the cases that are probably out there defining the public interest. Cases that would...
Serious abuses of power, not routine abuses of power. Routine abuses of power create evidentiary issues that are dealt with by the court all the time. I won't say every day, but pretty damn close. They're dealt with by the court all the time. They're not of public interest, right? Like the cops creating probable cause, or the cops improperly executing a search warrant, or executing a search outside of a warrant, or obtaining statements in violation of the Sixth Amendment or the Fifth Amendment. Those things happen all the time. The process for dealing with them is pretty well laid out for most of them, and the public interest is not served by focusing on the minutia of every single one of those things, because they're resolved pretty frequently by the parties that are there. The public interest in other cases, the right of public access that were cited in this, often involve terrorists and the fear that the U.S. judicial system is not exercising the constitutional rights in favor of terrorists. And if you're a terrorist and you're within the jurisdiction of the United States, you are entitled to many, if not, well, basically all of the constitutional protections. People can argue against the propriety of that and say that it should only apply to citizens. It should not apply to foreign agents, foreign nationals, or foreign terrorist groups. But, that's not the law as it is right now. The law as it is right now is that if you're under the U.S.'s jurisdiction, then you are entitled to the civilian protections of the Constitution. That was decided a long time ago. I think it was either Hamdan versus Rumsfeld or Hamdi versus United States, US v. Hamdi. One of those two cases laid out that proposition. So,
cases that
actually foreign actors picked up on foreign battlefields have more constitutional rights than U.S. citizens who are acting on foreign interests within the United States. Those guys get military tribunals. Foreign actors in foreign places or foreign combat zones are entitled to the civilian courts, which is wild to think of that disparity.
Would allow this situation to be in the public interest. There might be a case out there. It might exist, but you have to go find it and hope it exists. Or otherwise, you're going to have to try to. And if it doesn't exist,
the scratching commences.
If it doesn't exist, you're going to have to try to use whatever authority you can cobble together.
What has he got in his hand? Did anybody else see that? I mean, besides a significant amount of skin or whatever. He's got something there in his fingers. You see that? It's like a keychain or something. What is he smelling? What is this? What is that? Is that Gamer Girl panties? Like, what is that? Oh, is it his glasses? Oh, it's his glasses. Okay. You're right. It's his glasses. My bad. I didn't see it at first. Now I do. Yeah, there's the little bridge, and I can't see down here very well, probably because I'm wearing sunglasses, which makes, it's sometimes hard to discern darker colors. So thank you for clearing that up. I legit thought it was something strange.
Exist, you're going to have to try to use whatever authority you can cobble together from any other jurisdiction you can find, and try to.
Someone said, "Isn't Kurt a real lawyer?" What's really funny about this is the gulf in experience practicing law between me and Kurt is monumental. And I haven't done much at all. He just has done so much less than any lawyer I know. It's amazing. It's amazing because I don't know. Did other people know this about him? Like, I didn't know. I never looked into it. I didn't really care. I was having discussions with this person who had a different perspective than me on other things. I found that interesting. But if you want to go with the Nick, you're not a real lawyer or whatever, okay, that's fine. The amount of legal work I've done in reference to Kurt is almost, it's several orders of magnitude more. It's almost infinite. almost infinite, because up until recently, the amount of legal work he had done was 0. Now it's some smidge above that.
Bridge the gap. And I don't know whether or not you could pull that off or not. I don't know if you could pull it off. You could, but that's the only path I can.
Awig says, no, he lied about arguing cases, which I don't know of any specific instance that happened. I don't I'm no problem believing that it did or not. Like I'm not aware of them. But my impression for the longest time was that he was a practicing attorney of some sort, that he had done some legal work. And it turns out that was not true until recently, this year.
We poor baby. Kurt called a spade and a whore 22 times. Maybe don't open up your marriage. Stop being a cuck, admitting you miss April.
Okay. None of this affects you at all. So, or Kurt, but all right.
See, that's the way I would run it. And I don't know if that would work in the end or not. But that's what I got.
Well, as you said, Kurt, it probably wouldn't work. Again, there's always the human element. You never know what might trigger the Supreme Court of Minnesota to change their mind, or you could, I guess, go to the U.S. Supreme Court. But again, the premises upon which they're basing this claim and to why access is entitled would prevent the court from having the power to correct its own errors, and would allow people to get access to any and every document merely by asserting they should have access, having a court review it and say no, and then say, well, since the court utilized this request for access to review the document, it now must be part of the public record. And these are insane propositions. Maybe you think that should be changed, and that's fine. You can do that at the legislative level, but at the current level, it's just not going to happen.
Yeah, allegations of policeman conduct seem like the ones that would spawn cases. Yeah. So, you're not going to be able to get there on the U.S. Constitution. You're not going to be able to get there on federal authority. You're not going to be able to get there that way. You're going to have to get there on Minnesota law. Maybe bring other jurisdictions in for some sort of persuasive effect, but you're going to have to convince the courts that this is the right thing for Minnesota. And the legislature statute is going to.
Nagadashi Tomodachi says, if Kurt is always wrong, does that mean you'll lose? I mean, logically, that would be what that would mean. But I didn't say Kurt was always wrong.
Be a huge inhibitor.
Except to the extent that he agrees with me, because I'm always wrong, which is what he said. which is funny, because he agrees with me on quite a bit of things.
So, yeah. But that's the path I can see forward. So, but this appeal will be denied, I'm sure. All right, well, I hope you enjoyed that for whatever value it has. Yeah. Minnesota's safety is based in Minnesota. They say Minnesota's a pain, but you have to jump through hoops. It might be possible. But this situation doesn't seem like it lends itself to the typical. When you think about the typical police body cam, the kinds that just ask yourself, what are the kind of videos that you normally see from places like Midwest Safety? Like, what kind of videos do you see? Right? And the videos I'm describing are the videos you see, police interaction gone wrong, police shooting gone wrong, police beating gone wrong, police
What police beating has gone right?
Do you think that mushy queer Josh Moon is obsessed enough with seeing where your kids sleep to take this all the way to the Minnesota Supreme Court?
He has indicated that he is. He has indicated that he is obsessed enough to do so. He may have, also said something that he really shouldn't have, but we'll see if that comes up.
that kind of thing. So, right? So, yeah, it can be done, but can it be done in this fact pattern? I don't know. That's tougher. All right, guys, I'm going to sign off for now. We'll see how it goes. And they're generally in public areas. That too. Yeah, that too. So that goes a long way. I'm going to sign off for now. I hope you've enjoyed this content. Make sure to hit the like button. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye. And let's all go lift something together. Let's all go try to work on that bench press together. Let's all see if we can crush those bench goals, man.
Crush them.
Woo. Later, bye.
Sit on them. There we go. That is the end. Holy crap, that took a really, really long time, which is entirely my fault. We have streamed for 5.5 hours today. I want to thank all of you for making the show a resounding success. Wonderful attendance and participation today. Very, very much appreciated. And we are at a final membership count of 177. I was wondering if we would get to 200 members today, but it would require an additional 23 members. And I just don't think we're going to make it there today on this stream. But that is okay. Your efforts were valiant and valid and are wonderfully, wonderfully appreciated. To everybody who got gifted subscriptions today, make sure you check out the subscriber only, or member only, I should say, member only content. And you can come see everyone else's members. Tonight, we will have a member only show, Cooking with Kurt, or something like it. I'm not 100% sure. We may have some variety thrown in there as well, since we did so much Kurt content already. But there will be some other fun stuff tonight, some other legal and comedic issues that we can discuss. And then regular streams should be resuming, of course, into next week. And we're going to try and get back to this trial as soon as possible, the trial of Nevada versus Devin Michaels. My week got kind of disrupted in an unexpected way, but hey, that's how it goes. We'll soldier on in that one because I think it's going to be really, really funny. We did have 14 micropeens listed and 22 incel statements. I may have missed one or two incel statements. I was trying to keep up, but they came in a very specific part of the video and were very, very rapid fire. So if I misjudged any, I apologize. I believe it's relatively accurate. With that, I don't think there's anything else that we need to talk about for now. So to that, I bid you all good evening, and don't be what you just witnessed. Geocached sent 5 more gifted memberships. Oh my goodness. Is he trying to start it? It's 182 gifted memberships now. Or well, memberships, not just gifted. 182 memberships today. Thank you, Geocached, for coming in with that buzzer beater. I really appreciate that. If we have any more, you're going to have to do them very quickly. We are closing out. All the super tips are done. Thank you to my Rumble and Locals people for hanging out as well. Know that I love all of you equally, and we'll deal with all of you with the same firm but gentle hand. And what outro should we play? Regular outro, I guess, right? The full regular outro. Here we go, guys. Thanks a bunch. We'll talk to you soon. Keep watch for tonight's show, sometime probably after 11 p.m. Maybe as early as 11, but probably after. And we'll see you then. Have a good night. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight.
Adriana B. Custom Furniture, thank you for gifting us up. Yeah, I can still talk. You can't take away my power.
Explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig, the spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight.
Don't you dare challenge me, Aussie. Don't you dare. The destruction will be monumental.
So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. From the white shores of
Goodbye!